Good morning, I'm Tanya Iser. I'm an investigative reporter here at WFAA. We are back for day 8 of the Ken Paxton impeachment trial, and whew, what a day we had yesterday. A whole lot of head-spinning moments, and we're expecting the defense to start off with their first witness, but I've kind of learned not to assume because I don't know if that's actually really going to happen. We'll see.
We might have some motions.
Exactly. So we have Deandra Grant,
Morning.
one of the great local defense attorney, and I know she'll be a great commentator today from the legal perspective. We have Bud Kennedy back with us, a Fort Worth Star-Telegram political columnist.
Well, I'm just impressed that you handled this whole impeachment trial, Tanya. It's been a real ordeal, but it's been a lot of fun.
It's been very long.
It's been something, but this is, I've done this particular approach with for several other trials, and I absolutely love doing this. It's one of my all-time highlights is doing this sort of play-by-play, gavel-to-gavel coverage and helping people understand what's happening in a complicated case like this, and certainly we haven't seen anything like this in decades. So we want to start off by playing a couple of videos, and then we'll talk about them. So let's start. Jay is back there ready to cue up the video where Laura Olson, who was Ken Paxton's former mistress, was called to testify, and then we had all these head-spinning events that happened with her. So let's go ahead and play that video.
Mr. President, we call Laura Olson to the
Laura Olson, the bailiff will bring Laura Olson. The House Board of Managers called Laura Olson. She is present but has been deemed unavailable to testify. The statement has been made by the court. It says what it means. Both sides have agreed to that statement. Both statements have agreed to that statement.
Okay.
Yeah.
That was wild.
That was
Whatever
crazy.
happened, they didn't want the jury to know about it.
They sure didn't.
What'd y'all think about it?
I thought it was very shocking. I was actually looking forward to her, and then it was going to be delayed till 3:53 or something according to the rules, because they added her to the witness list late, and then just a small little statement slipped in, she's unavailable, and then tweets going out that she's gone out the back door of the building. It was crazy. It was a television moment for sure.
It was pretty wild, Bud.
Everything
crazy.
happened within the last hour yesterday. It was like one of these movies where like 6 climactic things happen in the last scene or something. all of a sudden she's out the back door with, very little explanation, and you have this motion, for summary judgment, and then that's withdrawn, and then you had Rusty Hardin abruptly saying, we're done. Oh, I forgot,
Well,
we're
we're
not
gonna
done.
play that video here in a minute.
Oh my gosh, it was like everything happened within a few minutes. It was just.
It was
dizzying.
lively.
It was dizzying.
Well, I called a friend on my way home, and I was describing the events of the day, and I just was like, my head was spinning the whole time. I'm going, I had a little bit of whiplash, from all the she's going to testify. No, she's not going to testify. Oh, no, okay. But let me ask you this, Deandra, from a defense attorney or a prosecutor's perspective, why, other than maybe being salacious, why should we hear from Laura Olson? Why would that have been important?
I imagine they were calling her to talk to her about how she got her job with Nate Paul and what her job was, because I think there's question about what she was doing there, at least the things that I've read. Like, what were her job duties?
Yeah, how does she suddenly...
What was the interview process
Right.
for you suddenly working for Nate Paul, and do you still work for him, and all of those kinds of things? There's a lot of good questions they could have asked her. But I'm hearing she was going to invoke the Fifth, so there may be some agreement.
That is rumored.
There's a rumor on Twitter for whatever, or X or whatever it's called these days.
It's hard to keep up these days.
And that would explain the term witness unavailable. That would explain that. So, but it was definitely unexpected.
Do you put her on the stand anyway? If you are leading the House Board of Managers prosecutors team, do you put her on anyway, even if she's going to claim the Fifth?
There's pros and cons, and really you're not supposed to call a witness that you know is going to invoke the Fifth for purposes of making them invoke the Fifth in front of a jury. And so there obviously was a
That
big
makes better
meeting.
TV.
It does make better TV, but there was a big meeting in the back, and I guess the decision was made not to do that. I thought it was interesting the way it was delivered, and I saw that one of the senators stood up to question, what's going on, because I guess they were expecting to hear from her, and obviously some of them wanted to hear from her. So it was not the ending of the day I expected yesterday. I really thought we were going to hear from her.
I did too. I mean, I pretty much all day long was, we were waiting for it.
Remember, she was walking in.
But can you
she
just
was
claim
walking
the
in.
Fifth? Can you just claim the Fifth willy-nilly? I mean, do you have to have an actual reason to claim it?
Yes.
And so,
I mean,
what does
really-
it take to claim the Fifth?
There has to be some belief that something that you're going to say could open you up to possible criminal prosecution.
It has to be legitimate belief.
Yeah, there has to be something there. And, I just thought it was interesting, her whole attitude. I'm sorry, this little earpiece is a little crazy. It looked like in the morning she was ready to go. I mean, they're playing the video right now. I mean, she was walking, this is, I think, her walking back out.
Right.
But she was walking in like she had a purpose, and she's all dressed up, and I just figured she was ready to go. She had something to say, and then to find out she's decided she's not going to testify was interesting.
Well, and it could be that something an attorney told her between the morning and 3:53 convinced her not to testify.
Absolutely. Something could have gone on yesterday that we don't know about.
Yeah.
Well, and we don't know, we know that like Missy Carey has testified before a federal grand jury. We know that the FBI has been in contact with people. And we know that from testimony. So, we don't know.
We don't know where she's
things stand.
testified.
Yeah, we don't know.
We don't know what's going on with her legally. We have no idea.
Yeah, and so there could be any number of reasons, and we don't know for a fact that it was a Fifth Amendment situation that was the issue, but there's not a lot else that makes sense.
Yeah, that would actually explain what happened. But obviously there could be another explanation that we don't know about.
Now, how important is she to these 16 articles? They obviously, it was a much awaited testimony. It was something that the senators wanted to see. But how important is she to actually sustaining or dismissing these articles of impeachment?
Probably not that important. Honestly, I would have liked to see Angela Paxton testify. I think she could have testified to lots of things. And obviously that was not going to happen. And I think there was some agreement. I don't really understand all these rules they
And that
agreed
was
to.
simply out of courtesy.
Yes, and out of courtesy. But as far as the things that were going on in the house, the kitchen, what was the plan for the the remodeling that didn't happen but was being planned, and all those kinds of things, all the things they were trying to get in an affidavit form with photographs off her phone yesterday morning, which was another strange interaction that went on in this trial. All of those things she could have testified to. I mean, they didn't need an affidavit. They could have had live testimony from her about what was going on with the house and how Nate Paul was involved in the construction project.
Of course, that would have meant you had somebody on the stand who had been present throughout the trial, which you usually don't have a witness who's been there the whole trial.
Right,
if you were going to call her as a witness, then you should not have. Yeah, illegally, you had to have her in the Senate chamber.
Yeah, it causes a whole lot of problems. But then this whole event is being called a trial, but it's not really operating the way a normal trial would in about 1,000 ways.
Right, it's a court of impeachment, and it's a. If you look at the dais, it looks like a trial, but if you turn the camera around and look the other way, it looks like a Senate. It looks like the Texas Senate. So
Yeah, it's got some of the trappings of a criminal trial, but there would be no criminal trial where you would have the jurors voting on motions. That's not going to happen.
And we should make it clear here: no crime is alleged. This is not a criminal trial, and no criminal actions being considered here. It's whether to sustain or dismiss the articles of impeachment, which do not necessarily allege any criminal activity.
Right, it's all about sustaining or not sustaining. It's not guilty, which is what's being put out in the media, but that's really not what's happening.
Yeah, that's why we've been trying to be very careful on this live stream to be
use the right terminology.
Use the right terminology.
Because it's
I've caught myself a couple times using the word convicted, and Bud has been very gracious in making sure that I stick to the right terminology, because it is important. It is important to be correct in terms of how we describe these things. And then, Bud's talked about that this doesn't have to involve crime.
And that's important to this, that nobody is accused. This is not a criminal court, not a criminal action. Nobody's accused of a crime. Attorney General Paxton obviously is out on bond on other accusations, but this is not in any way accusing him of any wrongdoing. An impeachment in Texas requires, in the words of the Texas Supreme Court, a finding of delinquencies or maladministration. And so that's what is being considered and alleged in the articles of impeachment.
Well, and it's still kind of amazing that we've had an attorney general for the last 8 years that it's been under felony indictment, and
is out on bond.
And
has been reelected twice.
Yeah. It's all
but as we know from the polls, 40 to 50% of the voters were not aware of any wrongdoing, because that's a down ballot race. Opponents weren't well funded enough to advertise about it, and the people really didn't know much about the race before those elections.
Well, I think the other thing is I noticed in the chat, because I've been following it during the entire 7 days, however many days it is, and people you see a lot of people saying, like, where's the evidence, and I think there's a misunderstanding about what evidence is in a trial.
What is evidence, Deandra? Let's explain.
Anything that comes into evidence, that's admitted into evidence, so documents, photographs, videos, of which there are a ton in this case. We haven't seen the videos that have been admitted because of the time constraints. There's video, and then anything anyone says from the witness stand. And then, so that is evidence. So all of these people coming and telling their story, that is evidence. And you as a juror, and when you're doing jury selection, you tell jurors this, you can believe some of it, all of it, none of it, but it's all evidence.
Well, that was hindered in Ryan Vassar's testimony when they talked about him going in and they asked him, did you bring any evidence? And he said, no, sir, we brought no evidence. So that quote has been seized on and circulated widely on social media. And as the prosecutors have come back and pointed out, you didn't bring any physical evidence, but you brought your own eyewitness testimony. All the witnesses have brought their own eyewitness testimony, which is the evidence in this case. There's no giant sack of money that is being shown that upholds any of the articles of impeachment.
Well, Deandra, since you're been watching this, and this is your maiden voyage on this trial, what do you think of the evidence that's been presented?
From a strategic standpoint, I think that some of the evidence could have been presented a little more clearly. when you have different attorneys doing the direct with all the and switching all the time, you have all these different styles. I think what was kind of lacking for me personally was a story. Really, as a trial attorney, you want to tell a story and be a good storyteller. And sometimes I felt like the story and the theme of the prosecution was getting lost. There were several of the attorneys that I felt like should have done more of the questioning in the case.
Like Aaron Epley.
Aaron
Mark Donnelly.
Epley and Mark Donnelly, I believe his name is. So for the chat people, that's orange bow tie guy. That's what they were calling him. They were like,
He's local.
bam. I think he's in Houston too, isn't he?
Let me look him up.
I don't know either one of them, but
Okay.
they were very effective in their direct. It was bam, bam, bam. Elicit what you're trying to get the information, go, go, go. And we kind of, in the first few days, it seems like got muddled in a lot of minutia that detracted from the story. And there also seemed to be a lot of problems figuring out what exhibits were in evidence, what exhibits weren't in evidence, what exhibits you were trying to get Stacy to pull up on the screen or Eric to pull up on the screen, who are big celebrities now, apparently Eric and Stacy.
We got GoFundMe's, I think, for Eric.
Yeah, I know. It got a lot of, it just kind of things got a little lost. But as far as if you actually read the articles of impeachment, especially the one you just quoted, I think they got there all day long.
Well,
All day long.
of course, Aaron Epley was up against the clock, and so she was brisk because she knew that they were running out of time, because Rusty Hardin talks slowly.
He does talk slowly.
He sounds like Matlock.
He comes up, he presented his case slowly, and his interrogation, particularly of the first few first assistant DAs, was this slow. Well, now, when did you get here? And you tell us all about
Tell us your life story.
Tell us what a big conservative you are.
Right.
You a rhino? Or just things like that.
Are you part of a coup?
Yeah, that's right. Just trying to encourage. And people, I think people are going to blame Rusty a lot if these articles of impeachment are dismissed. But on the other hand, as I've said, the key is not what the viewers think of the case. Tony Busby's play to the viewers, but you have to play to the 31 senators who were sitting there. Mm-hmm. And a lot of them are
Absolutely.
just like Rusty Hardin.
Yes.
And they're old, slow-talking Texans. And so the question is whether Rusty Hardin was the best prosecutor to present the case to the members of the Texas Senate.
Okay, so this is a perfect segue into playing this video that occurred late in the afternoon involving Rusty Hardin, and then we can talk about it.
Your Honor, at this time, the House of Managers rest.
He just rested without a cross-exam. I can recall the witness, though. I'm fine with that. We'll recall this man. We will accept the rest.
Yeah.
And that's how it works.
He's certainly right. I mean, I want to concede he's absolutely right. I apologize. I think he is entitled to his day in court. Thank you.
So he has given you your cross-examination, if I'm understanding, Mr. Hardin?
Certainly.
Your Honor, we have some motion practice we'd like to take up with the court today.
All right.
Now, is he waving cross or?
That I would recall this witness in our case in chief. If there is a case in chief needed from us, I'd like to do some motion practice today.
Well, here's the problem. I messed up and shouldn't have rested until he finished his cross.
And yet you did.
Excuse me. Having this witness come back doesn't make sense.
Well, Deandra, what'd you think of that?
I've never seen that before. But at the same time, if you watch the lawyers that are behind him in that video, no one was really reacting. So I think the plan all along was he was going to rest as soon as they were finished with the witness. He just forgot the cross part, but he'd always planned to rest.
He just jumped the gun a
He
tad.
just did it a little faster. He should have allowed, I guess it was Busby was going to be doing
Busby,
Yeah.
the cross, and he should have let him and then rested. And he just forgot about Busby's cross. But the planning to rest, I don't think that was an error, because no one over there on the side, if this had been my trial and this wasn't supposed to happen, I would have been, what is happening
Yeah.
right now?
Right.
And
Like, why are you
they
doing
weren't
that?
doing that.
They
So,
planned to rest.
yes.
And forgot the allow the cross.
Yes.
But it really, although the video of him saying I messed up will be remembered, I think the impact on the trial was minimal.
I think that we're making probably a bigger deal out of it than anybody in the Senate was making out of it yesterday. They were probably, thank goodness.
They're probably like, oh my God, can we end
Maybe
the
we'll get
torture?
out of here
I
today.
think if we criticize Rusty, it's not for that. It's for the all the time used earlier in
I
the
think it's a
trial
time
that put them on the
management
clock.
And I think viewers should know that that doesn't happen in criminal trials. There are time constraints in civil trials, but a criminal trial in state court takes as long as it takes. Whatever you want to cross-examine somebody for 2 days, then you get to do that.
And a lot of the purpose of this trial was to air all these charges and air all these allegations. And it has been a heavy lift from the very beginning to actually get the Senate to vote for removal. But they're at least able to air all this. And whether or not you think that all these loose threads tie together, at least they've been able to get them all in the public domain, get them all considered, repeated, and get them all reviewed, and maybe bring forth more evidence.
The time constraints were not good. They needed more time. There was a lot of articles. If this was like 5 articles, maybe, but 16 total, and a lot of them very different from each other, lots of witnesses, I don't think they gave them enough time.
Dan Patrick said he expected a 4 or 5 week trial. Where'd that go?
Yeah.
I mean, well, clearly that's not going to happen. I mean, just based on, he did not say out loud how much time was left at the end of the day, and it's hard
he
to know
didn't
because
say.
we had so much sidebars and so many breaks, and
I think it was quite a bit. Really, a
lot
lot
of
of it was
breaks
just
yesterday.
meetings yesterday.
well, because there was at the beginning of the day there was around 5 hours for the prosecution and around, I think it was 9 hours.
9 hours for the defense.
For the defense, yeah, and so. I'm ballparking that maybe there's half left for each.
I was thinking about half of that had to be left because so much yesterday was hearings behind closed doors and up at the bench.
And so, yeah. And then, do you, if you're the defense, okay, so right before they left, they called to the stand, or they were going to call to the stand, Michael Gerhardt, who's this constitutional law professor. Mm-hmm. First of all, what's the purpose of doing that, Deandra?
He has testified in several impeachment-related hearings, and he's been, I guess, consulted with almost every sitting Supreme Court justice, and this is kind of his area. And I'm guessing that he's coming in to talk about the history of impeachment and why we have it, and what it historically has meant, and maybe historically what sort of evidence has been needed to impeach someone. That's what I'm guessing he's doing, to try to show from the defense perspective they didn't get there in this case.
And I think he's going to come in from a federal background and testify about whether this is an appropriate impeachment or not.
Absolutely.
But some of what he knows will be applicable to federal impeachment, but not necessarily to Texas impeachment.
Do you put anybody else besides him on the stand, Deandra, if you're defending Ken Paxton?
I don't know who they'd call. I can't think of any people that, unless you maybe called the contractor you were working with on the house.
Well, they said the contractor would not come testify.
Okay, well then you've got a problem. But if I was thinking of people in a perfect world, maybe the contractor could come and say, here's what was really going on. When I was saying we got to check with Nate Paul, this is why. There was an honest explanation for that. So that might be a type of witness that you wanted to call. Guess you don't want to call Nate Paul.
Well, he's under federal indictment, out on bond himself.
Well, I think if you think you're going to win, then you drag in all your political enemies and start, flagging them out there.
Maybe put George P. on the book.
You put George
Johnny
P.
Sutton?
You put Johnny Sutton. You put TLR. You put all the boogeymen they brought up in this trial, and you put them all on the stand and roast them for everybody to see. You start.
All rise.
You
The Court
start
of Impeachment of the
taking
Texas
everybody
Senate
out
is now
for
in
the-
session. The Honorable
to begin
Lieutenant
the
Governor and
primary.
President of the Senate, Dan Patrick, now
All right, well,
presiding.
let's take a listen. Okay, they started on time. Awesome.
They want to get done.
All rise. The Court of Impeachment of the Texas Senate is now in session. The Honorable Lieutenant Governor and President of the Senate, Dan Patrick, now presiding.
Morning, everyone. Please bring in the jury. Well, I see the bagpipes are gone, but the crickets are still here. Senator Hughes, I believe you're doing the prayer this morning.
Well, let's go to the Lord in prayer. Heavenly Father, when we consider who you are, the one who has always existed before time, way back into eternity, who always was and always will be. When we consider that you made everything we see, things we cannot see, us, every molecule, every particle of each of us, just because of who you are, we owe you everything. We owe you our lives. And Father, when we consider on top of that all that you've done for us, the gifts that you lavish upon us, that you heap upon us, our very lives, and especially those of us in this country and this state, the special blessings we enjoy of liberty and opportunity and justice, unknown in the history of the world, uniquely given to us here from your hand. We know we each have a responsibility in preserving those things as stewards, each one of us, whatever our role. So, Father, we thank you. Thank you for who you are, for what you've done. We confess our failure to acknowledge you as we ought, to look to you, to humble ourselves before you. And we just thank you for loving us. The ultimate expression of your love for us, that Jesus Christ, God's Son, God himself, would humble himself and come to this earth and take on human form and live that beautiful life, and then pay the penalty for all of our sins on the cross, and then raised from the dead on the third day. We thank you for him. Your word says that since you gave him for us, there's nothing you'll hold back. So, Father, we ask you for wisdom that you've promised to give. We ask you to be honored in these proceedings today by everyone here, whatever their role. Thank you for loving us so much. In Jesus' name we pray. Amen.
Thank you, Senator. You may be seated. Members, can we have a little quiet in the courtroom? Can I have both parties come forward? Is the defense ready to call their first witness?
We are, Your Honor.
And who would that be?
Justin Gordon.
Bailiff will bring in Justin Gordon. Counselor, state your name for the record.
Of course, Allison Collins.
I always give you the time check. Members, House, you have 2 hours, 34 minutes, and 49 seconds remaining. A respondent, 8 hours, 38 minutes, and no seconds remaining. Were you here on day one to be sworn in? Yes, sir. I thought so. Please have a seat.
Good morning, Mr. Gordon. How are you today? Could you please turn on your microphone and go ahead and adjust it pretty close? The acoustics in here can be a little difficult.
Is that okay?
Yes, that's much better. Could you please state your name for the court?
My name is Justin Gordon.
And where are you currently employed?
I'm employed in the Open Records Division of the Texas Attorney General's Office.
And what is your position there?
I'm the Open Records Division Chief.
How long have you been the chief of the Open Records Division?
I began in 2015 at the beginning of General Paxton's term.
Excuse me, I think you're gonna have to speak louder and a little closer, okay?
I began in 2015, in January of 2015.
What does the Open Records Division do?
Our division handles a number of responsibilities regarding the Texas Public Information Act. That includes enforcement and review of public information decision requests. We also provide training for governmental bodies on the Public Information Act.
Okay, I'm going to ask you just to slow down a little bit while you're talking, okay, to help the court reporter out. Can you tell us how many public information ruling requests your division handles a year?
Last year we did over 40,000. In the previous fiscal year we did just under 40,000.
And does your division maintain a record for each ruling request?
Yes, we maintain both an internal record of our ruling requests. We also post all of our letter rulings on our website after they are issued.
Do you recall a request for ruling from the Texas State Securities Board in the fall of 2019 for some records related to Nate Paul?
Yes.
Do you recall if any records were released as a result of that ruling request?
I do not believe any records were released in response to that ruling request.
Do you recall if there was a request for reconsideration of that ruling?
Yes, there was.
How frequently does the Open Records Division receive requests for reconsideration or complaints about a ruling?
That's very common. I don't have an exact number to provide you, but that's something that we see certainly on a monthly basis, if not weekly.
Were you also involved in deciding a request for ruling from DPS, the Department of Public Safety, in the spring of 2020, which we're going to call the big request for ease of reference? Do you recall that one?
Yes, I do.
Was that also related to Nate Paul, if you recall?
It was.
At some point, as one of your duties, as part of your employment, did you make a summary of that file?
I did.
Your Honor, if I may approach the witness.
Yes, you may.
I'm going to approach with what is marked as AG.
Hold on one second. Yes, Senator Whitmire? Okay. Allison, you're going to have to speak louder as well.
Even louder, okay.
That'll do it. That'll do it.
I'm going to approach with what has been marked as AG 205, and it has been pre-admitted.
Okay. Members, do you need for us to review with the court reporter what has already been said? You're okay? Everyone's okay? You do? Okay. Okay, so let's go back to where you began the question on DPS, Senator West. Securities. Okay, let's start over.
No problem. Do you recall receiving a request for ruling from the Texas State Securities Board in fall of 2019 for some records related to Nate Paul?
Yes.
Do you recall if any records were released as a result of ORD's ruling?
No, I do not believe any records were released in that ruling.
Do you recall if there was a request for reconsideration of that ruling?
Yes, there was a request for reconsideration.
How frequently does ORD receive requests for reconsideration or complaints about a ruling?
That's very frequent. I don't have an exact number to provide to you, but it's something that we see, if not on a weekly basis, then certainly monthly, several times a month, we receive reconsiderations.
Do you also recall being involved with a request from DPS in the spring of 2020 related to Nate Paul?
Yes.
Now, we've been calling that the big request to help distinguish them. Will you understand what I'm saying if I call it the big request?
Yes.
Thank you. And at one point, as part of your employment, did you create a summary of this file?
Yes.
Your Honor, I'm now going to approach the witness with what has already been admitted as AG 205. Mr. Gordon, do you recognize this document?
I do.
Is it a fair and accurate depiction of the summary that you created for this file?
Yes, it is the summary I provided for the file.
Well, let's talk about it. Let's walk through it together, okay?
Okay.
First, how would you describe this particular request, the big request?
It started off as what I would have characterized as a relatively routine request from the Department of Public Safety. Department of Public Safety routinely briefs our office on law enforcement matters. They, again, very commonly submit rulings to our office. However, as the ruling was being reviewed, it took a turn procedurally, and then there was a number of procedural irregularities that occurred with the file that made it unique.
And Eric, if you could please pull up AG Exhibit 205 and highlight the first paragraph, please. And Mr. Gordon, I think it's consistent with what you just said that there were procedural issues that made this file unique. Is that correct?
That's correct.
Okay, and when was the request received by your office?
On March 13th.
Okay, and at this point, this is when you're talking about it was very routine?
Correct.
Do you recall what exception DPS was asserting?
They sought to withhold the information under the law enforcement exception. That's Government Code Section 552.108.
Is that, there are generally two types of exceptions under the PIA, is that right?
That's correct. There are two, we characterize them as two separate types of exceptions. There's an exception for confidentiality provisions that we would also call mandatory exceptions. And there's a type of exception that is just a normal exception to disclosure that we would call a permissive exception to disclosure.
And which type is the law enforcement exception?
Section 552.108 is a permissive exception. The governmental body has the option to raise it or not to raise it.
What happens if they do not raise it?
Nothing happens if they do not raise it. We won't address it if they do not raise it.
So if they don't raise it and you don't address it, what's the end result as it relates to the request? Are those records released or are they withheld under the law enforcement exception?
Oh, they would be released. They would not be withheld under the law enforcement exception.
So let's talk about some of the procedural irregularities in this file. I'm now in the second paragraph, Eric, if you could blow that up for the senators. Where did this file first start to take a turn towards the unique?
Where you have it highlighted, I described that.
Excuse me 1 second. I'm very sorry. I'm very understanding with 8 grandchildren and a lot of little ones, but we really can't have a distraction. I'm sorry. Might have to step out. I really apologize, but I don't want to distract the jurors. Very sorry for that.
May we continue? Thank you. I believe you were about to point out to us where the procedural issues started to rise in this file.
Sure. So we have a statutory 45-day deadline by which we have to issue all of our rulings. That's from the government code. And as we were approaching that deadline, the DPS submitted a follow-up correspondence to our office explaining that the requested information may implicate the interest of the FBI. And at that time, they also submitted additional records. So in the initial submission, they only submitted a representative sample, which they are permitted to do. In fact, the PIA requires them to do that if the records are voluminous, and they had done that in the initial submission. However, when they submitted the subsequent submission, they submitted additional documents, not the same representative sample that they had submitted earlier. And the new documents were substantially different than the documents that had been originally submitted and were of a different character. So they
and I'm going to stop you. I think that's a great spot. And just to summarize, so essentially the original representative sample that DPS sent in did not match with the sample that they later sent to your office in May of 2020. Is that right?
That's correct.
And they sent that second sample at the time that they were notifying the FBI that they might have an interest in the file, in the information being sought by the request?
That's correct.
Is that considered a procedural violation under the Public Information Act?
Yes, governmental bodies are required to submit all of the records that they want a ruling on or a proper representative sample by the 15th business day after receiving the request, which had been substantially before this time period.
So this sample was also late, is that correct?
That's right. That's correct.
What is the consequence for a procedural violation of this nature?
Under the Public Information Act, failure to comply with the procedural requirements in requesting decision from our office results in a presumption that the information is released unless the exception that they're raising constitutes a compelling exception. And our office has concluded that Section 552.108 does not constitute a compelling reason. That's a fancy way of saying that they waive that exception, and they would waive it for the information that they had the procedural violation on.
And that would be all of the information that they provided as the second sample in May of 2020?
Correct. Anything in that representative sample, the second set of documents that was not in the first set.
And is it your understanding that that second set of documents had also been provided to the FBI?
Oh, I'm not sure if they provided that second set of documents to the FBI. I don't remember that.
So this late, was the notice to the FBI also late?
Yes. Governmental bodies, there are procedural requirements and there are also due process requirements in the Public Information Act. And because of those deadlines, there are certain notice requirements. So the only notice requirement in the Act that applies to third parties is in Section 552.305. That section requires governmental bodies to notify third parties if their privacy or proprietary interests are at issue, and that notice is supposed to come within 10 days of receiving the request. Otherwise, there's also the due process element of that notice needs to be made in time for those comments to be received by our office before, in time for us to be aware of them, and also in time for the requester to receive notice.
And in this instance, was the notice given close in time to your statutory deadline to issue a ruling?
Yes, we received it just a couple of weeks before our 10-day deadline or our 45-day deadline.
The second sample of the second set of documents that you were provided by DPS, how were those provided to you? Hard copies on a CD, do you recall?
I don't recall if they were a CD or if they were a hard copy.
Okay, so you sent this, the notice went out to the FBI and you received a copy of it. What happens next?
So at that point, we were kind of up against it with respect to the timelines. You've got the highlights here with respect to the to kind of what was going on in this file. We had also been notified by the requester in this file that he had filed a lawsuit against DPS in this case, which added a whole nother layer of complexity to it. Because the late notice, because the notice was received so close up against our 45-day deadline, we didn't feel like the third party who was notified, FBI, would have had time to submit comments to our office in time, and so while we were waiting for those comments so that we could receive them and review them from the FBI, we took a 10-day extension on it, and again gave ourselves a 10-day extension, which is permitted under the PIA.
All right, I'm going to ask you just to slow down a little bit, okay? You're doing great. So you extend it for 10 more days. Does the FBI eventually provide your office with comments?
Yes.
And do you know if the FBI also provided the requester with a copy of those comments?
At the time, when we identified the documents, we actually only found the comments because the requester let us know that he had received comments, and so then we went and tracked them down. This is at the beginning of COVID, so our mail intake was kind of thrown off. So when the requester notified that we had received comments, we went and tracked those down. To add another procedural complication to it, at that time the requester notified us that his copy of the comments had been completely redacted. Our copy did not have any redactions on it. It just had a reference that at the end that the version that had been provided to the requester was redacted.
In your honor, if I may approach with what's been marked as House Managers 46 but has not been admitted into evidence yet.
You may approach the witness.
Mr. Gordon, do you recognize the document that I placed in front of you?
I do.
What is it?
This appears to be a copy of our internal ruling file pertaining to the DPS file that we've been discussing.
And does it appear to be a complete and accurate copy of the file?
I'm sorry, I'm just double checking.
Take your time.
Yes, it does.
I appreciate your thoroughness. At this time, we'd move to admit House Managers 46.
Any objection?
Mr. President, no objection to the admission. However, in this document, it contains a copy of the unredacted FBI brief, which not only contains personal identifying information, but a number of sensitive information of the types of operations plans and other sensitive law enforcement information, which Nate Paul had been trying to get for a while. If it comes in, we just ask that it be redacted because that information has not been publicly made available.
And Your Honor, we'll get to that on the next request, but I will represent to this court that that is not the case. As has been discussed by other witnesses, this brief was in fact released publicly.
Okay, so they did not object, and I'll let her go along with her line of questioning, and we'll get back to that issue, but thank you for bringing it up. Go ahead.
Thank you. Eric, if you could pull up towards the back of that Exhibit 46, the Bates number at the bottom is 8803.
Mr. President, I do have to, I'm sorry, before this is shown to the jury, there is personal identifying information
and
that
sir,
has not, may I finish?
Stop not talking over each other.
That has not been released publicly. It may have been released to Nate Paul at General Paxton's direction. However, it has not been made public to the world at large.
Okay.
There's very sensitive law enforcement operation plans, details about search warrants, how investigations are done, and also specific names of individuals that are identified and involved.
Come on up to the bench. Please come up to the bench.
Yes, sir.
Okay, so Deandra, talk about this.
Well, I think the prosecution is absolutely correct, and the defense should have offered a redacted version of this. I see Judge Myers leaning over listening because she's thinking the same thing I am. It's like, what are y'all doing, and what's in this document? Just because you've got the correct witness there to support a document coming in doesn't mean everything in it's admissible or should be admissible. So it'll be interesting to see what the ruling is here. I'm sure whatever the ruling is going to come from Judge Myers.
I mean, it'll be Patrick saying it, but you think
Yes.
that it'll be...
Yeah, because he has no clue, and she's listening pretty intently on this video. So
I think it will be Dan Patrick, whether he has a clue or not. What the defense is arguing is, once again, the ruling power of the Attorney General that he gave this to somebody, so it must be public, whether it should have been public or not.
well, and therein lies
You can
another
hear some pretty heated
issue.
conversation
Yeah,
up there
I
a little
mean,
bit. I mean, you can't exactly hear what's being said, but it sounds heated. Deandra, while we're kind of waiting on them to rule on this, or waiting for Dan Patrick to rule, you think that Dan Patrick understands hearsay?
No, some of his rulings, like I was laughing yesterday because it seemed like Busby kept saying, that's not how this works. That's not how any of this works. It's like the TV commercial where they say that. I kept laughing because that's not an objection. That's not even but he figured out that if he just yells really loudly and says that's not how this works, he was winning a lot of the objections.
Was Busby correct? Is that how this works?
No, I mean but I've
That's
been in
how winning
trials.
your case works.
That's how making objections in front of a judge who doesn't know what they're doing works. You know,
Yeah.
I've done it before.
That's
I'm
what-
guilty. I've gotten up and said, because I see if I just yell or say certain words, the judge will rule for me because they don't really know what the answer
He
is.
was trying to control Dan Patrick,
Yes,
wasn't he?
absolutely.
And how successful
absolutely.
was he?
It was very successful, and it was. But when Aaron was up, though, she had citations and hearsay exceptions, and she was citing the code and everything. And then
And there was times
It was
when he was ruling
interesting.
against her, and she was right?
she was right. Yes, and there were some times he let things in that I think should have been sustained. So he's been all over the place. But I've practiced in front of non-judge lawyers or non-lawyer judges before, and this is what you get.
This is a key ruling, isn't it? Because this is one of the key parts of the trial of whether all
Yes.
this grand jury testimony and all the data and the law enforcement identities and everything else should have been given to Nate Paul.
And if you have any experience trying to get open records and going through this whole attorney general process, I mean, they don't just release the stuff.
Love from the AG's office?
No. And I know you haven't either.
No. I promise you, they have never said, well, that law enforcement agency busted that line on that law enforcement exception. King's X, you get
Yeah,
it. No. What they'll do is they will bend over backwards. If that law enforcement exception can be claimed, you're not getting it.
Yes.
The end.
That
Because
is-
even if
that is
they
very
file
true.
it late, you're still not getting it. And I'd like to know when he says the representative sample was one thing, but they filed substantially different documents. What do you mean? What does that mean?
One different page, or
What's substantially different?
yeah. Notice that hasn't been asked or answered yet. I'd be interested to see if
Well, to me, that is an
Cross
obvious
does
question
that.
to
What
ask
was the difference?
on cross.
And again, arguing the defense's position here, the defense is going to say that the Attorney General obviously had the authority to release this. It's obviously public record, and this is an important part of the case because we're showing that the DPS was part of the vast conspiracy to get rid of Ken Paxton. So, I mean, they've made the DPS into their boogeyman, the federal government, the boogeyman, the FBI, this whole investigation is all rigged to get rid of Ken Paxton.
Deandra, when you run a conspiracy, do you usually involve a lot of people?
yes. Well, no, you have a core group. I mean, there may be a lot of people
The more
in
people-
drug conspiracies. There will be people that know a little tiny piece of the conspiracy because they indict 30 people.
Right, but in a sense, let's say a political
But on this,
conspiracy.
no, it would be a small
Cabal.
group.
And the reason
yes.
for that is because the more people you involve, the more people might talk. That's why, Tanya, we're sitting right here a few blocks from Dealey Plaza. Every time someone says there must have been a conspiracy in 1963, you say, well, if there was a conspiracy, somebody would have talked by now.
Exactly. And
Very true.
And
Very
I mean,
true.
in this particular conspiracy, the Nate Paul conspiracy, right? The idea
Yes.
that, so you're going to have, we haven't said this in a couple days, so I feel like I have to say it again. We're going to have a federal magistrate judge.
Don't forget the clerk.
The clerk who's dead.
Yes, the dead clerk.
A bankruptcy judge, U.S. attorneys, FBI agents, DPS, State Securities Board, agents with the State Securities Board, a member of the State Securities Board. All these people got together and conspired against Nate Paul.
Whoever changed the letterhead, it goes all the way down to
Letterhead gate.
Yes, exactly.
I mean, everybody.
that's not-
just a
it's-
ridiculous one.
No, it's completely ridiculous. But that's their theory, is that there was this big. Well, it was Nate Paul's theory.
Well, we
obviously,
actually have two conspiracies. We have the conspiracy to get Nate Paul, right?
Which is what Ken Paxton was investigating.
Right,
Yes.
and then we have the conspiracy, the alleged conspiracy, to get Ken Paxton.
Yes,
And
which
but-
took
which
all these
involved
people,
all these people,
all these law enforcement agencies.
And all these political factions.
right? And that his hand-picked lieutenants in his office, people he had hired and put into place, they all got together. I guess at Johnny Sutton's direction. Is that what we're?
know
Bush, I
whether
mean-
it was at Polvo's or at Galaxy Cafe.
Well, if it was at Starbucks, make sure you got your ride home.
That's right.
That's all
Oh
I've
my
got to
God.
say.
Well, while we're sitting here waiting, you watched Brandon Kamek's testimony.
That was
Talk to me
unbelievable.
about what you thought about that.
Well, he was a little patsy, which is sad for him, but I think the whole story about them going to the Starbucks won't even let him in the building to have a meeting in Ken's office. Oh, we'll meet you at the Starbucks. We'll take you to the Starbucks. You can't actually come in the building. And then we're going to tell you, not only are you done, your contract's void, we're not paying you, tough. And then we're just going to drive away and leave
Well, they
you
did
there.
give him a ride ultimately.
Well, because he
wouldn't-
said, hey, are you just going to leave me or do I have to Uber
They
back to
wouldn't-
my car?
They wouldn't pay him what they owed him, then they ditched him at the Starbucks.
That's just
This is
unbelievable.
This is a bad romance.
It was not a good situation
Well,
for
and I
Brandon.
keep going back to if everything is on the up and up with this contract, right? If everything
Yes.
is good to go with this contract, why don't you pay him? Why? To me, you say we paid the guy. We paid the guy for the work he did. So nobody has explained and maybe they will explain why why Brandon Kamek doesn't get paid.
And you've got a giant trust fund that you can just move $121,000 out of when you need to.
Well, that's Ken Paxton's personal funds.
Right, but they refuse to pay Brandon Kamek, and it's come back to bite them.
If you were a prosecutor,
Forgot.
right?
Yes.
Most lawyers I know,
Yes.
at one point in
In
their
Dallas.
lives in Dallas, were prosecutors at some point or
under
another.
John Vance. So a long time ago. I'm dating
That's okay.
myself
well,
big time.
I could start dating myself too. When I started quoting from A Few Good Men yesterday, I knew that I was dating myself. But if you're going to go out and you're going to pick somebody because you think there's a grand conspiracy against Nate Paul, do you pick Brandon Kamek as the guy that's going to be the guy to investigate this?
Well, if you want someone who's not going to ask any questions, you absolutely pick Brandon Kamick. He's the perfect choice. But if you want someone to actually do a real investigation, it was the other guy, the guy that used to be
Joe
out
Brown.
in Grayson County, Joe Brown. He would have actually done he was reluctant because the whole thing sounded, that's why he didn't get the job, is because he was like, okay, well, I'm willing to look at this and write a report. Whereas Brandon was like, oh, wow, this sounds
convincing.
This sounds very convincing. You're showing me some metadata. And so this sounds really bad.
Can you get
so
Nate
that's
Paul's
the guy that gets
attorney
the
to
job.
come out with me and serve these subpoenas?
Which was that. I'm sorry.
That's
I'm
not
sorry,
regular-
viewers.
Are you
If
sure that's not regularly done?
If
Are
you
sure?
think that happens, I am sad to burst your bubble. That was one of the biggest things I've heard. That was just no way did that happen.
Well, and then the idea that you have Nate Paul's attorney, not only that, I mean, that which is cuckoo for Cocoa Puffs, but you also have Nate Paul's attorney providing the list of who you need to go subpoena, and on that list is all these law enforcement people, these federal magistrates, these banks, and also opposing counsel in civil actions involving Nate Paul.
Well, so once again, Kamick was the perfect guy because he wasn't experienced enough to know that something was very wrong. Something was very wrong, and that the other Joe Brown would not have done that. He would have said, "No, wait a minute. I'm willing to look into this, but I'm not issuing subpoenas to some federal judges and magistrates over this."
And Brandon Kamick doesn't even seem to, based on his own testimony, seem to have been aware of who he was really subpoenaing, who these people were. He seemed to be taking at face value.
He had a list of names.
Yeah, give me a list of names and let me send them out into the world. I have never heard of such a thing.
He didn't ask any questions because he didn't see what was happening. He didn't ask any questions because he was young and inexperienced, and he was the perfect guy for the job.
Obviously, you both have bought into the vast rhino conspiracy.
Well, I'm tell you what, if you're going to be a rhino, it's not going to be any of those people I've seen testify. Those are some of those conservative people that I've seen, and those are true believers that I've seen testify, and they've not been rhinos. If you're going after them, I really don't think. Well, the senators are obviously the jury, so it's effective possibly in front of them. But in a real criminal trial, you need a better story, a better theme from the defense. I think the theme could have been there was just a lot of mistaken information. Like the guy misunderstood, we're going to check with Nate Paul thing. Like it was just all a misunderstanding. You could have cleared up misunderstandings as opposed to the vast, what do you call it, the vast right-wing conspiracy?
Well, I guess this is a vast rhino conspiracy, right? I mean, run by Johnny Sutton and George P. Bush, I guess? I mean,
we've got Dick Weekly, Johnny Sutton, the FBI, the DPS, Dade Phelan, the Bushes, George P., his family, and the Ashcroft Law Firm, and I think probably the school crossing guard at Ann Richards Elementary School in Austin.
You could have
All right, let's take a listen.
Members, take your seats. So we're going to proceed slowly, carefully. You may proceed.
Thank you. Mr. Gordon, as a preliminary matter, if a document is released after a ruling request or a ruling decision, would that be released to a subsequent requester for that same information?
Objection calls for speculation.
Overruled.
Yes, there's a specific section that directly addresses that. Section 552.007 of the Government Code prohibits the governmental bodies from selectively releasing information and provides that if information has been released to one requester, then it would be released to a subsequent requester unless there's a special right of access that applied to the initial requester.
Okay.
Sorry.
All right. Mr.
Okay.
Gordon, repeat your answer. Slow down.
Yes, sir. Yes. There is a specific section of the Public Information Act that addresses that. It is section 552.007. It provides that if information is released to one requester, then it would be released to a subsequent requester. It prohibits the selective release of information to one requester and not to another. So if information has been released by a governmental body, then it would be released to subsequent requesters unless there is a special right of access that only applied to the initial requester. For example, if I ask for my driver's license number and receive it, you wouldn't release my driver's license number to the next person because I have a right of access to that.
Thank you for that explanation. Eric, could you please pull up within House Managers 46 at Bates 8803, which is page 77 within that PDF. Mr. Gordon, can you see that on your screen?
Yes, I can.
Does this appear to be a fair and accurate picture of the redacted brief the FBI provided to Mr. Larson?
That's correct.
And Eric, if you could scroll to the next page, so to 78, go down. Is this showing an entirely redacted page?
Yes.
And does that continue through the majority of this brief?
Yes.
Is this unusual?
Yes.
Can you explain why?
Under the government code, if a third party submits comments to our office objecting to the release of information, they're required to notify the requester and provide the requester with a copy of those comments. They are permitted to redact the comments, but only to the extent that it reveals the information that is requested. In this case, they've redacted the entirety of the brief, including all of the substantive arguments.
And why does that matter?
That matters because the requester was not put on notice about what arguments the governmental body was making and would have been unable to respond to them to our office in order to refute any statements that were made or directly address the statements that were provided by the briefing third party.
Is this another procedural violation of the PIA?
Yes.
So far we've talked about at least 3 procedural violations or irregularities with this file.
Objection,
Yes.
leading.
Restate your question. Sustain.
Can you estimate for us how many procedural irregularities we have discussed related to this file so far?
There was the failure to submit the representative sample, or they submitted the documents late. Mm-hmm. The representative sample that they submitted the second time was not indicated that the first representative sample was not actually representative. They did not notify the third party in a timely fashion. And then when the third party briefed us, they substantially redacted their briefing to us. Or I'm sorry, they substantially redacted the copy of the briefing that was provided to the requester.
Are you able to tell us how frequently you work on a file that has 4 different procedural irregularities?
We see a lot of procedural irregularities. These are pretty unique, though, in the way that they came in. Ordinarily, what we see are missed deadlines. So it would be pretty rare that we see 4 completely different procedural violations like this.
And again, what can be the consequence of a procedural irregularity of the nature you've been discussing?
If a governmental body fails to comply with the procedural requirements of the Act, then they would waive their discretionary exceptions.
Meaning that any documents that fell within a discretionary exception would be released?
Objection, leading.
Sustain. Rephrase your question.
So what's the consequence of that, of the permissive exceptions being waived?
If a permissive exception is waived, then we would not apply it or review it in the context of those documents. And if that's the only exception that's addressed, then those documents would be released.
And in this particular file, the DPS file in front of you, was the only exception raised the law enforcement exception?
That's correct.
And it is a permissive exception?
That's correct. They did not raise any confidentiality provisions. They only raised the law enforcement exception.
Do you recall meeting with the Attorney General about this file?
Yes.
And I don't want you to go into what anyone said at that meeting, okay? But could you please tell us what topics were discussed?
We discussed this topic, this DPS file.
Did you discuss options for how to proceed?
Yes.
And what were those options?
The primary options were to release the information, to conclude that there had been a procedural violation and a failure to establish that the information was accepted from disclosure. And then the second exception, which was the primary option, was the closed letter that we ended up issuing.
Did you agree with with issuing the closed letter?
Yes.
Why?
It was correct. The procedural background of the request put the requester at a significant disadvantage, and allowing the procedural actions that were taken would have really been a detriment to that requester. There was already a pending lawsuit, and courts will give our letter rulings great weight, and rubber stamping the actions in this procedural context would have, or could have, I don't know what the court would have done with our ruling, but it could have tilted the scale in favor of a governmental body who had failed to comply with the procedural requirements.
And I want to make sure I understood your testimony a moment ago. You considered releasing all of the information. What do you call that within ORD?
Pouring out.
And would that have been supportable under the law, in your opinion?
It would have been pushing it. I agree with the closed letter. I feel like releasing it all would have been pushing it.
To your knowledge, had ORD issued closed letters of this nature in the past?
Yes.
Eric, I'm going to ask you to pull up the closed letter, which is within House Managers 46 at page 2, and please take it off the screen before finding the new page and placing it there.
Counsel, what was the Bates number that you directed him to, please?
It's page 2 of the PDF, which is in front of you.
That OAG 8728?
I don't have it in front of me, but it's the closed letter. Mr. Gordon, does this appear to be a complete and accurate copy of the closed letter?
Yes, it does.
And in that letter, you reference a prior ORD decision, right?
That's correct.
Why? Why did you reference that prior ORD decision?
Well, there were a lot of reasons. The primary reason is that what this open records decision specifies is that if a lawsuit is filed after a ruling request is made, I'm sorry, let me take it back and maybe simplify it. Under the Public Information Act, a requester can sue a governmental body if they believe they're improperly withholding documents. What this open records decision provides is that if a requester files a lawsuit after a governmental body has issued or has requested a decision from our office, then our office should still go on and issue a ruling. Prior to this decision, we routinely closed files and did not issue determinations where the issue that come before us in the decision was in court. So we would demur and close that letter and let the court decide.
And in your opinion, how did this DPS file differ from the closed letter that you issued in this case? How did that differ or was distinguished from that ORD decision?
It was all of the procedural irregularities, especially the redacted FBI brief. That was the primary issue that prevented us from ruling in accordance with due process. It was the heavily redacted FBI brief.
And why did that cause you so much heartburn?
Again, our rulings are given weight or great weight, quote unquote, by the courts. And in the face of those procedural irregularities, giving a rubber stamp of approval to them could have tilted the scales in that court, even despite the procedures being handled incorrectly.
Could it also set bad precedent?
Objection leading.
I'm asking his opinion, Your Honor. It's a yes or no. He can say what he'd like.
Overruled.
I'm sorry, I didn't understand. I didn't hear the question.
Sure. Could it also set bad precedent in PIA requests coming into your office?
Objection, Your Honor. The relevance of this personal witness's opinion is not relevant to any issue in this proceeding. And what he considers a good or bad precedent is purely subjective and not at issue in this case.
Your
Overruled.
Honor, thank you. You can answer the question.
I wouldn't characterize it as a precedent. So many of our rulings are fact specific. What I do think it could have resulted in, because DPS and FBI routinely brief our office, it could have again been seen as condoning that type of heavy redaction, which then could have led to that type of action being taken in future requests and for future requesters. So I wouldn't have characterized it as a precedent, but it could have indicated that we thought that was okay, and then they would, because they do it routinely, they request decisions from us routinely, they could have seen that as now we've got the stamp of approval to do this, and now we'll keep doing it.
And now, while all of this is going on, were you made aware of a request from Mr. Larson for a copy of the FBI brief?
Yes.
How were you made aware of that?
That came in as a Public Information Act request. The Public Information Act request was forwarded to my division for handling. And when I say handling, I mean we collected the documents. So we collected the unredacted brief in processing that Public Information Act request, and we provided it to our Public Information Office.
As to the DPS ruling itself, did that closed letter result in the release of any documents?
It did not.
Okay, so this request from Mr. Larson comes in for a copy of the brief. Do you know what happened after that was received?
I know what happened after the fact. Because it involved open records decision documents, our division does not rule on decision requests for our own documents, so it was handled by another division. But through the process of this whole circumstance, I did become aware of what issued or what happened with that public information request.
And your division maintains those files even if it doesn't necessarily make the decision on the request, correct?
That's correct. Because the FBI submitted the brief to our office, we were the ones who maintained that as part of our work file.
Have you reviewed the ORD file for the FBI brief request before?
So just to clarify, our office or my division does not have a file on that public information request. We have the file that's here before me as this PDF, and yes, I have reviewed that, but I have not seen the opinions file or the public information office file involving that ruling request for that brief.
Now, in the file in front of you, there is a copy of the unredacted FBI brief, correct?
That's correct.
Would you take a look at it, please?
Okay, I'm looking at page.
And what I want you to look for, you're the chief of ORD. I want you to set aside law enforcement exception for a moment. I want you to look at that brief and let me know if you think there are any mandatory exceptions to public disclosure that are flagged within that brief.
Not to nitpick, but there is Mr. Larson's email address is at the end of the brief, but he was the requester. So no, but other than that, I don't see any confidential information on the face of the document.
Thank you. And just one more thing on, forgive me. Your Honor, if I may approach with what's been marked as AG 34.
You may.
Mr. Gordon, do you recognize the document I placed in front of you?
I do.
And what is it?
This would appear to be the internal file for the opinions ruling request that we've been discussing that was Mr. Larson's request for the unredacted FBI brief.
Does OAG receive requests for copies of PIA briefing on other occasions?
Yes.
Does that occur can you tell us with any sort of frequency how often you receive that type of request for briefing?
If I had to guess, I'd say it would be once a month, probably less than once a month it's not very common. It's not a weekly occurrence.
And were you familiar with Joe Larson?
Yes.
How?
I've worked with Joe Larson for a long time. He is a well-known open government lawyer. He's also involved with the Freedom of Information Foundation, which our office has partnered with in the past to perform trainings. He's routinely sought after to provide input on Public Information Act requests. I've also observed a number of cases that he's handled because he ends up often handling important Public Information Act cases. So I've known Mr. Larson for a long time.
Was, based on your knowledge of Mr. Larson and working with him, was it surprising or unusual for him to submit a request for a copy of that redacted brief?
No, I wasn't surprised at all that Mr. Larson would ask for that.
And you started to walk us through what OAG does when it receives a request for documents that OAG itself holds. I just want to make sure that's clear for the jurors, okay? So let's walk through it. So what's the first step OAG would do when it receives a request for records that it itself holds?
That would be received and handled by the Attorney General's Public Information Office.
Objection, Your Honor. I apologize to the witness, but at this point, it's clear from the witness's own testimony that once this request that's about to be discussed was made, it went to a different division, not his, that he does not oversee, and he's previously testified that he was not involved. So any information that he has about specifically how it was handled or by whom would be hearsay or speculation.
Your Honor, right now I'm asking him to walk through the general process of how this is handled, which is something that as the chief of ORD, he is intimately familiar with.
The witness can answer. Overruled.
When a request comes into our Public Information Office, the Public Information Officer will identify the divisions that they believe maintain documents, and they will notify those divisions. Those divisions then collect the information. Generally, we collect the information unless there's some issue with the request, like we don't understand it or it would require a cost estimate. Those divisions, my division in that case, will respond back that we maintain documents, and then we'll follow that up by providing those documents. If a decision is required, then the Public Information Officer will prepare that decision, and they will send it to our division. As soon as we see that we've received a request from the Attorney General's office, it gets segregated out, and at this time, it would have been forwarded to the Opinions Division.
So ORD is not deciding decisions on documents held by ORD, is that right?
That's correct.
Action leading.
Sustained. You can re-ask the question.
I think the point's been made, Your Honor. I'm going to move to admit AG 34. It is an internal business record of OAG. It was actually given to us pursuant to a business affidavit that has been on record for more than 14 days.
And Your
Any
Honor,
objection?
as we discussed at the bench, the issue is not the business records affidavit. It is protecting the sensitive information of law enforcement, how they conduct their investigations, and specifically the individuals involved. An exact identical copy of the same brief we just talked to you about at the bench is also contained in this document. And so I have no objections as long as she's willing to protect law enforcement and the integrity of their investigations and redact that sensitive information. With those redactions, no objection.
And Your Honor, the chief of ORD has now looked at this brief and told you that there were no mandatory exceptions and no confidential information within that brief. Mm-hmm. He's also testified that once documents are given to one requester, they are given to any subsequent requester. They are considered public. And so I do believe that he is very highly qualified to speak to this file, and that there are no confidentiality concerns raised within it based on this witness's testimony.
Brief response, Your Honor.
Yes.
Everything my colleague said misses the point. All I'm trying to do is make sure that the sensitive law enforcement information, which is in front of you, the identities of the individuals involved in the investigation, how they conducted the investigation, their sensitive operations plans, their sealed search warrant affidavits, and the details contained within, how they communicate with each other, who was on those communications, and when they were sent, all of that information, I just would ask, would be redacted.
And Your Honor, very quickly.
Stop. Don't talk over each other. Court reporters have a tough job as it is. Come up for a moment again.
Well, you know, Deandra and Bud, I have filed lots of open records requests in my life. Mm-hmm. And I feel like when this trial is over, I want a transcript of this guy's testimony because I plan to use it the next time.
They deny.
Yes, absolutely. The next time a law enforcement agency busts a deadline and claims the law enforcement exception, and then they still try to withhold it, I'm going to say, hey, this is what y'all do. You did this for Nate Paul. I'd like the same treatment.
Well, this is one of the key points. The House wants to say they made special effort and went to a special extreme to help Nate Paul. The defense wants to say, we're the Attorney General and we can do whatever we want.
Well,
I think that it's also hard because they're talking about things we can't see. It's been one of the things I've noticed this whole time. You know, normally in a trial, exhibits are produced and you can see them, and we can't see any of this stuff. So it's even hard to understand what they're actually talking about. But I agree 100%. Usually the AG's office, it's law enforcement exception all
whether
day long.
deadlines are busted or not. And I have had them, and I can't remember the exact language, but I have had situations where filed the request, law enforcement agency, oftentimes the Dallas Police Department busts a deadline, still files and says, you know, and I'm paraphrasing here, we still claim in the law enforcement exception, la 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 la, and I still don't get it.
Yeah, rubber stamped. It's rubber stamp letter. We've gotten them too, where we've requested stuff from police agencies. Police agency goes way past the deadline. AG's office still turns
are you going to
down.
be citing this in your
Yeah,
briefs?
I think we're going to call it the Nate Paul exception now, I guess.
Yeah, I mean, I want the Nate Paul exception too. I want that kind of love from the Attorney General's office, and I plan to ask for it. And I guarantee you that every reporter out there in the state is going to be doing the same thing. So the AG, they have just opened up a big old can of worms.
Well, it
for
sounds like
themselves.
you just need to email Justin Gordon
I'm
and
gonna
say, Justin, hey, Justin,
I want the Nate Paul exception.
I want the Nate Paul exception.
I want that love from you.
Because they're late. There's some, what's he call them? Procedural irregularities. So hand it over.
Yeah, the first sample turned in late. The representative sample they initially turned in was substantially different than what they turned in
And
later.
no one has explained what that means.
Yeah, what does that mean?
This
More
reflects
pages.
the antagonistic role the AG's office took toward other law enforcement agencies, toward the court, toward the DPS. I mean, the AG set itself up as the sole arbiter of what was constitutional and unconstitutional, regardless of precedent or other law.
Well,
I'm really looking forward to the cross. I want to see what she asks old Justin Gordon about how many other times he's done this. Those are the kinds of questions you're going to want to ask. Like, how many other people where there were procedural irregularities did you go ahead and take these actions for?
I would love to hear that. I want to hear that.
And also, what specifically was different about what you got the first time and what you got the second time? What was the substantial difference?
Well, they're
'Cause
using
we
some
haven't-
buzzwords here.
Yeah, what is-
Procedural irregularities.
Yeah, what does that mean
And
exactly?
substantially different. Well, you know, is it really all that different? I mean, because they haven't, like you said, they haven't explained what they mean, and I guess we also don't understand. We don't really know like how this time. You know, the prosecution only has a little over 2 hours. You know, how is that going to hamper their ability to cross? Or do you need much time to cross this guy?
Probably don't. I mean, you should have your list of questions and go bam, bam, bam. I don't know who this young lady is who's acting on the behalf of the
Actually,
The defense.
somebody sent me that.
no, the
Hold on,
state
I'm gonna go look up the
Well,
name.
or the AG's office.
Well,
in the
Allison
pink.
Collins, is that?
Oh, yeah, Allison Collins.
Allison
Well,
Collins is the defense attorney, and she. And it's interesting that she is sticking to this argument that because they gave somebody the document, they have to give everybody the document. That's state law, but you know, it would seem like at least out of courtesy, they would have some redacted version to give in public in court, just out of. She is sticking to that totally, saying we get to give out everything we gave out.
I am telling you, they are opening up a can of worms here that they are not going to be able to put back in. Every reporter in this state, lawyers like Deandra Grant are going to be saying, and it will become the Nate Paul exception to the open records law.
Right,
on these
Justin.
issues, because
Justin.
and law enforcement entities better stop busting deadlines and better start because we're going to all say, well, they busted the deadline. Where's my records? Send them on to me. Oh, and and I'm going to start requesting these briefs. I'd like the briefs too. Oh, and if you bust the deadlines on that, I'd like the whole thing.
Right, non-redacted. Yes, unredacted.
Also, we'd like all the call records from those 4 cell phones that the Attorney General had, but I don't think we're going to get to that.
Well, people say I should be happy. Actually, no, this is thrilling from an open records perspective.
Yes.
This is like, Actually, I'm kind of excited because this is like new ammunition from an open records perspective. As someone who files open records requests practically daily, kind of considers it a God-given right. This is kind of cool.
Well, you've actually interviewed me on issues before regarding elected officials in Dallas County where I've said, well, why don't we try to get this record? And you're like, well, they're going to claim the law enforcement exception. They're never going to give it to us. Never going to give it to us.
How many times have you gotten something? One time, when Ethan Couch in Lakeside, and I requested all the tickets that Lakeside had written in a given day, knowing that one of them was to Ethan Couch. And I was able to get all those tickets. That's the only time that I've been able to get anything at all that involved law enforcement.
Well, tickets have a presumption of being public. Now, where you would probably run into problems is like there's going to be some things on that ticket, like dates of birth, driver's license,
address.
Address. Well, yeah,
maybe
address. I think you would get addresses, but there are definitely driver's license. If they don't really put social security numbers on stuff like that anymore, but there are definitely some things that are confidential by law. But one thing I want to talk about while we're kind of sitting here.
Yeah, we're talking inside baseball.
We are. Well, it's because those of us that file open records requests, this is actually really exciting stuff. Yeah.
They're coming back.
Oh, they're coming back.
Let's see. Well,
is
there a little discussion going on up there with Patrick?
Let me take a look at the live. I've got the Senate feed up as well, the direct feed, which is about a little bit behind ours because we're trying to make sure that we don't step on any of the testimony. Yeah.
For people who want to know, what we're talking about here is Article 3 of the Articles of Impeachment, disregard of official duty. Paxton misused his power in administering the state's public information laws by directing employees to act contrary to the law on an open records request, releasing public DPS documents, and also in another case.
Yeah.
The House only has to prove one article of impeachment for Ken Paxton to be removed from office. They are prosecuting him on 16 articles. They're asking the Senate to sustain any one of those 16 articles to remove him from office.
Okay, so we're back in session.
Members, we will take a break in a little bit, just a little bit. Everybody be seated, please. So as we have been going through this testimony, slowly continue.
Mr. Gordon, the file placed in front of you marked as AG 34. Is there any search warrant inside this file?
There is no search warrant inside this file.
Are there any emails between the FBI and DPS inside this file?
There are no emails between the FBI and DPS in this file.
Did you notice any victim information inside this file?
I did not.
And if the redacted FBI brief had been released to one requester, it would be released to other requesters?
That's correct.
And you've had a chance to look at this file now, correct?
Yes.
And at the back of it, you'll see that, well, let's walk through it. So I think you've testified that Based on this file before you, does it appear that OAG sent a notice to the FBI about this request for their redacted version of a brief?
Yes, it does.
Did the FBI respond?
Yes, they did.
And I want you to take a close look at their response brief, and specifically the last page under the signature line. It's the last page of the file. Are you there?
Yes, that's page 6 of the draft.
Witness needs to stay close to the mic and speak up.
Does it indicate that the version sent to Mr. Larson was redacted?
Objection, Your Honor. The counsel is mischaracterizing the evidence and honestly misleading the witness. The document that she
Overruled.
is...
You may answer the question.
On this brief, it does not say redacted after the CC list to Mr. Larson.
And this brief was filed by a Mr. McPhillips from the FBI, is that right?
That's correct.
And from the front of this brief, was it filed, and it's actually marked as received by Open Records on or about June 18th, 2020? Do you see that?
Yes.
And then I want you to look immediately in front of this brief is a copy of the redacted brief at issue. Do you see that?
I'm sorry, would you repeat the question?
Yeah, if you keep flipping forward in the file, the next thing you see is a copy of the blacked out brief that the FBI had filed first.
I believe that's, I don't see in this.
The Bates at the bottom of the page I'd like to direct you to is 49982.
49982. Oh, yes, okay. That's the last page of the redacted version?
It's the last page of the brief that the FBI filed in May of 2020, right?
That's correct. I'm sorry, I was looking for the version that was actually redacted. There's no redacted version.
I apologize. There is no redacted version in here. And when you look under the signature, first, who signed this brief from May 2020 for the FBI?
Matthew Phillips.
So the same
Or
Mr.
Mick
McPhillips?
Phillips. Yes.
And underneath his signature line, what does it indicate next to Mr. Larson's signature? I mean, next to Mr. Larson's name on the copy list?
Next to Mr. Larson's name on the copy list, it says it was redacted.
So the first brief was sent to Mr. Larson, redacted. Is that what it represents to you?
Yes.
And so the second brief, the June 2021, based on the documents before you, was that redacted when it was sent to Mr. Larson?
It does not indicate that it was redacted.
Does that indicate to you that the FBI provided a copy of this brief directly to Mr. Larson?
Objection, leading.
Sustained, rephrase your question.
What does that indicate to you?
That indicates that they provided the same copy of this brief that they provided to DPS, not unredacted.
And I want you to take a look at this June 2020 brief and tell me how it compares to the May 2020 brief.
They look very similar. There is some different language certainly at the beginning, but they look very similar.
Other than the first paragraph, they are very similar.
Yes, that's correct.
So based on the documents in this file, does it appear that Mr. Larson that the FBI provided this information itself to Mr. Larson?
Yes.
And the very front of this file is the decision issued in this case. It starts with Bates 49954. Do you see that?
I do.
And you just looked at the FBI's June 2020 brief addressing whether or not that blacked out brief should be released to the public, right? You just looked at it?
I did.
Did it anywhere in there argue that their redacted brief should be withheld from public disclosure?
No, it looked like the arguments applied to the documents that were issued in the underlying DPS file.
And so when that happens, when the comments don't address the information being sought, what, in your experience in ORD, happens in a file like that?
In that case, we would not apply the exception to the documents that are submitted. We ordinarily, because this opinion was done by opinions, they use slightly different language than us, but we've got boilerplate for that type of circumstance. Either that the entity that submitted the arguments is arguing against the release of information that was not submitted to our office, or that the arguments that they've submitted don't apply to the information that is at issue. Because we have a presumption of openness, there has to be an exception to disclosure in order to withhold the information. And if it's a discretionary exception, it wouldn't be applied to information that they don't seek to withhold. If it's a discretionary exception, they have to seek to withhold it in order for the exception to be applied to it.
And the FBI, so the FBI just didn't address their redacted brief at all, based on this file, is that right?
That's right.
Which would result in what, ultimately, for the requester?
That would result in the information, that would result in the arguments that are raised not being addressed to the information for which there are no arguments. And if there are no other arguments, then the information would be released.
Okay, so I want to make sure we all understand what your testimony has been here today. So we had the first request to TSSB in the fall of 2019. Was any information disclosed to Nate Paul as a result of OAG's ruling?
No.
Then we move on to the big request to DPS in the spring of 2020. Was any information released to Nate Paul as a result of that ruling?
No.
And then we get to this third request. And what we see is that the FBI provided a copy of the brief directly to the requester itself. Is that right?
Objection, leading.
Overruled. Repeat the question and answer.
We get to this FBI request for their blacked out brief. And what we see is that the FBI directly gives a copy of the brief to the requester, to Nate Paul. Is that correct?
Objection, Your Honor. It should be made clear for the record that we are talking about two different briefs, one in May and one in June. And the one in June, yes, there's no dispute. The FBI provided that to Nate Paul's counsel. That is not the one that contains the sensitive information that we have been discussing.
Clarify.
Of course.
I sustain the objection. Clarify.
What we're seeing from this file is that the FBI provided a copy of its June 2020 brief directly to Mr. Larson. Is that right?
Yes, that's correct.
And you've also testified that that June 2020 brief is very similar to the May 2020 redacted brief, right?
Yes, that is correct.
And that ultimately, because the FBI did not address why their redacted brief should not be released to the public, it was released.
Objection, leading.
Sustain. Rephrase your question.
What was the ultimate outcome of the opinion on this FBI request related to its redacted brief?
The opinion concluded that the unredacted brief could be released to the requester.
And you reviewed that brief?
Yes.
And you did not see any mandatory exceptions within that brief that would require OAG to apply its own redactions before release?
That's correct.
Objection, leading.
Overruled.
That's correct.
And after this ruling in August of 2020 on the FBI brief, do you recall one way or another if Joe Larson, on behalf of Nate Paul, continued to seek information from public safety agencies through public information requests?
Yes, he did.
And how do you know that?
He continued to pursue complaints against the Texas State Securities Board all the way through September of that year, seeking to obtain documents that TSSB was withholding from him in the context of Public Information Act requests. So then that continued, throughout the summer and into the fall.
And after ORD rules on a request, what does ORD do with the documents that the governmental agency provided to you to make your ruling?
We send the documents back to the governmental body.
You don't keep a copy?
No.
Those are all my questions for this time. Thank you.
Thank you, Ms. Collins.
Examination, Your Honor.
Yes.
I'm so sorry. One thing, we are moving for admission of HM 46 and AG 34 based on this witness's testimony.
Your Honor, same objection. All we're trying to do is protect the sensitive law enforcement operations, who was involved, when emails were sent, what the subject of those emails were, what the FBI's operations plans were, how they work with the State Securities Board, the FBI, the DPS. If that information can be redacted, no objection.
Hold on. We've discussed this at length. He testified there was nothing confidential. The FBI could be here. They could be called.
Yes, Your Honor, or Mr. President, yes, that's correct.
Either one, doesn't matter.
Okay, yes, sir.
But they're not here.
They're not, however, I would like to, for the record, remind the court that it was Mr. Bangert's testimony opposite to Mr. Gordon's.
Your Honor, I'm going to insist that she not say testimony of another witness in front of this witness.
Okay. Both of you, just stop for a moment, okay?
Okay, so our mics are up. Deandra, go ahead.
Okay. I'm interested in what, it seems like they already had a little powwow on this exact objection, and now they're back talking about it. So I don't know what the issue is. I thought he'd already made a ruling on it.
And this seems to be more lawyers involved in this discussion besides Justice Myers. This looks like when they call all the referees in to look at the video replay to figure out what's going on.
Yeah, it was kind of.
Your Honor, if I could, I just want to make sure that there's no misunderstanding or misstatement here.
Jurors, please take your seats again.
I just want to make sure that there's no misunderstanding here, that you have a complete copy of those files in front of you, and you can see for yourself that there are no copies of search warrants, there are no copies of the actual emails within those files, which appear to be the documents that counsel is concerned about, and I just want to make sure that's clear for the record, that those documents are not in those files.
And we have reviewed them while up here going through this testimony. Is it your representation as an officer of the court that this document has already been released to the public?
Yes.
Both documents?
Yes.
And that was the testimony?
It was.
I have to overrule your objection. We'll admit into evidence AG 34, and OAG Exhibit 46.
That should be HM 46 and AG 34,
I'm sorry.
Your Honor.
HM 46, yes.
Thank you, Your Honor. Those are my questions for now.
Yes. Your witness.
Good afternoon, morning, Mr. Gordon.
Please state your name for the record for the.
Leah Graham. You talked about this decision being fact-specific. Do you recall that testimony?
Yes.
So let's talk facts. The requester in this case was Nate Paul's lawyer, correct?
Objection, speculation.
I believe that same testimony was elicited on direct that Joseph
Overruled.
Larson.
Go ahead.
Correct.
We did not know that at the time. It's become apparent that that is the case now, but we did not know that at the time.
In your original opinion, as it relates to the request for the full release of the DPS file, was that it should not be released and that the law enforcement exception applied. True?
That's the big DPS file that we're referring to?
Yes, sir.
The original draft on that, I believe, did just address it under the law enforcement exception.
And that was your opinion that it should not be disclosed under the law enforcement exception, correct?
No, that was not my opinion. That was just the first draft that was on the ruling.
Who drafted the first draft?
I'm not sure if that was the drafter on the ruling or if that was me. I don't remember.
You had direct conversations with Ken Paxton about this specific request for a full copy of the DPS file, true?
Yes.
He made it clear to you that he wanted to find a way to release the documents that Nate Paul's attorney was requesting, true?
Objection, Your Honor. That's improper testimony through this counsel, assuming facts that have not been addressed with this witness.
Your Honor, this testimony has already been elicited.
Overruled.
True?
No.
Mr. Paxton did not summon you to his office to talk about this file?
Yes, he did.
He did not put pressure on you to either not rule against the requester or to release the information?
No, I would not classify it as pressure. The decision that we made was not.
Sir, I appreciate that. I'm not asking you what the decision was made. I was asking about your conversation with Mr. Paxton. He had one of two things that he wanted to occur. Either release the information or at a minimum, figure out a way not to rule against the requester. True?
Same objection, Your Honor, assuming facts not before this witness.
Sustained.
In your conversation with Ken Paxton about this particular DPS file, can you recall any other time when Mr. Paxton directly came to you and got involved on a DPS open records request?
No.
Ultimately, you did exactly what Mr. Paxton wanted, correct? You did not rule against the requester, Nate Paul's attorney, true?
Again, objection, Your Honor, assuming facts not before this witness.
Overruled.
True?
I'm sorry, could you repeat the question?
Yes, sir. Ultimately, the opinion was not to rule against the requester, which was exactly what Ken Paxton was pressuring you to do, correct?
Again, Your Honor, I'm going to object. She's now mischaracterizing this witness's testimony. He said he was not pressured.
Sustained.
By not ruling, you were not ruling against the requester. By making a no decision, that's not ruling against the requester, true?
That's correct. We didn't rule against either party, the requester or the governmental bodies at issue.
Now, earlier you said that the OAG decision not ruling against Nate Paul's attorney, quote, tilted the scale in terms of how a court would ultimately decide whether or not to rule on the disclosure of that information. True?
No, if I said that, I may have misspoken. We did not want to tilt the scale. We didn't want to tip the scale either way. We wanted to maintain the status quo and allow the court to review it completely de novo without our opinion, which is due great weight, tilting the scale based on the procedural requirements.
Withholding the information would have been detrimental to the requester. That's what you said on direct. Do you remember that?
I'm sorry, could you repeat the question?
You said withholding the requested information would have been detrimental to the requester. Do you recall that testimony?
I'm going to object, Your Honor. I don't recall that testimony either, so mischaracterization of his testimony.
And I'm happy to put her on the stand. I'm asking the witness if he recalls his testimony.
We can check with the court reporter.
I have a quote, it would have been detrimental to the requester.
Okay. I'm going to overrule. You can answer yes or no.
Yes, it would have concluded that the information could be withheld.
Now, on June 8th, after the opinion came out, Joanna Ward, do you know who that is?
John Award?
Yes, sir.
Yes.
Okay. On June 8th, she was asking if you still had the file in your possession. Do you recall that?
Yes.
And the file she was referring to was the entire DPS file, correct?
Yes.
And within that file is one part of it would have been the probable cause affidavit that Nate Paul was looking for, correct?
No. I believe that, if I'm not mistaken, I think that was after the ruling had been issued.
It is, sir, but that's not my question. Included within the DPS file would have been the probable cause affidavit that Nate Paul was looking for, true?
No.
The probable cause affidavit would not have been within the DPS file.
Not after we issued the ruling, we would have sent the documents back to DPS.
But by June 8th, after the decision was released, do you recall Joanna Ward emailing you and specifically asking you if you still had it, it was still checked out to you, and asking when you were going to return it? Do you recall that?
Yes.
We talked a lot about precedent and what should be publicly disclosed. You would agree with me that a search warrant is treated substantially differently than a probable cause affidavit or search warrant affidavit in terms of whether or not that should be released to the public, correct?
There are different exceptions that can apply to those, but I would not characterize anything as what can or should be released to the public. It needs to have an exception that applies to it. But both can be released to the public. A search warrant affidavit is more likely to have an exception that applies. They're not automatically confidential.
Correct. No further questions, Your Honor.
Redirect.
Very briefly, in any of these requests, could either party have filed a lawsuit challenging the outcome?
Yes.
Did anyone file a lawsuit for the outcome of the FBI brief ruling request?
No.
That's all I have, Your Honor.
And just so the court knows, because it has been unusual, either side can ask questions from the podium or their tables in case anyone's asking. Can the witness?
Requires no redirect, Your Honor.
Pardon?
Witness requires no redirect. Recross.
Can the witness be excused?
Yes, Your Honor. Thank you, Mr. Gordon.
Am I released, Mr. President?
I'm checking with the House. Yes, you can be released. Thank you. And so we'll call their next, no, we're going to take a break. Sorry. We'll call your next witness after a break. How about 5 minutes after 10? 20-minute break? 11. Sorry. We passed the 10 hour. 5 minutes after 11.
Okay, guys. Reactions?
Well, first he said, and I'm borrowing this from Lauren McGoy of the Morning News, but first he said that Ken Paxton didn't pressure him. Then he said, he was asked, did Ken Paxton ever get personally involved in an open records request? He said, then he said, did Ken Paxton call you to his office to discuss the open record? He said, yes.
That feels like pressure.
Yeah, that feels like pressure to me when you get called to the office.
And he still works there, right?
Yeah.
He does.
Yeah, because he sees what happens if you if you say you got pressured, you're gonna probably get fired tomorrow.
And I would have liked and maybe they didn't do it because of the time constraints. I would have liked the prosecutors the House managers to ask a little bit more about, well, what did Ken Paxton say to you? Walk us through that conversation. Yeah. I just wanted a little bit more.
I did too. I was expecting her to come out punching and ask a whole lot more direct questions like that. And then, do you think it's the time?
I think it could be a time issue.
The time issue?
I mean, because it's a lopsided amount. The defense has, a little over 8 hours. The prosecution has a little over 2.
2.5,
And so they've got to be really careful, I guess, here to manage their remaining time. That's the only thing that makes sense here.
So Allison Collins seemed very confident in her defense performance. Do we think that she won the day? Do we think that she was able to point out that this was handled legally?
I got bogged down in the fighting over which version, which request, which date. I was sort of lost. I feel like she was trying to make some points, but I was losing what the points were. Fighting over which version. was coming in and which version was not coming in.
How do
I
you
got a
think-
little lost.
How do you think this went over with the jurors, the 31 senators? Were they able to follow, or what were they hearing?
They probably were thinking the same thing that a lot of people would be thinking, in that, did Ken Paxton ever call you into his office to talk about this? And the answer is yes, he did. And had he ever done that before? No, he hadn't. And isn't that sort of like the key part of this?
And we've talked about this up here during the live stream, but one thing that Leah Graham did do is she kept repeating the words of protecting law enforcement
Right.
officers, protecting the agents,
Right.
protecting people involved in the investigation, and so she kept reinforcing the idea that it is
Yeah.
the House managers and the prosecution who are trying to protect law enforcement, and it's the defense that is not. And so, although whether she won or lost those motions, those repeated points may have resonated with the Senate.
Absolutely. And I think that, I pointed this out to you guys when it was going on, that I wish that the defense had gone through all this testimony with their witness to begin with, so he would have had all these pages marked, as opposed to sitting there for long periods of time reading through things. He could have had everything marked, and knowing she was going to ask this, and just have everything flow a little bit better, and I think it would have been a little bit more clear.
The other thing that they could have done from the prosecution is asked, did you ever issue a no decision before?
That's true.
They
How many
elicited-
times do you do that?
And the answer is there was one time. One time.
Yeah.
And in this case.
You've
one
certainly
time
never
in
gotten one, have you?
I mean, I keep saying, like, I'm not joking when I say, and others on, other reporters are on Twitter are doing the same thing, saying, hey, we're going to start asking for the briefs. We're going to start saying, okay, they busted the deadline. Because what did he say? We have a presumption of openness.
Presumption of
This
openness.
is the
That's
AG's
new.
office that I want to deal with.
And you
for
need to
open
quote
records.
that in your request, because I
Oh.
know you have a presumption of openness.
I know,
so.
I know. Be so open with me. Because, again, I have had these scenarios where deadlines have been busted, and still I didn't get it. In fact, I've written letters where a law enforcement agency busted the exception, busted the deadline, still claimed the law enforcement exception, and I've sent the letter and said, they've busted the deadline, send me my documents, and do you think I got it?
No, and they didn't take no
No.
position either.
No, they didn't give me that love. But again, as somebody has said, we've now coined the Nate Paul exception.
Well-
and we would all like that exception.
Miss Graham did not do what I was hoping she would do, which was ask, what was the substantial difference between the first submission and the second submission? Because he
Right.
kept using that phrase that there was a big difference. What was the big difference? Was that more papers were involved? There was a
did
cover
they put
letter,
did they put the
a seal
Yeah,
on it?
what was
I
the
mean,
difference?
what
Maybe it
was
was
the
different
difference?
letterhead.
It was different letterhead. Had the good letterhead and the bad letterhead.
All
A different
the
paper clip. That's the
mystery.
word I was looking for. Maybe it was a different
But
paper clip.
I
don't know.
just I
Letterhead
wanted to
conspiracy.
know what was the substantial difference between the packet they got the first time and the packet they got the second time, because he acted like that was of significance.
But Leah Graham was able to circle back for the prosecution, and when he said that they didn't take an opinion because they didn't want to affect the decision of the court, she was able to come back and say, well, doesn't not taking an opinion affect the decision of the court?
Yes.
And he said yes.
Yes.
Oh,
So
of course.
she was able to circle
we didn't
back
want
back.
to tilt the scales.
Yeah, no
Right.
decision is signaling also.
Right.
It's not meaningless to do that.
Well, yeah, and because they don't do that. They don't take no position on law enforcement exceptions. That doesn't happen. And so, what happened here was extraordinary. And even the witness, like he said, that he'd never been called to Paxton's office to discuss a request like this from DPS, so
But then there was no pressure on it.
but there's no pressure.
No pressure.
No pressure. No pressure. He didn't feel any pressure to do something different. I mean, that's just clearly, that doesn't make sense. That doesn't make sense.
No,
it
it doesn't make
It doesn't
sense.
stand up with logic. So, one thing we haven't talked about with regard to Allison Collins. So I did a story on.
She works for the state.
Yes. Yeah. Hey, Jay, do you have that story in the queue that you could play it?
About the AG,
Huh? Okay, Jay's going to load it up. It'll take a couple minutes, but so yeah, we did a story. The one about the 6. Yeah, you got it. Okay.
The AG.
Is it already in there,
employees.
or
I know which one.
he's gonna find it and play it for me? Yeah. So she's one of the 6 attorneys in the AG's office that took leave to go work for his defense, and I actually was pulling up my spreadsheet because during June and July she was paid a little shy of $11,000. That would have been her paid leave time. Now she wasn't paid to represent Ken Paxton, but she was paid that while working for Ken Paxton. And so you have, all these attorneys that work in the Attorney General's office that have taken leave, and every expert I talked to, talked about just how problematic this was from an ethical perspective.
Well, she works for the people of Texas, but this is her side gig today.
That's exactly right. And then I think there's, from a legal perspective, you don't ever want there to be a hint of impropriety or a question about your ethical obligations. And if you're taking money from your job, because she didn't have to. She could have said, I'm going to take an unpaid leave and I'm going to go do this, and I don't want to be paid during that time because I think that could be questionable. She could have done that. I mean, certainly we heard from the witness this week that sent all the money back, that they accidentally paid him.
Yep. So Jay has the story. Let's take a listen to it. At the Attorney General's office, they're some of Ken Paxton's staunchest defenders.
There's no court in America that would tolerate a process like this one.
General Litigation Chief Chris Hilton,
notwithstanding Section 1,
and his Solicitor General Judd Stone. In late May, Hilton and Stone both left the AG's office to join the defense team for their former boss, suspended AG Ken Paxton.
Chris Hilton.
But they didn't quit their old jobs Texans pay for. They took a temporary leave of absence. 4 other attorneys and an executive assistant also took temporary leave. You see, it's normally against internal ethics rules for a lawyer employed by the Office of the Attorney General to represent someone other than the state of Texas. But the man who briefly took over when Paxton was suspended, First Assistant Attorney General Brent Webster, waived those rules, writing, I authorize you to represent Attorney General Paxton in your individual capacity in all matters related to impeachment proceedings.
How do you waive an ethics rule?
Will Pryor served as First Assistant Attorney General under Dan Morales.
Something's either a violation of an ethics rule or it's not.
It's certainly an unusual circumstance.
Jim McCormick served as the State Bar's Chief Disciplinary Counsel.
I'm really struggling to try to figure out why this seems like such a workable arrangement for these lawyers, given their role day in and day out in representing the state of Texas and its taxpayers.
This is about ending the political theater and allowing the Attorney General to get back to the crucial work of fighting for Texans. Thank you.
And here's one fact to know. While they've been on leave, taxpayers have still been paying them. Records show in June and July, Texas taxpayers collectively paid almost $121,000 in paid leave to Hilton, Stone, and the others. Again, that's after they stopped doing their jobs at the AG's office and began defending Paxton against charges he abused his office and took bribes from a friend and political donor.
They shouldn't be paid by the public.
Chase Untermeyer is a former chairman of the Texas Ethics Commission.
They're certainly at liberty to defend him and to be compensated by private sources for defending him, but not on the public payroll.
So how did we get here?
We are beginning with breaking news.
On May 27th, the Texas House impeached Paxton. 3 days later, on May 30th, Stone, Hilton, and 4 other attorneys requested to take a leave of absence to work on Paxton's legal defense. Webster's response? This is approved. We dug through the AG's office employee manual. It says, except in limited circumstances, employees may not accept any employment for legal representation that is in addition to their official position, and employees are generally barred from accepting fees. It It also says employees shall not participate in any outside legal activities that could constitute a conflict of interest.
I mean, it does have state consequences, certainly, because he's an elected official, although suspended. You're essentially adverse to the Texas House of Representatives that brought these articles of impeachment.
But Webster wrote in a May 31st memo that he'd concluded their outside legal representation poses no conflict. He wrote that they were not precluded from accepting monetary compensation. The same day Webster wrote that memo, Hilton and Stone started their own law firm called Stone Hilton. That firm employs the other attorneys who took leave.
If someone else is funding this private law firm for these state attorneys to go work in, who are those people?
We reached out to the 6 lawyers on leave to ask, are you being paid by outside sources? If so, what are those outside sources? They have not responded to our questions.
I would encourage them to just resign. I don't know why they handled it this way.
Which brings us to the revolving door statute. That law prohibits former employees from representing or receiving compensation on matters they participated in while working for the state.
The process here has been completely lacking.
Before they went on leave, both Stone and Hilton helped defend Paxton against the claims that led to the impending impeachment trial. But experts say there's a loophole in the law. The law applies to former employees. And right now, Hilton and Stone aren't former employees. They're current employees on leave, defending Paxton.
They need to be one thing or the other. Either they are employees of the Attorney General's office or they are not employees of the Attorney General, in which case they're totally free.
In Dallas, I'm Tanya Iser. Yeah, so that was the story that we did that ran not long before the trial. And we never did, by the way, ever, not to this day, hear anything from them in terms of, have they been paid by outside sources during this time that they've been on temporary leave working on behalf of Ken Paxton. So,
well, if you're creating a law firm,
go ahead.
Something's funding it.
We'll see that on some campaign ethics reports. We'll see that someone paid Stone Hilton, and then we'll know. But we'll see that when the ethics reports are filed.
Well, I will say that the boss telling you something's okay for you to do does not get rid of your ethical duties under the State Bar of Texas and the Grievance Committee. I mean, the fact that he says it's okay doesn't make it okay.
Do you think it's okay?
I do not think it's okay.
And why not?
I think they should have resigned, started their law firm, and probably gotten whatever funding they were getting anyway and gone and defended him. And if he later on gets cleared and wants to hire them back, he can hire them back.
And it's important to say that Brent Webster was brought in after all this process started with the Attorney General under a cloud replacing some of the whistleblowers, and Brent Webster was brought in to grease the skids for all this to work in Paxton's favor.
Well, and part of the testimony we heard yesterday about Brent Webster is how, that was from Blake Brickman, discussing a number of the things that were in this report that Brent Webster wrote. I don't know who all he worked with to write it, that there were things in it that Brickman said were just not true. That wasn't the way it went down. And that's actually also one of the impeachment articles, I believe.
Well,
I don't remember which one, but
I would be curious to know if anyone has filed a grievance with the Grievance Committee of the State Bar against these lawyers for having a conflict of interest in this case. It'd be interesting to know.
What do you think
we
the
wouldn't
conflict
know.
of interest is?
Well, I mean, they're taking money from one side while they're on the opposite side.
Even if it's paid leave?
Yeah, just say I resign in protest, and I'm going to defend my former boss. And then when it's all over, if he wants to hire us all back, he can. Do it that way. Just cut the tie. Don't keep taking money.
They would say that this is a constitutional process and he's entitled to capable defense, and that this is not...
Busbee feels pretty capable.
Yeah.
Yeah, I don't think he really needs them, does he? Does Busbee really need all these people? I think he could probably done this whole thing on his own.
Well, and people are bringing up in the chat. We can't ignore this. One of the things that's been brought up is the number of the testimony from the whistleblowers is that they retained Johnny Sutton.
Johnny Sutton.
Who's a former U.S. attorney out of the Western District.
Right, and we don't know who's paying Johnny.
And we don't. Well, and we don't. And they don't have a written agreement with Johnny.
They say nobody, it hasn't been paid, hasn't billed them as far as we know yet. So.
And so, I mean, I think that's problematic too. I think that they, because that was one of the things that Victor was talking about. Yes, Victor Vital was talking about is, have you ever had a situation where you've been retained but you don't have a agreement about what you're going to be paid, or if it's going to be pro bono, or
Well, if you may. I was recently involved in a situation in Dallas County with an elected official where I believe that the work being done for that elected official was pro bono. I don't think that the people involved on her side were getting paid. I could be wrong about that, but I don't think that they were. So I think sometimes people take on, if you're an attorney and it's just like if you're a plumber, if you want to go fix someone's drain and not charge them, you can do that. You don't have to be paid. You could volunteer. I want to take up this crusade and represent these people.
Well, should it be secret who you're working for?
Well, if you're working for yourself, you're working for yourself.
Mm-hmm.
But if someone else is paying for the legal fees, I don't know if they're not public officials.
Right. So it's just that a lot has been made of when they've put some of the whistleblowers on the stand. Who is your attorney? Johnny Sutton. Do you know what you owe him? What's the agreement with Johnny Sutton? A lot's being made.
But is he their attorney? What does that mean? He's their attorney. Is he giving them advice as far as their concerns about being possible co-conspirators in some sort of crime, or is he representing the whistleblowers in their lawsuit where he might be getting a contingency fee?
Tanya, I want to make a point, and you may feel differently, but I want to give Lieutenant Governor Patrick some credit for the way he handled this, delicate balance of juggling between what the Attorney General's office claimed was legally released and what the prosecutors want to protect. Mm-hmm. I think that he listened, he looked at the details, he studied both documents carefully, and when he turned around and asked the defense lawyer, he said, "Do you, as an officer of the court, testify?" That is not something that an inexperienced judge in his 5th day on the job would even understand the concept that she's an officer of the court. And when he turned around and called on her using those words, I thought that showed that.
I hope she was right.
Yeah,
I hope so too.
I sure hope she's right.
That was exactly what he meant to say. Was that?
Well, because it's come back on you. Yeah. It's not going to come back on him.
Right? Are you lying to me? Because if you're lying to me, then
we have a problem.
Then we have a big problem.
So
but he called her out right there, and I thought it was Dan Patrick growing into the role.
No, I 100% agree. That was because there was a lot of confusion about what's in it, what's redacted, what's been released, which version was released.
So
it
that's
got
a
confusing.
shot of Johnny Sutton right there from earlier. It's not from, I don't know, Jay went and dug this up. But that's,
the mysterious Johnny Sutton.
Yes, the mysterious Johnny Sutton is right there. Jay, do you know what day that's from?
Yes.
He's going to look for us.
That's day 6. So
that's day 6, so a couple days ago, yes.
Busby pointed at him.
And Jay is our Eric and Stacy. So.
Jay is Eric and Stacy. There
That's
you
right.
go.
He's Eric and Stacy here at WFAA for us.
Very good.
and also Ryan. We also got Ryan back over there. We've got our Eric and Stacy as well.
Well, and I will point out though, if you're involved, if you're a witness in this case at all, if you, other than maybe the guy that worked from the bank, if you don't have a lawyer, you're crazy. You absolutely need a lawyer if you're involved in this whole giant
Even if
mess.
you're a lawyer?
Absolutely.
Maybe even more so.
Even more so. Because there's just so many implications and questions about what you might be getting in trouble for, and absolutely you need a lawyer.
Well, even Drew Wicker, we saw yesterday, got a lawyer early on, while he was still with the AG's office.
Absolutely, that's what I would have done.
Gave him advice about how to handle things and what to do, and it was another another part of his testimony that lent credibility.
If your spidey senses are going off that something is not right and you're in that position, you need a lawyer.
Yeah.
Well, and Drew Wicker, for folks that who maybe haven't been following every in and out of this, he was Ken Paxton's scheduler. He was his body man. He basically he accompanied him everywhere, made sure he had what he needed, if he needed a copy of the speech or whatever. He was like a personal assistant. He was a personal assistant to Ken Paxton.
And knew everything and saw everything.
And in fact, he said that they viewed him as like a son.
Yeah.
And he had nothing. He did not have any personal animus towards Ken Paxton. He
had almost a sweet attitude toward both.
Absolutely.
Is this the guy that was at the Omni and
Yes.
saw him in the elevator?
Yes.
Yeah.
See, I would have made a bigger deal out of that, because here's a guy that obviously a very conservative person. His parents came to visit him. He's got the job at the AG, who's supposed to be this really conservative attorney general. And I'm sure that the parents were really proud, and he was probably taking them around and showing them everything. And they're standing in that hotel, and what happens? The doors open, and there's the attorney general yakking it up with his alleged mistress.
His real estate agent.
Whatever she was. I was just imagining that moment. You're standing there, and here's these really conservative people, probably very Christian people. I can't remember which one of the backgrounds his was, except that he was a very conservative guy. And the door opens, and this is what you're met with. And it probably was a really deflating moment for him. But I also had questions about him meeting with the contractor at Ken Paxton's house to work out deals on the renovations. Was that during the workday? Was he getting paid by the taxpayers while he's bopping off to work with the?
It wasn't really addressed. And he
was that a Saturday, or was that a work
well, and
day?
at one point he said that there were things he did that he basically did for free. I mean,
or as part of the campaign.
Yeah.
I would only ask about the elevator. Which of the 16 articles of impeachment does that address? If you have him talk more about seeing them coming out of the elevator, what can you conclude from that, and which article of impeachment does that
I don't think it goes to the articles of impeachment, but just like we were talking about how Rusty Hardin might be hitting a certain tone with members of the Senate, that would hit. If I'm in the Senate and I'm an ultra-conservative, far-right person, I would be very interested in that.
So you just want to throw it out there?
Just want to throw it out there. Throw it out there. And it came out, but I just would have asked a little bit more questions. So you and your father are standing there in the door. I just wanted a little more detail.
You wanted to tell a story.
I wanted to tell a story, and there they are.
And then Tony Busby comes back and says, you have a man and a woman that came out of an elevator. What's the big deal about that? I mean, then that's what
we all know what the big deal about that was.
What's the big deal about that, and how often does that happen in Austin?
Well, as they say, there are no coincidences.
There are no coincidences in Austin. There's your closing argument for the AG side.
So they had said they were coming back at 11:05.
They're coming.
And they are now coming back in. There you see Dan Patrick and Lana Myers, and actually that man that just walked across the screen, that's Chris Hilton, who's one of the 6 attorneys that was the subject of that story we played just a couple minutes ago. So it looks like we're about to.
He was the vociferous defender of Ken Paxton.
Oh, he's about to do something. Look. He's up at the.
I think he's going to be
He's going to do something.
We're going to have another of our Attorney General's employees taking part in this.
And I can't say enough
Chris
about
Hilton was the defender when the House committee reported out the articles of impeachment to the House and voted. Chris Hilton rushed into the room, and he later claimed that he rushed in and tried to testify and was turned away. But actually, he just rushed in and started talking to the press and telling the press what a raw deal this was. He never tried to testify at all. I was standing right beside the Tribune and Morning News reporter.
Well, and he's also the one, we had it in my story, he was also the one that was, kind of led that press conference in, defending Ken Paxton. And, I talked to a number of experts about this whole revolving door statute, and had they actually, because Judge Stone, we haven't seen Judge Stone, but had Judge Stone and Chris Hilton, they had been already working on these matters in the AG's office, the whistleblower lawsuit and all these matters. There was a real question about had they quit the AG's office, actually quit.
Would they have been barred?
I think they would have. I mean, that was what the experts were saying, was that because they didn't quit, then they weren't subject to it, because that revolving door statute talks about former employees, and so it's definitely a loophole in the law. But if assuming Ken Paxton keeps his job, it feels like these employees that took leave to go help him, I mean, they're going to be like the cat's meow, right?
Of course, check and see where they are a few years down the road. But also, I have a question about if the other thing you have to worry about as an attorney is, are you a potential witness? And if you're a potential witness in any of these proceedings, then you can't be one of the lawyers. And
Well, that's
so
an interesting question because
so-
Chris Hilton and Judd Stone both worked on these matters, the whistleblower case.
But I mean, they could have been working on the whistleblower case in the AG's office because they were completely cut off from any of the allegations. But if they weren't, I mean, were they eighth floor people? Were they part of these meetings? Were they, if they have any fact knowledge, I mean, I would question whether or not they could be conflicted out.
Yeah, I don't know.
I don't know what their roles were before
that I don't know either. Like
the time all those people left in October and November of 2020.
Well, you asked what happens to them if he retains his job, and the answer is they're going to have to be running the office next week because Ken Paxton says he's going to Maine to be on Tucker Carlson, so somebody's going to have to be running the AG's office.
Well, you better watch out for the hurricane. It may be hitting Maine.
Which brings us to Donald Trump sent out a tweet, right? Bud? You're the political expert.
Well, I think we have the Donald Trump social media message today. This is the first time Donald Trump has directly addressed the case. His son, his cohorts, all of his allies have spoken up, and today, social media post, or last night actually, Ken Paxton was easily reelected. But now the establishment rhinos are trying to undo that election with a shameful impeachment. And he called Paxton one of the toughest and best, capital letters, attorney generals in the country. Could it be a Democrat, or even worse, a rhino? So that once again, the rhinos are all a suspect here. The voters have decided who they want. There are just all these accusations of rhinos. As watch as usual, the Republicans fight and eat away at each other. That is exactly what the House Republicans accuse the Paxton faction of doing, and the state Republican chairman, Matt Rinaldi, and the people of creating this division and fight in the state of Texas that's undermining the leaders, the Greg Abbotts, the John Cornyn's, the stable Republican leadership of Texas. Donald Trump says it's a sad day in this great state of Texas. Donald Trump's very popular in the state of Texas, but he has a short record of success as far as endorsements.
Expert testimony we were going to provide would not be
Here we
heard.
go.
I want to clarify for the record, for the jury, and for the public. At the end of the day yesterday, we had called Professor Michael Gerhardt, who's intended to be one of our expert witnesses. Last night, the court ruled that the expert testimony we were going to provide would not be heard. And so to the extent there was confusion, I just want to make the jurors aware and the public aware that that was the court's ruling, and that's why those witnesses aren't here.
And the court ruling was based on objection from the House under rule such and such.
Yeah, yes.
And we took about an hour to deliberate and look at all the questions.
That's right. I apologize for,
We ruled in favor of the House on that.
Just wanted the public to be aware, that's right.
And you were very kind to pull them from your witness list.
Thanks, sir.
Mr. Kinghorn, I believe I already swore you in the group. You may be seated. Speak loudly and closely to the mic. Thank you.
Austin, good morning. Thank you for being here. We both need to speak slowly and loudly into the microphone, I am told. You've testified in this chamber before the Senate, correct?
Yes, I have.
Okay, so you know the acoustics in here can get a bit weird, especially for our folks in the back.
That's correct.
So please just introduce yourself to the jury and tell us about your career.
My name is Austin Kinghorn. I'm the Associate Deputy Attorney General for Legal Counsel at the Office of the Attorney General. Would you like me to go back from the beginning?
Yeah, sure. Why don't, if you could please just start with law school, walk us through what you've done up to the present day.
So I graduated from Baylor Law School in 2010. After that, I did a clerkship on the 14th Court of Appeals for then Justice Jeff Brown. I did a stint in commercial litigation. Yes, sir. I did a stint in commercial litigation after that, primarily doing insurance defense. After that, I went to work for the AG's office in the Civil Medicaid Fraud Division. When Justice Brown was elevated to the Texas Supreme Court, I went to work for him again as a staff attorney. I worked at the court for about 6.5 years in that capacity for Justices Brown and later Justice Jane Bland. And then came back to the AG's office in the General Counsel Division. From there, I was promoted to General Counsel, and then most recently to the title that I hold now.
Thank you, sir. And tell us a little bit about your work for the Attorney General and your current roles, both as General Counsel, Opinions Committee, and your current title.
Right. So as the Associate Deputy for Legal Counsel, I'm over 2 divisions. It's a General Counsel Division and the Opinion Committee. In that role, I am both the Division Chief of General Counsel and General Counsel for the agency, and also Chair of the Opinion Committee.
How many employees do you oversee?
19.
And are you proud of your time at the Attorney General's office?
I am very proud.
I think this is a bit of a silly question, but it's come up a lot. Are you a rhino? Do you know what a rhino is?
Yes, I do. I've been called a lot of 4-letter words. That's not one of them.
What are your politics? Are you conservative?
Yes, I am.
Again, I think it's a silly question, but it's being asked. On a scale of 1 to 10, how conservative do you think you are?
11.
Fair enough. What I'd like to do today with you is go through these articles of impeachment, see if there's any perspective you can provide as to each. And I appreciate you being here helping explain the work of the agency for the jury. So let's start with Article 1, which relates to the Mitty Foundation and the intervention into that lawsuit. Were you directly involved in that lawsuit or that intervention in any way?
I was not.
Okay. But are you familiar with EAMs?
Yes, I am.
Unfortunately, we've talked a lot about EAMs during this trial. What's your understanding? What is an EAM to you?
An executive approval memorandum is a document that the agency relies on to seek and attain executive approval of various agency actions or engagements.
And do you receive EAMs as part of your work?
I do. I probably receive 1 or more a day.
What do you do if you have concerns about an EAM?
If I have concerns about an EAM, typically the practice is going to be to reach out to who circulated the EAM and, engage with that person directly, try to flesh out the issues. Sometimes it's simply a matter of correcting something in the EAM and recirculating it. So, the first step is always just get in touch with the folks who are asking for the executive action and connect and make sure you have an understanding of what's going on.
If you get an EAM that you're concerned about or you're proposed a course of action that you don't agree with, do you just go ahead and sign the EAM anyway?
No, I do not.
Okay. So what does signing the EAM signify?
That would signify that you have reviewed the EAM, you reviewed the legal authority in it, the explanation of the rationale for the action that's being sought, and that you approve of that action being taken.
So if someone at the Attorney General's office signs an EAM, does that mean they've approved that action?
That's correct.
What about, let me ask you this. Does the Attorney General have to have an EAM that's fully approved by his subordinates before he takes an action?
No, he does not.
Why not?
The Attorney General's authority and the First Assistance Authority flow directly from the Texas Constitution and from statutes, specifically Government Code Chapter 402. The EAM process exists to vet certain proposals, but it is ultimately not binding on the person or persons who actually possess the constitutional executive power to act as Attorney General or on behalf of the Office of the Attorney General.
So just to make that clear, the Attorney General has the legal authority to act without an EAM approved by his subordinates?
Absolutely.
Okay. Does that include the authority to sign a contract?
Yes, it would.
Let's look at an example of an EAM. Can we pull up House Exhibit 62, please, Mr. Arroyo? Your Honor, I believe this has already been admitted into evidence, and I'm going to try and go electronic today, so we'll see if it works. And Mr. Arroyo, if you could just zoom in on the signatures on the top of this EAM and maybe capture the subject line as well. Have you seen this EAM before, Mr. Kinghorn?
Yes, I have.
Okay. And which EAM is this?
This is a EAM requesting approval to intervene in the Mitty Foundation litigation.
You weren't a signatory on this EAM, correct?
No, I was not.
Okay. But let's look at the first signatory. That's Mary Henderson. Who is that?
Mary Henderson at the time was in our financial litigation division, and she held a senior attorney role in that division.
And what does her signature on this EAM indicate?
That would indicate that she has approved of the action described in this EAM, and it looks like she's the one who actually circulated this EAM.
Why do you say she's the one who circulated it?
It says from Mary Henderson, and also she's the first signatory. So typically the first signatory on the document, the lowest signatory would be the person who actually routed the document for approval.
So does this indicate that Mary Henderson and Kat Day actually authored this EAM? Is that what this says to you?
That's likely the case, yeah.
Do you know whether the Attorney General ever spoke with Mary Henderson or Kat Day about this EAM?
I do not know.
Okay. Who's next on the signature line? Who's Josh Godby?
Josh Godby at the time was the division chief for the financial litigation division.
And what does his signature here indicate?
That would also indicate approval of the action that the EAM is seeking.
And who's next up the chain on this EAM?
It's Darren McCarty.
What was his role at this time?
At the time, he was the Deputy Attorney General for Civil Litigation, so you'd see his name a lot on EAMs like this involving requested courses of action in active litigation.
And again, I want to be clear about what his signature means here. When he docu-signed this EAM, what does that indicate to you as General Counsel of the agency?
That indicates approval of the action that is sought by the EAM.
And same question with Mr. Mateer. What was his role and what does his signature here indicate to you?
Jeff Mateer was the first Assistant Attorney General at the time, and his signature would indicate approval of the action that EAM seeks.
And would it be your expectation that all of these people who signed this EAM have read it?
It would. I mean, that is certainly the point.
That's what you normally do within OAG, right?
Correct.
And would it be your expectation that they understood the memorandum before they signed it?
I would not sign an EAM that I did not
Objection,
fully
Your Honor.
understand.
Question calls for speculation.
I'll move on. Thank you, Mr. Roy.
Sustained. And
all right, let's move on to talking about Article 2. That's about the foreclosure guidance letter. It's been called a lot of things in this courtroom. That's what I'm going to call it. Do you understand what I'm referring to? Are you familiar with that letter?
I do understand and I am familiar with it.
Okay. Did you work on that guidance letter personally?
In a very limited capacity early on, I performed some very perfunctory research on it. I never participated in the drafting of the letter itself.
Okay. Who asked you to do that research?
Ryan Vassar.
And did you form a conclusion as to what was the ultimate outcome in your limited role?
As memory serves, I didn't form any firm conclusions at the time. I performed a couple hours, maybe 3 hours of research, and really just had enough time to kind of come up with some general parameters of what the issues were. And Mr. Vassar and I had a phone conversation about what we had found so far in our respective research. And he took it from there, and I never had another conversation with anyone else about the letter moving forward.
Did you see the letter once it was ultimately issued?
Only when it was issued, yeah, when it went up on the website.
Right, so to be clear, you weren't involved in the drafting process, so you don't know how they got from A to Z on that.
That's right.
Okay. But you saw the final letter.
I did.
Did you agree with the analysis and the conclusion in that letter?
I do.
Objection, Your Honor. Relevance.
Overruled.
And just as sitting there, as you sit there today, can you briefly explain what that letter does in your view?
Well,
or rather, let me rephrase. Can you explain the conclusion of the letter?
The legal conclusion?
Yes.
The legal conclusion essentially was that under the circumstances of COVID at the time, with 10-person restrictions on in-person gatherings, that there was a possibility that a public sale, as defined by statute, that necessary element to proceed on a foreclosure wouldn't be satisfied if you didn't have a situation where anyone who wanted to be a bidder on a property that was under foreclosure would have an opportunity to bid on it and thus get the most fair value for the property.
Let me make sure I understand each piece of that. So you mentioned the public sale issue. That's a requirement out of statute. Did I understand you?
That's right.
Okay. And you mentioned a bidder being excluded. Why would that be the case?
Sorry, could you repeat that?
I thought you mentioned the 10-person requirement might result in a bidder not being able to participate in a foreclosure sale. Why would that be the case?
Correct. So normally these sales are open to the public. Anyone who wants to go bid on a property can, and that of course has the effect of increasing the price typically. And the COVID restrictions are at the time, the governor's executive orders only permitted 10 people to gather at once in what was considering, I think the nomenclature was at the time, a public gathering.
So to make sure I understand what you're saying, if there were bidders that were excluded, that could drive the price down at the sale?
Yeah, that's certainly a possibility.
Okay. In your view, does that letter shut down foreclosure sales in the state of Texas?
I don't have an opinion on whether it did or didn't. I do know it was non-binding and informal legal guidance.
Did you work on any other COVID-related opinions or guidance documents?
I worked on a great number of them. During my first several months at the agency, starting in June of 2020, COVID-related work was the vast majority of what I was doing.
And if you could just briefly for a minute here, explain to the jury, explain to the public, we're trying to explain the work of the Office of the Attorney General today, so explain what it was like to be working on these issues during COVID.
It was intense. It was a demanding time, as I'm sure it was for a lot of people in this room. We were on the cutting edge of a lot of novel legal issues. A lot of folks were looking to the AG's office for guidance and direction on how to respond, how to navigate the challenges that were coming forward, especially as it pertained to the governor's executive orders, which were coming out. We were often looked to for guidance on how to comply with those, what they meant construing them, and we fielded those requests from all corners.
Was it unusual during that time to have expedited requests or to be working on short deadlines?
That is never unusual at the OAG, under any circumstances.
Particularly so during COVID?
Sure, particularly so. Everyone who came to us with a problem needed an answer and wanted an answer, at least quickly.
Understood. Let's talk about opinions and guidance documents from the Attorney General's office more broadly. What kinds of guidance can the Attorney General issue?
Well, there's a range of options. A lot of folks in this room are probably familiar with our formal legal opinions. Under Chapter 402 of the Government Code, a authorized statutory requester may request a formal legal opinion from the OAG, and that opinion, while non-binding, is a source of persuasive legal authority that courts typically will look to and consider when resolving a case. But we have other tools in our belt beyond that. Additionally, under Chapter...
Before we go to the next one, I just want to clarify one thing. You mentioned that a lot of folks in this room might be familiar with that formal legal opinion. Why would that be the case? Why would these senators and some of these House members be familiar with that?
Chairs of legislative committees, senators and House members, are authorized requesters under the statute.
Okay. Does the Attorney General's office work frequently with those authorized requesters regarding their requests for opinions?
We frequently work with members of the legislature on a host of issues and try to be as solicitous as possible in being helpful and giving the best legal guidance we can.
Okay. And I'm sorry I interrupted you. So that was the formal legal opinion process. You're moving on to the next category, so I apologize for interrupting.
Sure. So under Chapter 418 of the Government Code, which is the Texas Disaster Act, the AG's office has additional authority to provide legal counsel to local political subdivisions during a declared disaster. Authorized requesters include mayors, county judges, county commissioners, emergency management directors. Beyond that, the office has historically operated with the understanding that we have broad legal authority with the Attorney General as the chief legal officer of the state to issue informal guidance of public note, of public interest that would have a wide applicability to the public at large, especially in disaster situations where there's a need to get good information out to the public on pressing issues. And that authority, I think, flows directly from the Attorney General's constitutional and statutory authority as the Attorney General, as the chief legal officer of the state.
Other than the foreclosure guidance letter, can you recall any examples of other COVID-related guidance that was issued that also fell in that third category you described?
We put several guidance documents out on issues that a lot of folks are facing. Churches, private religious schools. I know that we did some opinions on access to vacation homes, and not opinions, letters on access to vacation homes in other states, where golf courses fell in terms of the governor's orders for shutdown purposes. So there were a lot of topics that we put something out there short of a formal opinion that was designed to provide generally applicable informal legal guidance to the public at large.
So it's fair to say, is it fair to say that the foreclosure letter was not unique in that regard? It was not the only informal guidance that was put out?
That's correct.
Let's look at a couple of other examples of guidance from this time. Mr. Arroyo, if you could pull up House Exhibit 105. And I believe this has already been admitted, Your Honor. Are you familiar with this document, Mr. Kinghorn?
Yes, I am.
And just very briefly, what is this document?
Objection, Mr. President. This document is not in evidence.
I apologize. I thought it had been admitted. It's House Manager's Exhibit 105, and I'd offer it if it hasn't been admitted.
We thought it was pre-admitted, Ms. Epley?
No, Mr. President, I don't believe so. We don't object. It's our document to begin with. I just wanted to make sure the record was clear.
Yeah, I apologize. I tried to get this smoothed out with counsel before we started, but yes, I offer it if it hasn't already been admitted.
Okay. It will now be admitted into evidence. That's exhibit, what's the number, 105?
House Exhibit 105, Your Honor.
Okay. Admit it to evidence.
Mr. Kinghorn, if you could, please just, if to the extent that you can, please just describe briefly what this document is.
This was a general guidance document that the agency issued to houses of worship during the COVID pandemic.
Is this a full-blown opinion under Chapter 402?
It is not.
And is this a disaster council letter under Chapter 418?
No, this is not.
Mr. Arroyo, if you could show us the bottom of the page, there's a date next to the exhibit stamp. And when was this letter issued?
It says April 27th of 2020.
Do you think it was any way improper for the agency to issue this guidance?
No, I do not. And in fact, I think this is the kind of guidance a lot of folks were looking to the Attorney General to provide.
Let's look at another example.
May I seek clarification? He was confirming that the guidance in regards to the house of worship exhibit 105 is not something he takes issue with, correct? Not the foreclosure letter itself?
Your Honor, she can cross-examine the witness.
No, I'm clarifying.
This is my examination,
Yes,
and she shouldn't be able to.
You can cross-examine on that.
Okay, thank you.
Thank you, Your Honor. Let's briefly look at House Exhibit 104 next. I also thought this one had been pre-admitted. Maybe I'm wrong. To the extent that it wasn't, I'd offer House Exhibit 104.
Thumbs up.
Great. Mr. Kinghorn, have you seen this letter? Or rather, are you familiar with this letter?
Yes, generally speaking, yes.
Okay. This is a letter in response to Chairman Frank.
Yes, this is the one about the golf courses. Okay, I had to read a little bit into it.
Okay, great. Let's look at the last page, please, Mr. Arroyo. If you could just zoom in on that text, please. So this letter, was this a full-blown Chapter 402 opinion?
No, it was not.
And how can you tell that?
It's got some language there caveating that it is not a formal opinion issued pursuant to section 402.042, which is our formal opinion statute.
It says on the letter that it is not a formal opinion under Chapter 402.
That's right.
So if someone were to say that this was a Chapter 402 opinion, they would be wrong. Do you agree?
I do.
Are you aware that the foreclosure guidance letter has substantially similar language in it?
Yes, I am aware of that.
Okay. And who was this letter signed by?
Ryan Vassar.
So Ryan Vassar signed an informal guidance letter.
Yes.
Does that indicate to you whether Mr. Vassar thought he had the authority to sign that letter? Do you think there was an issue with authority for issuing this letter?
I assume that he operated under authority to issue this letter on behalf of the agency.
Did you think a requester was necessary for the foreclosure letter?
No, I did not, personally.
Do you have any personal knowledge as to why one was sought?
I do not.
So you'd have no reason to disagree with me if I were to tell you that a requester was demanded because someone was trying to get out of doing the
Objection,
work.
Mr. President, I'm sorry. Counselors testifying to facts not known to this witness.
Sustained.
You can take that down, Mr. Royal. I think that's enough for Article 2. I think we're going to skip Articles 3 and 4 because I don't think you have any unique responsibility with regard to the PIA. Is that true?
I do not, that's right.
And we've heard plenty about the PIA today. But as an aside, does the Attorney General have the authority to access any case file or file in the agency?
Yes, I believe he does. He's the Attorney General.
Why does that give him the right to access any file he wants?
Well, I guess there's kind of an old saying in the legal profession that his name's on the wall. It's his agency, and he's the duly elected Attorney General. So it's his law firm. He gets to see a file if he wants to see it.
So if someone were to say that the Attorney General improperly accessed a file, would that make sense to you?
That would not compute to me.
Me neither. Can we pull up Article 4 briefly, Mr. Arroyo? Do you see the allegation here where it says Paxton improperly obtained access to information held by his office? Did I read that correctly?
Yes.
Let's go to Article 5 now. Take that down, Mr. Royal. Are you familiar with the contract with Brandon Kamek?
I am.
Okay. Did you have any involvement with hiring him?
I did not.
Did you have any involvement with drafting the contract or executing it or anything like that on the front end?
I did not.
Okay. When did your involvement with this particular contract begin? When did your familiarity with it begin?
Sometime later, after the contract had been terminated, I believe Mr. Kamek reached out to our office to inquire about payment on the contract for the outstanding invoices.
And when you say reached out to our office, does that mean he reached out to you as general counsel, someone in your division? Do you recall?
My best recollection is that it was a phone call to the general counsel division. I think he was looking for someone to talk to about it.
Do you remember a date for that phone call?
I don't.
Was that before or after you'd been promoted to general counsel?
I believe it was after.
Okay. And when were you promoted to general counsel?
During the month of November of 2020.
Okay. So sometime after your promotion in November 2020, Mr. Kamek called to inquire about payment on his contract. Is that your testimony? I just want to make sure I understand the timeline.
That's right.
Okay. You were made aware of this phone call. What did you do with that information?
I conferred with Leslie French, our chief of staff, on that, primarily because she had more awareness of these issues and what had been happening at the time. As I said before, I had no involvement with the contract. So she and I recall discussing it.
Objection, Mr. President. Question calls for hearsay, or he's about to get into hearsay at this point.
And let me clarify. Please don't.
Sustained.
Thank you. Of course, I agree. Please don't relay the contents of any conversation that you had with anyone else. Don't tell me what anyone said. Again, I'm just asking, once you became aware of this request for payment, what happened next? So you said you conferred with Leslie French. Please pick up there.
My best recollection on this is that at some point, a call was made to Mr. Kamek.
Objection. Anything he could state after that is going to be hearsay.
We don't know what he's going to state next, so I don't think that's true.
Overruled.
In that case, anything next is non-responsive. May he ask another question?
You can break it down into questions.
Did you reach out to Mr. Kamek?
Yes.
What was the purpose of reaching out to Mr. Kamek?
To follow up on his inquiry.
What did you want Mr. Kamek to know when you followed up with him?
Objection, Your Honor. Hearsay.
I didn't ask for what he said. I asked for what he wanted Mr. Kamek to know in response to his inquiry.
Overruled.
The purpose of the call was to inform Mr. Kamek of how he might proceed about processing his invoices under the contract.
And what were Mr. Kamek's options to get paid at that point?
There remained work within the scope of services that had not been satisfied before we could issue payment. Specifically, the preparation of a report of his findings hadn't been completed. So what I relayed to him, and I believe this was over a voicemail, was that we couldn't make payment on the contract until that commitment had been made.
If Mr. Kamek had sent you that memo that he had contracted to provide, what would you have done?
Subject to any other clerical reason that we might have to shore up, from my view, it was a payable invoice because it was a valid contract at the time that the services were performed.
Did you ever hear back from Mr. Kamek after you advised him that if he sent you the memo, he could get paid?
I did not.
Mr. Kamek never called you?
Not to my knowledge.
And again, when was this, to the best of your recollection?
My best recollection is it would have been sometime in November or later.
Let's go ahead and skip ahead to Article 7, just briefly. Are you aware of the Attorney General's Office internal report regarding the events underlying this impeachment proceeding?
Yes.
And broadly speaking, what is that report as you understand it?
That report is the findings of a 10-month investigation that was conducted internally at the Office of the Attorney General concerning the allegations that the whistleblowers raised.
Did you ever review that report?
I did.
How many times? What was the nature of your review?
No more than 3 times. I was provided a copy and asked for general feedback on the document, proposed edits, revisions, things along those lines.
Were you ever directed by anyone to make sure that the report was a sham?
No.
Were you ever directed to make sure it included false or misleading statements?
Absolutely not.
Are you aware of anyone else receiving such a direction?
Absolutely not.
What would you have done if you had identified a false or misleading statement in that report when you reviewed it?
If I had identified a false and misleading statement, I would have immediately raised that issue to the folks who are working on the report for consideration.
When was that report published?
That was August 24th, I believe, of 21.
And just to be clear, I'm looking at the text of Article 7 here. The allegation is Paxton directed employees of his office to conduct a sham investigation. Are you aware of that occurring?
I'm not aware that that occurred.
And you're one of the employees who, at least to some degree, worked on the report?
That's right.
Okay. The report was published in August 2021, you said?
That's right.
And it's been on has it been on the Attorney General's office website continuously since that time?
Yes, it has.
So, was that before or after November 8th, 2022, that this report was issued to the public?
After. Can you repeat the question?
Sorry.
I
Was
may
the
have misheard
report made public before or after the Attorney General's election on November 8th, 2022?
Oh, I'm sorry, before.
It's been on the Attorney General's office website continuously since then.
That's right.
Are you aware of whether there was reporting on the issuance of that report?
There's been extensive reporting on the issues that were discussed in that report.
When did that reporting begin, as far as you're aware?
That reporting began pretty much immediately when the whistleblowers reported General Paxton as law enforcement, and it's something we've been dealing with ever since.
And the OAG report also contains the details of those facts?
It does.
And that's been public?
Yes.
On the Attorney General's website?
Yes.
You can take that down, Mr. Roy. Let's move on to discussing Article 8 a little bit. Article 8 deals with the settlement of the Brickman versus Office of Attorney General litigation. Are you generally aware of that litigation and that settlement?
Yes, I am.
As part of the agreed settlement terms in that case, are there any contingencies that must be satisfied before the settlement is fully effective?
Well, the biggest contingency would be funding for the settlement itself. I think there may have been some non-monetary considerations as well, but I think maybe the one you're asking about is the contingency of the legislature funding the requested amount.
That is the one I'm asking about. Why is that legislative appropriation of funding contingency necessary for this settlement?
Like other state agencies, the Office of the Attorney General is prohibited in the General Appropriations Act from settling a case for more than $250,000 without seeking additional funds to do that.
Does state law set out a process for seeking funding for such a settlement?
It does.
Did the Office of the Attorney General follow that process?
Yes, we did.
Do you know whether funding was appropriated?
It has not been appropriated to the state.
Has the Office of the Attorney General paid out a single dime on this settlement?
It has not.
As far as you're aware, has a single dime of taxpayer money been spent funding that settlement?
It has not.
Who decides whether that will ever happen?
At this point, ultimately, the legislature will.
The House and the Senate?
Correct.
It's up to them whether to fund it.
That's right.
The Attorney General can't force them to do that, can he?
He can only ask.
Let's pull up Texas Government Code section 554.010. Your Honor, this is just a statute. I'm not offering it as an exhibit. It's going to be up on all of the screens. Mr. Arroyo, if you could zoom in on that. And I have paper copies for the witness and the court and opposing counsel, if that would be helpful.
Now this will work.
Are you familiar with this provision in the Whistleblower Act?
Yes, I am.
Can you explain in English what the statute means?
So this is essentially a reporting requirement. There's two parts to this. When you pay out on a settlement or judgment in a Whistleblower Act case, the agency is required to essentially put together a report on that case. And following that report, the state auditor's office may initiate an audit or an investigation of basically what went into what happened with the Whistleblower Act complaint. And if the SAO initiates that investigation, then they must follow up with a report to several entities on improvements that can be made, things that can be changed to prevent this from happening again.
So let's break that down. Let's go piece by piece. If the settlement is consummated, the Attorney General's office has to do what?
It has to put together a brief memorandum describing the facts and the disposition of the suit, and it has to provide that to the state auditor's office.
Okay. The Attorney General's office has to prepare a memorandum describing the lawsuit and send it to the state auditor's office. What happens after that? What does the state auditor's office do with it?
The state auditor's office will review the report, and not later than the 90th day after that report is submitted, the SAO has the option to investigate the governmental entity or conduct an audit.
Let's just pause right there. Mm-hmm. They have the option. Has the Attorney General's office been contacted by the state auditor's office regarding this provision in connection with the Brickman versus OAG matter?
Yes.
And what's your understanding of that contact from the state auditor's office regarding this statutory audit?
We were made aware of the existence of the statute, and they just wanted to bring it to our attention in light of the settlement road that we were on, to make sure that we were aware of this requirement.
The audit's coming.
That's right.
And under this statutory audit, who would have received the state auditor's report?
The Legislative Budget Board and the Legislative Audit Committee, and the governing board of the chief executive officer of the entity involved.
What would that report contain pursuant to the terms of the statute?
The SAO's report would include recommendation on changes that would be necessary to correct the problems that gave rise to the whistleblower suit.
Mr. Arroyo, could you pull up the text of Article 8, please? If I'm understanding your testimony correctly, the OAG's been notified of the statutory audit by the state auditor's office, and those findings and recommendations will be given to the legislature under the terms of the statute, correct?
That's right.
Are audits and cover-ups the same thing?
I'm sorry, could you repeat that?
Is an audit the same thing as a cover-up?
Did you say a cover-up?
A cover-up.
No, it is not. It's kind of the opposite.
If someone's trying to, conceal their wrongful acts, should they subject themselves to an audit, in your opinion, as general counsel of the Attorney General's office?
No.
Do you know whether the state auditor's office likes to conceal facts when it conducts an audit?
I do not believe that is the way they are wired.
I don't believe so either. And of course, we talked earlier, your testimony is that the allegations underlying the facts at issue in this impeachment have been reported since they happened. That's your understanding.
Correct.
You've seen reports in the media frequently about the goings on at the Attorney General's office.
That's right.
Texas Tribune seems to have a story every other day about the Attorney General's office, don't they?
There is a lot of coverage.
Do you have any personal knowledge of Ken Paxton ever forming an agreement with Nate Paul and accepting a bribe?
I have no personal knowledge of that.
And do you have personal knowledge of anything to do with Laura Olson?
I do not.
Okay. Do you have any personal knowledge of any vast criminal conspiracies involving misuse of OAG resources?
I have no such knowledge.
If there were such a conspiracy, would you still be working at the Attorney General's office?
No, I would not. I accepted promotion in this agency at a very critical time, and I assured myself and assured my wife if there were ever anything that I saw that were illegal or unethical, I would step away. And I'm still here. I'm proud of the work we do. I'm proud to serve General Paxton. I'm proud to be part of this agency.
Thank you, Austin. Pass the witness.
Ms. Epley, your witness.
Thank you, Mr. President. Hi, Mr. Kinghorn.
Good afternoon.
Have you and I spoken before?
We are old friends now.
That's right. Is it fair to say that you have been my contact to get documents from the Office of the Attorney General?
That's right.
And that our first conversation went well, but subsequent ones got a little chillier?
That's fair.
Now, we played respectfully with one another, right? No one was rude?
That's right.
Okay. Is it also accurate, though, that right after I would have private conversations with you as an officer of the Office of the Attorney General, particular details of our conversation would show up in Ken Paxton's filings?
Objection, Your Honor. Relevance, hearsay, has nothing to do with these proceedings.
Sustained.
Mr. President, I don't know that I've ever seen a lawyer open up a bigger door in regards to the credibility and bias of a particular witness, and I would ask for a little latitude.
Your Honor, this has nothing to do with credibility and bias. She's asking about litigation discovery. That has nothing to do with
I
this.
sustain the objection. Try your question a different way.
Did you receive pressure from Chris Hilton or Judd Stone to provide you information in regards to our conversations?
Not at all, and I can answer your question more pointedly.
I'm certain that he will do that, so I don't want to be rude, but I want to make sure we move forward. Did you receive pressure in coming without a conversation?
Not at all.
Did you receive directives in regards to what position you should take?
None.
So the fact that you and I would have a conversation and it would show up in their filing the next day is completely and totally made up.
Objection, Your Honor. This is totally improper. All parties, all witnesses were free to speak to both sides. That was in the Senate rules that were adopted. And it is only fair that people producing discovery talk to both sides. They certainly talked to people we were talking to. We talked to people they were talking to. That's how the entire litigation of this impeachment has gone. This is completely improper. Nothing improper happened here. And she's not only attacking the witness's character, but my character and my colleague's character. This is completely improper.
Sustained.
To clarify, then, maybe it was the subjective use of a word. As opposed to pressure, did you receive incoming communications that inquired about our conversations?
Objection, Your Honor. Same objection, and this is hearsay.
Sustained.
Okay. You talked some about MIDI. Is that correct?
About you?
About MIDI. Sorry, M-I-T-T-E.
MIDI, yes.
Yes, sir. Yes. You were not directly involved in that litigation?
I was not.
So mostly what you offered for us was the use of the EAM or people's signatures to validate a contract or an action, correct?
Objection, Your Honor. Mischaracterizes testimony. His testimony speaks for itself.
Sustained.
What is the purpose of the EAM?
The purpose of an EAM is to solicit and attain executive approval of an action that's being proposed to be taken or an engagement that's being proposed within the agency.
Thank you, Mr. Kinghorn. And when you personally sign an EAM, are you signing to say, I believe this is a good idea, we should proceed? Or are you signing to confer, as general counsel, there is legal authority?
You're asking about me personally?
Yes, sir.
And I would be signing generally as to legal authority.
Okay, so when Mr. Hilton asked you and you said you were giving approval, it means consistent with your job, that's an available option that we can justify, not this is my idea, I suggest we do it.
Objection, misstates testimony.
He can answer, Your Honor, if it's within his knowledge. Thank you.
I think that everyone's, depending on their role, their reasonings for going into their signatures a little different. For my role as general counsel, I'm primarily focused on whether the agency has the legal authority to take the action proposed.
And to draw an analogy then, Ryan Vassar, for example, signing Brandon Kamek's contract is approval that it's a legal justified position, not that it's the right one.
Objection, Your Honor. Assumes facts not in evidence with this witness.
Sustained.
But your approval is about legal authority, yes or no?
Yes.
Okay. I'm going to turn your attention for a moment to the PIA. Are you aware of incoming public information requests as to Ken Paxton's email, Signal, or Proton?
Typically, no. If a PIA request you're referring to is directed exclusively toward the Attorney General, that's probably not a request that would come across my desk.
I think I want to be more specific. Are you personally aware of any PIA requests ever for the text messages, Signal account, or Proton of Ken Paxton?
Objection, Your Honor. Relevance.
Overruled.
There's been a great number of PIC requests concerning the Attorney General's personal communication devices. I don't remember with specificity as to the specific types of communication you're referring to.
So you're telling the Senate you do not know if a PIA has ever been requested for his texts?
If you phrase it that way, then yes, I am aware that there have been PIA requests for his text.
Are you aware of PIA requests for his Proton email?
I'm not personally aware of them, or at least do not recollect.
Are you personally aware of PIA requests for his Signal?
I'm not personally aware or don't recollect at this point.
Are you personally aware that he has those accounts?
Again, objection, Your Honor, to the relevance of this. It has nothing to do with anything this witness has testified about. It has nothing to do with anything in his personal knowledge, and nothing to do with any of the articles of impeachment.
Overruled.
I do not have any personal knowledge on the use of a Signal account. In terms of, as I have reviewed the documents in terms of producing to you through subpoena requests, I have seen that there was a Proton email account that wasn't included, I believe.
Are you familiar with the fact that either the Proton or the Signal was set up by Office of the Attorney General IT staff?
I am not familiar with that.
Do you think that you should be if it's true?
Not necessarily.
Okay. Are you aware of the fact, either through a PIA request or the subpoena authority of this Senate, we were not provided any documentation related to Signal or to Proton email for business conducted on behalf of the state of Texas by Ken Paxton?
Objection, Your Honor. Lacks foundation, lacks personal knowledge. The witness has testified that this is not within his scope and that he doesn't know anything about any of these. This is an argumentative question with no foundation.
Sustained.
Did you personally respond to our discovery requests?
Yes, I did.
Did you personally have a conversation with me about Proton email?
Objection, Your Honor. Hearsay.
I don't know what to say to that, Your Honor. We're both here.
I'm going to overrule. You can answer the question.
Thank you.
Can you restate the question for me? I'm sorry.
Did you personally have a conversation with me about Ken Paxton's Proton email?
I do remember that conversation, yes.
Do you remember telling me that you knew it existed, but couldn't provide me any of those documents?
I did not say that.
You didn't tell me that you knew that there was a Proton email account, but you didn't know anything about it.
Objection, Your Honor. Asked and answered. She's attempting to impeach the witness with a conversation that she thinks she recollects. This is improper.
I'm certain I recollect it, if that helps.
Overruled. You did ask, he did answer, but overruled.
Okay, so let's try this one last time. Will you tell the ladies and gentlemen of the Senate if you provided us any Proton or Signal documentation for Ken Paxton?
Sorry, can you ask it a little bit more slowly, just the echoes?
That's fair. I speak quickly. Will you tell the ladies and gentlemen of the Senate whether you did or did not provide us any document in regards to Ken Paxton's Proton or Signal account?
We did not provide any documents related to a Proton or Signal account.
At one point during the questioning, I think what you had said was the Office of the Attorney General is Ken Paxton's law firm. Did I get that right?
Objection, misstates prior testimony.
It was in court today and a moment ago on the subject of Gross.
Overruled.
Thank you.
I've been analogizing, but yes, I did say that.
But of course, that kind of brings me to my next point. As a prosecutor, your job is to zealously advocate for your job is to seek a true and fair, I've forgotten my oath. As a defense attorney, your job is to zealously advocate. But as a civil attorney who works on behalf of the Office of the Attorney General, what is your oath? What are you supposed to do? What's the most important part of being a lawyer for the state of Texas?
Objection, Your Honor. Compound question.
Overruled.
I would say the most important part of my job as a public servant is to faithfully serve my principal and the people of Texas.
Do you believe your principal and the people of Texas to be different? Who do you think your client is, Mr. Kinghorn?
Who is my what?
Who is your client?
My client?
Yes.
Is the Attorney General.
Would you believe me if I told you that when you work for the Office of the Attorney General, you work under his authority and for him, but your client is and only ever is the state of Texas?
Objection, Your Honor. Argumentative, contains a legal conclusion.
Sustained.
Do you believe me when I say that, or do you agree with it now as you sit here?
Objection, Your Honor. Same.
Yeah, same question. Sustained.
You were asked questions about Brandon Kamek, and you relayed a conversation in which he'd called to find out about payment. Do you recall that?
I do.
And can you tell us what month and year that was?
Not with any greater specificity than what I indicated earlier.
I didn't hear you, so would you tell me again?
Sure. I believe it was after I was promoted general counsel, which would have been sometime during the month of November. But it wasn't necessarily during November. It could have been December. I don't remember exactly when it happened.
Okay. So Ryan Vassar was part of bringing you into the Office of the Attorney General, is that correct?
He was.
And Ryan Vassar was a friend of yours, correct?
Yes.
And is it fair to say that you liked and respected Ryan Vassar?
Yes.
And when he was summarily dismissed from the Office of the Attorney General, you rose to his position somewhere around November, correct?
Objection, Your Honor. Argumentative and assumes facts not in evidence before this witness. Moreover, I don't know what this line of questioning is intended to do other than improperly bolster the character of some witness who's not here. The door has not been open to that, so that aspect of this questioning is also improper.
Overruled.
I'm sorry, could you give me the question again?
Were you promoted after Ryan Vassar was fired?
Eventually,
yes or no?
Yes.
Thank you. And it was after that you had a conversation with Brandon Kamek, and Brandon Kamek is asking your office about payment because despite the fact that he's been employed since September, he's never been paid. Is that right?
That's right.
And as of November, there was no contract in place, right?
There was a valid contract.
Then why was he never paid?
At one time. By the time Mr. Kamek reached out, I believe the contract had been closed at that time. Just trying to be specific.
So what I'm asking you is, there's a secret, private contract signed only by Ken Paxton, not kept in the Office of the Attorney General at some point in this storyline, correct?
Objection, Your Honor. Argumentative, assumes facts not in evidence before this witness.
Sustained.
I don't know how else to do that. The defense's entire position is that Ken Paxton signed a contract with Brandon Kamek, correct?
Objection. This witness has been subject to the rule and doesn't necessarily, doesn't speak for the defense. It's the same question. It's argumentative. It's a sidebar. You've sustained the objection.
If I may, he was questioned at length in regards to the OAG report. Any person who's read it once or skimmed through knows that this is their position. It's not a violation of the rule. It's a question he opened.
Objection, argumentative, and lacks foundation. She hasn't laid that he knows anything about that aspect of the OAG report, and if she wants to ask that question, she can do it, but she has to lay the foundation for it and do it properly.
I'm happy to do that.
Dane, go ahead.
Did you read the Office of the Attorney General report?
I have read it, yes.
Okay, so on page 5, it reads, position taken by the Attorney General in this litigation was adverse to Nate Paul and in support of higher settlement amount to be paid by Nate Paul. Do you recall that being their position?
Objection, Your Honor. If she's reading from a document, I don't understand what it is, and I don't have it.
He's testified that he's read the Office of the Attorney General report.
I didn't understand.
He's been questioned in regards to its veracity. I intend to take him through a list of false and misleading statements to get his position and then challenge him with the testimony of the whistleblowers as allowed by the rules.
Objection overruled.
In regards to the Mitty Foundation, on page 5, it says the position taken by the Attorney General in this litigation was adverse to Nate Paul. You understand that's his being Ken Paxton's position, correct?
Objection, Your Honor. There's been no testimony about Ken Paxton's position, and there's no, are we talking about the report or are we talking about Ken Paxton? I'm still confused as to what we're doing here.
Sustained.
Is the Office of the Attorney General report in question published on the AG's website?
I'm sorry, say that again.
Is the Office of the Attorney General report published on the AG website?
Yes, it is.
And do you have to have either title status, meaning Ken Paxton, or the first assistant in order to publish it?
Yes, that's a fair statement.
And therefore, every statement put onto that website is adopted and made on behalf of Ken Paxton, correct?
I believe that the report is issued by the Office of the Attorney General. Whether that extrapolates to a legal position that Ken Paxton holds pursuant to this proceeding, I'm not going to go there.
So as an officer of the court and a government agent, you're not going to honestly say that anything published on the Office of the Attorney General website is the responsibility of Ken Paxton and something he should be held accountable for? That's your position?
Objection, Your Honor. Argumentative. She's demanding that this witness make a legal conclusion that he's justified, that he's just testified that he cannot make.
He is the general, thank you. Is your position that he cannot be held accountable for what he posts on the website?
My position is that I can't speak to the Attorney General's legal positions.
Isn't that your entire job duty?
Objection, Your Honor.
Let him answer. Let him finish his answer.
Thank you.
No, it is not. My job is to provide advice and counsel to my client, the Attorney General of Texas.
Okay. So if you had to choose between the state of Texas interest and Attorney General's interests, whose do you choose?
I do not see them in conflict.
Okay. Then back to this point. Do you or do you not, as attorney for Ken Paxton, think that he is held accountable for the items that he posts on his website?
I don't know what you mean by held accountable. That's a very vague question.
I'll help. Are you familiar with the Texas Rules of Evidence?
Somewhat. I am general counsel, not a litigator.
Do you understand what an admission by adoption is? Or an admission because it's made by a representative? Or an admission because it's made by an employee?
I'm aware of those rules.
Do you believe that those things would apply in appropriate context to Ken Paxton?
That's not something that I've researched specific to this proceeding. I don't have an answer for you on that.
I think we're all clear on you not wanting to answer this question, so I'll move along. I'm going to give you a series of statements then, and I would like for you and I to discuss them. This investigation revealed the OAG's intervention worked to the foundation's advantage on mediation. If I was telling you, or if that statement's about Mitty, and you have Ryan Bangert, Josh Godby, Darren McCarty, and Ray Chester all disagreeing with this statement, would even them disagreeing change your opinion as to it being valid?
Objection, Your Honor. Assumes facts not in evidence before this witness as to those other folks' positions. I don't have an objection to her questioning the witness about a document that I believe is in evidence, but I think in fairness he should be provided with a copy of it.
Sustained.
So earlier when Mr. Hilton asked you if you believed in the OAG report, you're not actually saying anything in it is true or not true, or that any of us should really entertain your opinion on it, right?
Objection, argumentative, misstates testimony.
Overruled.
Can you restate the question?
Your opinion on the Office of the Attorney General report being truthful is irrelevant to this proceeding because you will not address the statements within it. Is that accurate?
I don't agree with the question as you phrased it.
Okay. Then let's talk about the foreclosure letter. You went into great detail in regards to the distinctions. You relied on 418. Is it accurate to say that applies to mayors and local subdivisions, but not Senator Hughes?
That's correct.
And so Senator Hughes's authority or name wouldn't be necessary if that was the basis of that letter, correct?
I do not believe it was necessary. That's correct.
That's a different question. If the Attorney General was relying on 418, Senator Hughes's approval would not be necessary, correct?
If I understand yes, that's correct.
In regards to 402.042, that you do need an official requester for, correct?
That's right.
And if it was an informal guidance, then no requester is needed at all, correct?
That would be my position, personally.
So in regards to items 1 and 2, you wouldn't need to involve Senator Hughes at all, let alone use his name to put forth an opinion that he certainly would never have approved of, right?
Objection, assumes facts not in evidence. Moreover, she's stating a juror's opinion without following the rules.
Sustained.
Okay, last, in regards to your credibility and the Attorney General's reliance on you, is it fair to say that you represented him in a bar grievance relying on in a government filing or a court filing? And you took the position that the Attorney General was not subject to the bar rules or the state Texas ethics rules?
Objection, Your Honor, assumes facts not in evidence.
I'm asking him, he's on the stand, it was his position.
And you're characterizing that grievance and that litigation. You're mischaracterizing it. You haven't established that any of those things are true with this witness.
That's the purpose of the questioning.
Overruled.
Did you or did you not take the position that the Attorney General of the state of Texas is not beholden to state bar ethics rules?
Objection, relevance. That doesn't have anything to do with an article of impeachment.
Overruled.
Ms. Epley, I'm not sure which, can you be more specific about what complaint you're referring to? I don't have recollection when I sit here as to specific.
Does it feel appropriate to you that you would ever, for any reason, for any purpose, indicate that the Attorney General of the state of Texas was not beholden to bar ethics rules?
I don't think that's what we said at any point.
Pass the witness.
Mr. Kinghorn, do you know if any proton mail or signal documents that would be responsive to their subpoena exist?
I do not.
Did you conduct a diligent search for those documents on behalf of the Office of the Attorney General?
I conducted a diligent search of all documents that we had in our custody and control.
Do you have an obligation to produce documents that don't exist and that aren't in your possession, custody, or control?
I do not.
I have 1 moment, Your Honor. Pass the witness, Your Honor.
Ms. Epley, are you coming back?
No, I have no further questions for Mr. Kinghorn. Thank you.
May he be excused.
May we approach on a quick housekeeping matter? It's just the admission of some records I left at the podium, frankly.
May I excuse the witness? Yes.
That's fine with us, Your Honor.
Okay. Yes, you can approach.
Okay, so Deandra, your reaction?
Oh my gosh. Well, that guy, I wasn't impressed with him as a witness.
Why not?
That's the nicest thing I can say. Too much, I don't know, and you're the counsel that's giving advice to Ken Paxton, and all your answers are, I don't know. It's not even disputed that I can tell that there was this Proton account and whatever the other
Signal
account. And so he's just going to say, well, I don't know anything about it, but if I do know anything about it, I conducted a diligent effort to turn over items that were in our custody, when obviously if the Attorney General has those things, he's specifically taken them out of their custody. It was just a lot of double talk. I wasn't impressed with that guy.
And what about her question there at the end about the bar complaint, and have you ever taken that position? You seem like you were familiar with that.
I've heard that was the position they took. I haven't read it, but
she seemed pretty certain.
I came in here thinking that had been the case as well, because I remember it being a little bit of a hot topic at one point.
Well, and they didn't say, Chris Hilton didn't say, Aaron, you're lying. That's not the
No,
position.
he didn't.
He didn't say you misrepresented that position. He just said he just didn't want the guy to answer that question.
And I like how he's considered the guy who got him hired his friend and then took his job. He's a cool dude.
I'm very concerned about Austin Kinghorn. I'm very concerned that he's working for the people of Texas and apparently doesn't know who he works for.
Mm-hmm.
She very specifically asked about his oath. His oath is to represent the state of Texas and to see that justice is done. His oath is not to represent Ken Paxton. He said, if he used the phrase that he works for Ken Paxton's law firm, that is completely out of line. If he did say on the stand that he represents my principal and the people of Texas. His principal is an elected official. He works directly for the people of Texas. He does not work for any of the various elected officials who fill that seat. I'm probably as upset as I've been in any testimony at this trial that we have this employee who doesn't know what he's doing or who he works for.
Yeah, I was trying to go back to my notes.
I think he's about to break for lunch.
Because I did hear him say that he basically, it's his, I wrote this, he gets to see a file if he wants to see it. And so he phrased it as Ken Paxton's law firm.
It's his law firm. This is the defense's position, is that Ken Paxton is the king, and whatever Ken Paxton says and does is the law.
Members, we will take our lunch break now until 1:30.
Okay.
Yes, and there's a short meeting before that.
Okay, so they've gone on break. They've gone on lunch break. They've said they'll come back at 1:30. We've heard from two witnesses. We heard from Justin Gordon, who was over open records, and we heard from Austin Kinghorn, who's the deputy for legal counsel.
The first witness was a lot better. The second witness was not impressive.
Do you think they made any headway with the first witness?
Oh, I don't know. I mean, I would have crossed that guy a little bit harder, but the second guy, I don't think he was very credible at all. And I like to watch witnesses' micro expressions, and I noticed when they I can't remember the big guy's name, the guy
Chris Hilton.
Chris Hilton. When Chris Hilton said, "Do you have any personal knowledge of Laura Olson or something?" that he had a micro expression of no. Just not credible. It's not credible.
This has been, the first witness definitely at least presented the argument effectively. The second witness, Austin Kinghorn just, fell into this wide open giant crater that they opened up that everything Ken Paxton says must be right. And so he's defending it, and particularly when she started presenting this long statement. First of all, she set it up of who makes the statement, who must have authorized it, why is it posted, why is it on the website, and she led him into the crater that way, and certainly then he started saying he didn't know anything about this, and that he really couldn't address it, and just not sure he understood the question, and then as I was saying, for him to say that he doesn't remember his oath, for him to say that he works for Ken Paxton's law firm, or that that Ken Paxton that Ken Paxton is the principal. I mean, those are completely at odds with the oath he swore to uphold. He didn't know the oath. His oath is to represent the state of Texas and to see that justice is done. And and what he said is completely at odds with his oath for serving the people of Texas.
I agree with all of that.
It certainly was problematic. What'd you make of his explanation for why Brandon Kamek didn't get paid? Well, he just
I guess it was Brandon's fault. So I guess after the infamous
Brent Webster?
Starbucks,
Right.
the Starbucks meeting, when he almost had to walk back, he was supposed to go back to his law firm, write a report that he's already been told he's not getting paid for any of the work he's already done. He's supposed to do that and then send it in to this guy, Kinghorn.
Austin Kinghorn.
And then he's going to get paid. Just keep working, and someday we'll pay you. That's what he was told.
We'll gladly
that was
pay
funny,
you
actually.
Tuesday.
Yes,
Exactly.
that's exactly right.
Yeah, that was
Just
interesting.
keep working.
I think that this was a split for Ken Paxton today. I think that the first witness at least made the arguments. I don't think the second witness in this set of witnesses that's being presented by the defense, I don't think the second witness helped the defense at all, and pretty much crashed one of the cases that may be in favor of one of the 16 articles.
And please let Erin do all the cross.
Oh, she is
Please.
so good. She's
Please
so
let
good.
her do all the cross.
As far as I'm concerned, she is a great trial lawyer.
No, she's a
and
great
maybe
trial
we
lawyer.
have a new legend.
She's
Erin Epley.
She's fabulous. Mark Donnelly also. Had those two been doing the first few days, or a bulk of the first few days, we would be much further along. We'd probably be finished.
She's working the clock very well. Her sense of drama is very good, and she knows how to irritate the defense attorney.
Very much so.
Oh, and
very
she
much
made that
so.
comment about when they tried to say hearsay, and it was a conversation she was on, and she's like, I don't know what to say.
We're
to
both
that.
in the room.
Here.
That was good.
It was really good.
Yeah, Chris Hilton has been studying the Tony Busby School of Objections. So.
Well, and Chris Hilton is one of those 6 employees, those 6 attorneys that we showed the story earlier that took temporary leave. He is still an employee of the Attorney General's office on temporary leave, representing Ken Paxton. And so if Ken Paxton, well, no matter what happens to Ken Paxton, the plan would be that these employees, including Chris Hilton, would return to their jobs at the Attorney General's office. So, very interesting.
Very lucrative.
Well, and we don't know.
Very lucrative plan.
We do. It's very interesting. So, all right, guys. Well, we're going to take a lunch break. We'll come back about 1:15, and we will see what happens when we resume.
See you after lunch.
Bye.
Okay, thank you for joining us. I'm Tanya Iser, an investigative reporter here at Channel 8. We are back after having lunch and waiting for the Senate to restart proceedings and waiting to see if the defense will call more witnesses or will they rest. Deandra, if you were the defense, what would you do?
Rest.
Why would you rest?
I don't think I would call anyone else and risk them being able to poke some more holes in those witnesses. I don't think the last witness was, unless they have, I was telling you on a break, if they had a witness that was in any of the meetings with the former employees, I guess called the whistleblowers, that had some insight into those meetings, then that would be a helpful witness, but otherwise I don't think I would call anyone else.
But
I think that they probably have the 10 votes they need. I said at the start of this trial that I thought it would be a vote or two either way, and that I thought that he would not be removed. I think that the vote probably still stands where it started at the beginning of the trial. They had 6 to 8 votes on their opening motions. I think they probably have 3 or 4 more who said, well, they haven't completely proven this case. We can't overturn an election, something like that. I think they have the 10. If they have the 10, there's no reason to go on. You might lose one.
And Andrew, we were talking about over the break that the feeling that they needed the prosecution needed to do a better job of telling a narrative, telling a story.
Right. Yeah, they've had moments where I thought they were doing a very good job of that, and other moments where I thought the story was getting a little lost in the cross-examination or the direct examination. But that's one of the reasons I think closing argument is really going to be important in this case, because you've got to pull it all together. You've got to go through each article, and you've got to talk about what witness gave evidence on that, what your evidence, well, also documents and things like that, but what evidence you have to prove up that particular article, because they only have to sustain one. I'm with Bud. I'm going to be surprised if they get the votes to actually impeach him. I would be shocked. But if they do, I really think closing argument could be a big deal. It could really pull together all the reasons, and even if someone just thinks one of those articles was enough, that could make the difference.
And Bud, you thought before we actually got started that they wouldn't even get here.
Right. I thought it would be thrown out on the original motions because the Senate, of course, is overwhelmingly Republican, and not just Republican, but staunchly conservative Republican. Their loyalty is to Lieutenant Governor Patrick and what he wants and how he wants things to be done. Lieutenant Governor Patrick, although he's done a very presentable job as a judge in this trial, is politically aligned with Ken Paxton. His donors are the same as Ken Paxton's. He is the chairman of the state campaign for Donald Trump, who called this morning for keeping Ken Paxton in office. And so, I felt all along that the senators would please Dan Patrick, would do whatever Dan Patrick wants. I was a little surprised that they went ahead with the trial. And there were some senators on that who crossed over, including a couple who seemed to cross over on an integrity reason and say, well, we just can't let this go by. I think that some of those senators, especially if they think the prosecution didn't stitch it together, that the prosecution presented a lot of threads but never stitched them together, never actually showed where Paxton benefited, how anything changed hands, then I think that they'll probably will say, this is a lot of bad stuff, but we need to keep the guy that the voters elected.
Well, and I think we're going to find that out one way or the other probably pretty soon.
Probably tomorrow, maybe. I mean, it just depends on how many witnesses they may still call today, if any, and if we get to closing arguments. I do think it's worth, noting that this isn't the end. I mean, Paxton is still under indictment, and that case may start rolling, this fall, allegedly. We'll see. I don't know what's going to happen with it. But he is still under indictment, and there could be investigations we don't know about because they're secret.
Well, there is an FBI investigation.
Right.
There is a grand jury investigation related to all this Nate Paul stuff. We know that because there was already reporting on that, but there's also been testimony about it.
So we don't know where that's going, and I also think that it damages Paxton regardless of what happens, because a lot of the things that were not put out before the election are now out there. I think the electorate will be a lot more, assuming he runs for re-election, if he's not impeached, is going to be a lot more knowledgeable. There's going to be a lot more to work with for people potentially running against him.
I'm going to disagree with that. He's built up a tremendous amount of statewide and national name ID now. He'll say I've been vindicated, and there's no reason for my enemies, the rhinos, to challenge me in court, and this was all a sham, and that I think that he will say all those things and be able to make his cross-country TV tour.
Well, unless he gets convicted and is serving some time during the next election. So.
That would have to be on the federal level, probably.
Yeah.
As we mentioned, the state charge, although there's evidence to uphold it, the state charge on securities is a little shaky because it hasn't been prosecuted before.
But a lot of the reason I think it hasn't been prosecuted has got to do with COVID, and then also there were challenges with the special prosecutors that were brought on board. There's just been a lot of things.
Well, the charge you're referring to that hasn't been prosecuted was the third-degree felony.
Oh, yes,
There's
that
still
one.
2 first degrees.
Yes. There's just, there's a lot of other things going on, but I think that they ultimately will be prosecuted.
And of course, he would continue to serve, if he were, he would continue to serve from, wherever the court sends him on those cases. So he'd continue to be the Attorney General.
If he's convicted, he continues to be the AG?
I believe that's right. I don't know that for sure.
I mean, I guess they could still go back through this process.
Yes.
Assuming, well, we don't, of course, that case we're referring to is the two that he was indicted in 2015 on 2 first-degree felony counts of securities fraud, and then also a failure to register charge, which was a third-degree felony. And that's been batted around between Collin County and Harris County for the last 8 years. It made its way up to the Texas Supreme Court, and the Texas Supreme Court ruled that it would stay in Harris County, and that case, by all, from what we can tell, looks like it's going to proceed.
And that was fairly recently, wasn't it?
Right, that was pretty recent, yeah.
But those remain open articles of impeachment. They were put in abeyance in
That's
this
true,
trial,
there
but
were
there's 4 of them articles of impeachment. This is something interesting that's going to have to happen at the end of this trial. They're going to have to decide whether to withdraw those articles of impeachment or not, or the House might have to vote again to drop those or to withdraw those articles of impeachment.
Why did they put those in abeyance?
They put those in abeyance because they're in court. And Lieutenant Governor Patrick and Senator Birdwell, the people in the committee said, let's see what happens on these other articles, and then we can talk about these that are already in court. But of course, he would remain suspended from office because these articles are still in effect if the House does not vote to overturn these articles.
But if he gets convicted of a felony and loses his law license,
he doesn't have to be a lawyer to be AG.
Then I think I'm just walking through the process
you're thinking like a lawyer and not like a politician.
Of whether he would have to resign or not.
You're thinking like.
Yeah, he doesn't have to be a lawyer. I don't think he doesn't need a license.
This is not a court of law. We're not.
Oh no, it most certainly is not a court of law.
Here, so.
Not a court of law.
Okay, so Jay is going to play for us the clip of Brandon Kamek describing how he ultimately is not going to get paid.
I thought we were going to meet to talk about the contract and what is going on, and but instead, they were like, well, let's not meet here in the office, and they walked me over to a Starbucks outside of the office to have a meeting.
Did you ask why?
No, but it was uncomfortable. It was not professional to me at all. At that meeting, Mr. Webster did all the talking and told me, well, in fact, your contract is not any good anymore. Stop working, don't do anything at all. I asked him, okay, well, what about, paying me?
Do you recall exactly how you put it about whether you were going to get paid? Did you put the amount in there?
I think I ballparked it, and I said, what about my $14,000 invoice? And he's like, well, you're going to have to eat that invoice. I've had to eat $40,000 invoices.
Webster said he had eaten a $40,000.
That sticks out in my mind, sir.
Yeah.
Yes, sir.
Why does that stick out in your mind?
Just because it was offensive. They left the Starbucks and tried to get in the car and drive off. I said, "Excuse me, can I get a ride back to my car?"
So these guys take you to, are you saying that these guys took you over to a Starbucks outside the office, terminated your contract, told you weren't going to get paid, and then drove off? And if you hadn't said, wait, I got my car, they'd have left you in the street?
That's what it looked like.
Royce West is laughing.
Oh my.
If they take you to the Starbucks.
Oh my gosh, don't go to the
If
Starbucks.
they take you to the Starbucks, tell you they're not paying you back what they owe you, and ditch you, what do you do?
I don't think you finished the report for Mr. What was his name?
Oh, we're gonna have to. Well,
Kinghorn.
Okay, so Austin. So we're gonna have to just talk about what Austin Kinghorn said. It was technologically kind of too difficult to pair the two up on this. But anyway, basically, Austin Kinghorn, who is the head of legal counsel, is asked about, well, why, he's asked on direct, why doesn't Brandon Kammack get paid? And he says that he doesn't get paid because he didn't do the report, right? I mean, and if he'd done the report, he gets paid.
He could ask again and he'd get paid.
So
it's terrible, but it just is it was one of the more interesting parts of these last few days.
How do you match up that testimony?
You don't. I mean, first of all, if you're being told you're going to eat $14,000 invoice, too bad, so sad, and going to be left at a Starbucks, you're not going to turn around and write a report and do more work. And they told him you're not going to get paid and your contract's over. It doesn't. No, I don't buy that story, the Kinghorn story.
I mean, is Kinghorn, in your mind, is Kinghorn just testifying to what he knows about?
It's very possible. It's very possible that he actually didn't know and picked all this up and was handed to him, and he didn't actually know what the background was.
Because he wasn't involved in the drafting of the contract.
He didn't know.
We know when Kammack testified, he said Brent Webster was at the Starbucks.
Right.
Ken Paxton and a couple of people that he did not recognize. So we don't know who those other people are, but we have nothing to indicate that it is Austin Kinghorn.
No, I don't think it was probably Austin
I don't think
Kinghorn.
it was either at this Starbucks meeting, but that seems to be the defense's attempt to explain why Brandon Kammack didn't get paid.
Well, and I think though if Kinghorn had this conversation with Kammack on the phone, I'm sure Kammack would have most likely said, "Hey, I already talked to these guys about this and they told me not to do any more work and they weren't going to pay me." I mean, I think he would have said something back and not just been like, "Okay, nice talking to you." I just don't think that just doesn't ring true.
Do you think that the prosecution should have asked him about that? Because once you've opened the door, you opened the door to hearsay to begin with, right?
Yeah.
Mm-hmm.
Probably should have asked some more questions about that.
Because once the defense is asked about that conversation, and nobody's claimed hearsay, because that would have been, if they'd have made the objection, that would have been hearsay, right?
Correct.
So they didn't make the objection.
Mm-hmm.
So a potential logical question for them to ask, Aaron Epley to ask, would have been, okay, so did he talk about his meeting with Brent Webster?
Or she could have asked him, Kinghorn, hey, what did Paxton tell you about this Kammack invoice? What conversations did you have with him about paying this, not paying this? I mean, what were you told? I don't think anybody asked him.
No, they didn't. And I don't know if it's because of the timelines that we've got, the timeline situation we've got.
I think that is playing a role.
Because they're trying to keep the cross-examinations pretty tight.
Right. Because they don't know how many witnesses
they only had
the defense
2
is going to
hours
call.
left. So.
Yeah, and they're going to try to just hit some key points and sit down, because if they call a whole bunch of witnesses, they just get a little bit of time for cross on each one.
If the defense tries to unfold the vast Rhino conspiracy,
and you don't want to be in a situation where you can't ask a question.
Correct. You run out of time, you don't get to do any cross, and so you don't. That's why this is this whole thing is so odd, because in a criminal trial this wouldn't happen. It's just these rules for this particular proceeding, but this isn't the way a criminal trial
Well, and
proceed.
that's still
in a million ways.
That's still where and I think all the legal experts have agreed on this, is one of the failures of the prosecution team has been to better manage their time in the beginning of this trial.
Absolutely. You needed a lot more efficient, direct,
and a better narrative.
A little bit of a better storytelling. And then apparently I'm getting messages from an attorney in my office that's telling me that if AG Paxton is convicted of a felony, he can't run for re-election unless pardoned, and they're looking to see if he would be removed.
Oh, so they're doing some research.
They're doing a little research.
Legal research. We got them doing some work over there.
That's right. He wouldn't be able to run unless he's pardoned.
And apparently there is actually an AG opinion on this from Paxton.
Right, from Paxton.
So, ironically enough.
So they're going to go look for it. And we also heard from Justin Gordon, the open records guy. What did you think about his testimony, Deandra?
He came across, I thought, fine. I felt like I would have asked some more questions because who was the guy that directly supervised Justin Gordon, who was one of the whistleblowers that testified?
I think it was Godby.
Okay.
Isn't that Josh? I think it's Godby. I'm thinking out loud. I'm thinking in my head.
No, there's not a Godby.
Well, it doesn't sound like Justin Gordon was involved in a lot of these meetings that we heard about the first few days. So I know he had the one meeting with Paxton, which is the only time that's ever happened.
About a DPS request.
Yes, about a DPS request. But it's very likely that Justin Gordon was compartmentalized and didn't know. So not that he's like being a dishonest person or anything, that he is telling you exactly what he knows because he wasn't part of these other meetings that we heard about previously, assuming that those are all true.
He was covering details of, what the DPS did wrong, what this agency, what that agency did wrong, and why this was public. And then we got to the whole kerfuffle over this shouldn't have been public. Are we able to testify about it now? We got into that.
Well, and you were saying, Deandra, that you felt like if they're going to call more witnesses, that you'd want to call witnesses that were present during these meetings to say, no, these whistleblowers, they're all lying. Or something to that effect.
Or I was in the meeting too, and that wasn't the impression I left with, or that's not what I remember happening, or something along those lines. But one thing that I seem to notice, because I did watch all of this because I knew I was going to be here today, so I felt like I needed to watch the whole trial. It seemed like Paxton compartmentalized a lot of things. There were a lot of, like, he'd go to this person and say, hey, I need you to do this. And he'd go to this person, hey, I need you to do this. Hey, and not everyone knew what everyone else was doing until they did, until they all came together and started comparing and had that meeting, and then they started realizing what their concerns ultimately were. So if he's doing this compartmentalization, need to know basis type thing, then Justin Gordon his story would fit right in with that.
And same with Austin Kinghorn.
Oh yeah, actually him too. Yeah.
They know what they know.
And that's all they know.
And they discussed a lot about this long brief that was posted on the Attorney General's website, and who wrote it and who's responsible for it and what was true and not true in it. And Justin went through all these things that he tried to validate it, and then Austin Kinghorn couldn't validate things that he claimed he could validate. And so we went into this long discussion of basically the long defense of the Attorney General that was posted on the website.
And that was one of the sticking points with the settlement, wasn't it? Was the
Right.
statement?
Well,
they insisted it to be removed.
There was a statement that was put out that called them rogue employees, and it was pretty strident. And so one of the terms of the settlement agreement was that statement be taken down. And there was a couple other things. And also that Blake Brickman testified yesterday that he wanted that, and then he wanted also that they not appeal that I think it was the Third Court of Appeals that had basically said that an elected public official was subject to the Whistleblower Act, because part of what Paxton had contended was that as an elected official, he was not subject to the Whistleblower Act, and
Right.
he said that he wanted to ensure that for future whistleblowers, that a public official could not make that claim.
Which delayed the case for.
Right, and he said it stopped discovery, which is part of the argument that Paxton's side has made is, well, the voters knew everything, and what Brickman was saying, well, they didn't know everything because discovery got stopped.
Well, and they didn't. I mean,
I've learned things in this trial.
I've learned lots of things in this trial that I didn't know, and I tend to try to keep up, but I didn't know a lot of this. I had many moments where I was like, wow, that's unusual. The whole serving the subpoenas with Kamek.
You mean the attorney for Nate Paul going?
Nate Paul, yes, that was just a lot, and the whole secret squirrel nature of Kamek being brought on, but he didn't have any way to communicate with the office except through apps and alternative methods of communication. I mean, just all of that was just a little. I didn't know any of that.
But what's wrong with the attorney for Nate Paul going along to do the subpoenas?
Well, there's definitely a conflict of interest. Plus, what is he? If you bring an attorney on to conduct an investigation, which is allegedly what was going on here, then he needs to conduct the investigation, not have an interested attorney on the other side walking hand in hand with you and leading you down
and showing
the path,
you how to fill out a subpoena.
And showing you how to fill out a subpoena.
And providing you
that.
lists of who you should subpoena. And then you subpoena those people. And Kamek acknowledged on the stand that, like, he didn't know, for example, Ray Chester was the attorney for the Mitty Foundation.
Yeah. He just got a list, apparently, and started issuing subpoenas once he figured out how to do it.
That's
very unusual.
And I've dealt with people who were special prosecutors or in those types of roles, and that's what Kamek described to me is just very unusual. In terms
the
of
Texas Constitution is silent as to removal. Just FYI, on the AG convicted of a felony.
Interesting.
He'd have to be impeached again.
Yeah, and I know there's nothing in the Constitution about it. The only way you remove someone is through impeachment.
Oh.
So potentially you could
do this all again.
And then that gets in question. I mean, double jeopardy, does it apply here, not apply here? This isn't a court. This is under the Constitution. Theoretically, you could bring a lot of this evidence back into court because there's no double jeopardy prohibition in the Constitution, but that would be something that would be argued.
So let's talk about, while we're waiting, let's talk some more about the events of yesterday. Okay. We had Drew Wicker. Well, we had the beginning of yesterday when the prosecution announced that they were going to call Laura Olson, and then suddenly that didn't happen. Initially, because they had not met this 24-hour clock. How much of a mistake was that, Deandra, on the part of the prosecution?
I don't understand. I didn't read the rules that they created for this particular hearing
in detail. You had to give 24-hour notice.
But I don't know why they wouldn't have just listed all of their witnesses at the beginning. And that's what happens for the state in a criminal case. You have to tell all the witnesses you might call. So I don't know why they didn't just do that, unless they just made this last-minute decision to call her, which seems kind of far-fetched to me. I mean, or they were trying to do a surprise, or that didn't. And I think it backfired, because had they given notice, proper notice, then maybe she would have ended up on the witness stand. I don't know.
You think there was too much of a lag time there?
Possibly. I mean, I think a lot of things were probably going on yesterday while she was waiting to testify, because she was there. We saw her. There's video playing. She was walking in to get on this witness stand.
I wonder if they had to submit a list of who's going to be called each day. Then because they were running short on time, they went ahead and called her, and she wasn't on the list for that day, so they had to wait.
Well, and I think these time constraints have played a big role in a lot of what we're seeing here. But again, early in the trial, we spent an enormous amount of time with Mateer and Banger.
We did.
And
not very effective time.
No.
No, a lot of it was them telling their story, but just more of their story than probably needed to be told. I don't know how to say that.
Well, and then
that's
you
not
had-
exactly the way I wanted it to come out, but
Well, and then like I had a point along the way, I think it was Tuesday when we had Darren McCarty at the end of the day, and I frankly just, I felt like I'd heard all this before, and it was hard to even pay attention.
We're all thinking that the defense didn't really do as good a job as it could have. There are 31 senators sitting there thinking that too. Now
mean
we're
the prosecution?
And now we're just in the beginning to hear what the defense has to say. And so we'll hear, certainly these have been some pretty bureaucratic first couple of witnesses, but we'll see whether the defense has any more big bombastic witnesses to bring forth.
Well, and certainly the defense pretty effectively used the objections to break narrative.
oh yes, and that is, I know you've had attorneys this whole week telling you that's a common thing. Another thing that I don't think anyone's actually mentioned is the fact that there's a difference between doing direct examination on a witness and doing cross-examination on a witness. And you have defense attorneys acting as prosecutors who are accustomed to always doing cross-examination, and they rarely probably do direct examination. And when you have to switch that role, that's when you started getting all the leading objections, because they were in fact leading. There was a lot of leading, which is fine on cross-examination, but it's not okay on direct. And so it can't just be a prosecutor, be a defense attorney and go back and forth. There's different ways you have to do it, and I think it was a little harder for the defense counsel acting as prosecutors to do
even
direct.
for Erin Epley when she was challenging Austin Cleghorn on what's his oath, but then she turned around and said, "What's my oath again?" Yeah, let's say I know the defense attorney's oath. What's the prosecutor's oath? And so
Right.
she had to remember.
She was a former federal prosecutor.
Yeah.
I did look her up. So.
And by the way, I did look up the oath. The oath that Austin Kinghorn was supposed to remember is that he swears to represent the state of Texas and to see that justice is done.
How do you think he?
It doesn't say anything in there about working for Ken Paxton. So, he seemed to be unclear about who he worked for. He said several times that he worked for Ken Paxton, or that Ken Paxton is who ran the office, and he worked for Ken Paxton, and this is the confusion we have now in a lot of government is that people have a loyalty to the official and not to the people they serve.
You have to swear an oath. I mean, when you get sworn in as a prosecutor, and I'm assuming at the Attorney General's office is the same, you literally raise your hand and swear an oath, and you swear to that. There's a statement you have to make as part of being sworn in as a prosecutor.
I mean, presumably you're hired and you're going to stay there through several attorneys general. So it shouldn't matter who the personality is who's holding the office. The defense is making the counter argument. The defense is arguing that because the voters elected Ken Paxton, that Ken Paxton can do whatever he wants. And they're actually taking umbrage at anybody who challenges that. They're taking umbrage at the idea that, how dare you challenge something that Ken Paxton said he was elected.
And I don't think it's a political thing to say that we expect our public officials to adhere to certain standards. I just don't view that as political. I think that it is important that we demand accountability regardless of who that public official is. Deandra, we go way back, right? You would say I'm a pretty equal opportunity offender regardless of party, right?
Yeah, there's been...
I think I've probably been
interviewed me on both parties.
Yes, I mean I am quite. I don't care.
Yeah.
What your political party is. I don't care what your ideology is.
Are you a rhino?
Rhino.
Look, I just don't. For me, when I'm working on stories, I don't look at it and say, oh, they're this or they're that, therefore I can't do it. It's always about what is right, what is wrong. What is accountability? There was once a Democratic DA in Dallas County that about 10 years ago did a whole bunch of stories on that had to do with misuse of forfeiture funds, and then there was a Republican DA after that who also I did a number of stories about issues with her. So
some of them with me.
Yes, and then we've had judges, and again, so I think that you know, in my job and my role is I don't care about your party. And with Ken Paxton, whether or not what the outcome should be, I take no position on that. But the conduct that's been described here, it's problematic. And I, to a person, I don't hear anybody that understands the way that the criminal justice system operates and the way that the Attorney General's office operates or should operate that says that a lot of what we heard in this trial is normal.
Well, and the way elected
and okay.
The way elected office operates, if if Representative Villalba were here, he would remember this. He could speak to it better than I can, but you know, he would talk about that. You know, when you're elected, you serve a sacred trust.
Right.
You serve in sacred trust, granted by the people, and you serve the people. And that if you serve yourself, then you should no longer be in office.
So there's a live look. You can see there's Chris
Weren't we
Hilton.
supposed to start at 1:30? Yes. But they don't even look like. I mean,
no.
I wonder if something's going on.
Well, this is why we have sort of this debate on what time we start the chat back up, is because, or you know, chatting like this, because we never know. They say they'll start back at a certain time, and then they don't. But that sounds like a lot like a trial, Deandra.
They're waiting for a ride back from the Starbucks. The jurors are all.
I will never forget that.
The Starbucks moment is kind of a classic moment.
So we have, we have the Polvos, the Galaxy Cafe, and the Starbucks seem to have all been.
Could take
and
the Paxton tour.
Terry Black's barbecue.
Yeah, I could take the Paxton
Yeah,
tour.
the Ken Paxton impeachment tour would be a good adventure. You'd have the Omni elevator. They should have asked him, was that elevator number 1, 2, or 3?
Oh my God.
So that you would just see how many details he remembers.
Well, one thing that I don't think you've addressed in the past 7 or 8 days is. About the whistleblowers in particular. You know, in this day and age, especially since I think all of them were attorneys, except the one guy was a police officer, I think.
David Maxwell.
Right.
David Maxwell was a former Texas Ranger.
Hall of Fame.
Very, very, very
I remember his testimony. But I just, in this day and age especially, if the federal agents come after somebody, they come after everybody. They come after anybody even in any way attached to whatever it is they're investigating. So I know that if I put myself in the position of those folks and I thought that all these things were going on, I would have been very nervous too. I would have been very concerned because I think that there's been some question about why did they go to the FBI. I know that was a big questioning that went on in the beginning with Busby and about why didn't you just go talk to Mr. Paxton about it. Well, you know, when they come after you, they come after everybody. And I think they were all concerned that they didn't want to be co-conspirators.
Well, one of them said that. I can't remember
that
which one that was.
That is a legitimate fear.
One of them said that, and
one of them did use that term.
It was one. I can't remember who it was. I don't think it was Banger. It wasn't Mateer because he was first, but it was definitely. Might have been Vassar, but my memory escapes me on which one it was. But yeah, they definitely expressed that concern. One of them expressed that specific, actually said that on the stand, that they were worried that they would be viewed as co-conspirators. And it's and based on all the testimony, it's pretty clear that it wasn't one thing. You know, I think they could have, based on what they've testified to, they could have overlooked the open records thing, the foreclosure order, some of the Mitty Foundation stuff. It really is those grand jury subpoenas. Oh. That's the moment when they kind of have because that's when, and talk about what would be the problem to have, as in this case with these grand jury subpoenas that are issued to law enforcement, federal law enforcement, you know, email records and stuff of federal judges, and also to civil opponents of Nate Paul.
Well, I think that what you're doing, if you're involved in that, is you're
Would you please state
sending
your
up
name
a
for the
flare.
record?
Oh, we've got somebody coming on.
Yes, Your Honor.
Oh, we're
Amy
back on.
Hilton for the Attorney General.
Oh, let's take a look.
Would you please state your name for the record?
Yes, Your Honor. Amy Hilton for the Attorney General.
Would you call your first witness?
Yes, Your Honor. The Attorney General calls Henry De La Garza.
Will the bailiff bring in Henry De La Garza? Amy, there's some documents still up here if you want to get those removed. Watch your step. I need to swear you in. Raise your right hand. I do solemnly swear or affirm that the evidence I give upon the hearing of the Senate of Texas of the impeachment charges against Warren Kenneth Paxton Jr. shall be the whole truth. Shall be the truth, the whole truth, and nothing but the truth, so help me God. I do. Please be seated and speak closely to the microphone.
I think we need to swear in the new court reporter.
Hold on, I understand we have a new court reporter I need to swear in also. Where is our new court reporter?
She's down there.
You raise your right hand, step to the side. Hi. I do solemnly swear or affirm that I will correctly transcribe and report all the proceedings of the trial of Warren Kenneth Paxton Jr. on the impeachment, so help me God. Welcome. Give her a moment, and then when you see she's ready, proceed.
Good afternoon, Mr. De La Garza. Could you please introduce yourself to the jury?
Sorry about that.
Uh,
Yes. My name is Henry De La Garza.
and I'd like to just have you take a minute and a half or so and give us a little of your background, where you're employed, and what you do there.
I work at the Office of the Attorney General, an agency of the state of Texas, and I am the HR Director, the Chief Employment Counsel, and the Ethics Advisor.
And how long have you held the position as HR Director?
HR Director, Interim Director, November 2nd of 2020, and then became Permanent HR Director December 1st of 2020.
How long have you worked for the Office of Attorney General?
I started in 1995 as an Assistant Attorney General 1 and worked my way up.
And what division did you start in? Have you always been in Human Resources?
No, I started in Habeas Corpus Division and then went to Transportation Division and then Human Resources.
How many attorneys general have you worked for at the agency?
Well, let's see. I guess it would have been Dan Morales and then John Cornyn, now Senator Cornyn, Greg Abbott, now Governor Greg Abbott, and then Ken Paxton, and then also the Provisional AG John Scott and Provisional AG Angela Colmenero.
How many years have you been working in Human Resources?
I started in May of 2008.
You've testified that you've been at the agency for a couple of decades. How would you describe your experience working at the Office of Attorney General?
The agency is an outstanding state agency. It's a great place to work. This is as a lawyer, it's an ideal place to practice law, whether you do civil, criminal, trial, appellate, transactional, plaintiff defense, whatever, we have it. And, as an agency, we're number one in child support enforcement. This is an agency of lawyers, of child support officers, peace officers, and a lot of hardworking employees.
And as the HR director, how many employees at the Office of Attorney General are you responsible for, enforcing agency policy and procedure?
Well, the approximately 4,000 employees that we have throughout the state of Texas. And we also handle human resources work for the State Office of Risk Management, SORM.
And just generally, what are your responsibilities as both the ethics advisor, the HR director, and the chief employment counsel?
Well, it's quite a bit. As HR director, I oversee the HR operations for our state agency, 4,000 employees throughout the state of Texas. I lead a team of 22 talented and dedicated employees. We handle all sorts of HR functions, from hiring, posting, classifications, onboarding, benefits, leave, training, development. We have a wonderful wellness program, and we also have a robust law clerk program. And as chief employment counsel, I, along with the other attorney in the division, excellent deputy chief, we provide legal guidance to the managers and supervisors of the agency, and we, make sure, EEO compliance, the rare EEOC charge of discrimination, and workers' compensation, and unemployment benefits. And then as ethics advisor, I provide guidance to approximately 700 lawyers of our agency, mostly on the Texas disciplinary rules of professional conduct, other ethical issues, and then I oversee the agency's fraud, waste, and abuse prevention program. I think I have it all.
I started as a law clerk at the office, and so I certainly appreciate everything that you do for the office. Outside of working in HR, do you have any other experience with employment law?
Yes, before starting in HR, I worked in the transportation division where I managed the employment law matters for TxDOT, another outstanding state agency, and handled the trials, appeals, hearings for state and federal law, for all different types of employment laws, Title VII, Chapter 21 of the Labor Code, FMLA, FLSA, ADA, First Amendment retaliation, whistleblower retaliation, USERO retaliation, workers' comp retaliation, all that.
And so you mentioned the Whistleblower Act. Have you ever taken a Whistleblower Act case to trial?
I actually have.
Okay. And does the Whistleblower Act, does that have certain requirements in order to state a claim?
It does.
And does it also provide specific remedies?
It does.
Is one of those remedies removal from office?
It is not.
And who is a proper defendant under the Texas Whistleblower Act?
The government entity.
Is an elected official a proper defendant under the Texas Whistleblower Act?
No.
Where are Whistleblower Act claims usually adjudicated?
It's a state law claim, so it would be in state district court.
Are you aware of a Whistleblower Act claim ever being litigated outside of the state district court?
Not under the Texas Whistleblower Act.
Are you aware, Mr. De La Garza, that in 2020, a group of high-level staffers made reports to law enforcement about the Attorney General?
I am.
And are you aware that some of those staffers subsequently filed a Texas Whistleblower Act lawsuit against the Office of Attorney General?
I am.
And to your knowledge, is that case still pending?
Yes, in Travis County.
You mentioned that you've worked under a number of attorneys general, and so I just want to ask you a few brief questions about how the agency works. How do most employees of the Office of Attorney General obtain their positions?
Most employees, we're talking about, just about everyone, would apply through a competitive posting, and then the hiring manager would select the best qualified candidate.
And how did the former staffers who made those complaints to law enforcement, how did they obtain their positions?
They were appointed by Attorney General Ken Paxton.
And so, and to be clear, I think you said there are about 4,000 OAG employees?
Yes, about 4,000.
And about how many are appointed?
We're talking about half of 1%, maybe 0.2% or 0.02%.
Is it your understanding, Mr. De La Garza, that the Attorney General has authority to appoint certain high-level policymakers?
Yes.
And what is that understanding based on?
Well, it's a well-established concept and tradition in the United States of political patronage. This has been affirmed in Supreme Court law, U.S. Supreme Court law, federal law, state law, that elected officials, whether you are the governor or the attorney general or the elected sheriff of a county, that you have the right to hand select people who are going to help you reach the goals and the vision that you've presented to the electorate and who voted you in.
And for those appointed officials at the Office of Attorney General, are those appointed officials still required to comply with agency policies, just like every other OAG employee?
Yes.
At this time, Your Honor, I'm going to move to admit Attorney General Exhibit 431. Counsel and I discussed this during the break, and I understand that there is no objection.
No objection.
Admit AG 431 into evidence.
Mr. Arroyo, could you please pull up AG 431? And could you turn to the second page, please, Mr. Arroyo? Mr. De La Garza, is Exhibit 431, do you recognize this as a copy of OAG policies and procedures?
On the screen, there's nothing on the screen.
Oh.
Hold on one moment. We'll stop the clock for a moment.
Hilton's.
Okay, so that's Amy Hilton doing the questioning. She's another one of the attorneys that's on temporary leave from the Attorney General's office. And I went back and looked at the records I had gotten from the AG's office. So during June and July, she was paid about 21,500. I mean, give or take. And so that's, you know, I had interviewed a number of ethics experts on this question of, you know, employees, attorneys in the AG's office taking leave and then going to defend Ken Paxton, and, you know, all of them, you know, thought it was problematic.
Well, and working for a law firm, right? I mean, they're working.
Well, yeah, because Stone and Hilton, Judd Stone and Christopher Hilton created a law firm.
And apparently she's named Hilton, but not related.
As far as I could tell,
we
you
can
know,
tell.
I don't have any indications that they're not related. That they are related. I think it's just a, you know, a coincidence that both of them have the last name Hilton.
So this is their side gig right now. They're representing their boss, their former boss,
while on temporary leave,
Right.
and also the attorneys that took temporary leave. One of them had actually didn't have any leave time, so they didn't actually draw anything.
Who was paid the most?
Who was paid the most? I can look at my little spreadsheet here. Judd Stone.
Judd Stone.
Judd Stone. 37, about 38. I'd have to total it up exactly, but
That's pretty good leave money.
well, he was the he is the Solicitor General, so he's a pretty high-ranking person
He's
in
the
that
top
office.
litigator.
Yeah, and so
Has he done any?
I
Has
have
he
not
done anything?
seen Judd Stone. Chris Hilton's the one we've been seeing. Chris Hilton is the, I believe his title is Head of General Litigation, and he's been pretty involved in, you know, he did the press conferences, and of course you, Bud, you saw him at that hearing.
Right, at the Ethics Committee hearing that where the articles of impeachment were reported out from committee and sent to the House floor. General Investigating Committee.
You know, one thing we haven't talked about, are they about to go back? Okay, let's take a listen.
Members, return to your seats, please. Hold on one second, Amy. You start the clock again. Proceed.
Mr. De La Garza, can you see Attorney General Exhibit 431 on your screen?
Yes.
And you recognize that as a copy of the Attorney General Office of Attorney General Policies and Procedures?
Manual? Yes.
And what is your role, if any, with respect to drafting and creating policies for the office?
Well, since May 2008, I've been pretty active in making sure that our policies are up to date, revising policies with new laws. For example, I know that we've got the new Crown Act and military performance and paid parental leave, things like that. So we make sure that we're always keeping up, and we make changes to the manual.
Do these policies provide that Office of the Attorney General employees are at-will employees?
Yes.
And can you just briefly explain what that means?
Well, the state of Texas is an at-will state since, I think, 1877 or something like that. And it just means that in Texas, you don't have a property right in their job. You can be fired for any reason. A little more? This? Oh. Oh, perfect. Thank you. Thank you.
Mr. De La Garza, are members of the executive administration at-will employees?
Yes.
Does OAG have an unacceptable conduct policy?
Yes.
Mr. Arroyo, could you please flip to page 43 of Exhibit 431? At the bottom, the bait stamp should end in 535. Mr. De La Garza, is this the unacceptable conduct policy we were just talking about?
Yes.
And Mr. Arroyo, if you could just flip to the next page, please. And about halfway down on those bullet points, Mr. De La Garza, one of the things that's listed as unacceptable conduct is use of an insubordinate or unprofessional tone towards management. Do you see that?
Yes.
Is that a policy that you wrote?
Yes.
And when did you write that policy?
Based on the date that I saw, it looked like it was in 2013.
And can you explain for the jury why you included that policy in the office's policies and procedures handbook?
It just seems typical that most manuals for employers would include something about, conduct and what's appropriate and what's not.
What are the potential consequences for failing to comply with agency policies?
Well, it depends. We look at every situation individually. It could be corrective action, such as a counseling session, a reprimand. But if it's, depending on the situation, it could be disciplinary action, including involuntary separation.
As the Chief Employment Counsel, the Ethics Advisor, the Director of Human Resources, do you provide advice to executive management on matters on employment issues?
I do.
And do you provide advice related to the application of the policies that are contained in AG Exhibit 431?
I do.
I'd like to switch gears a little bit here, Mr. De La Garza, and talk about the ex-staffers, the former staffers that left the Office of Attorney General in 2020. Who was Jeff Mateer?
Jeff Mateer was the first Assistant Attorney General.
And how did his employment at the OAG conclude?
Jeff Mateer resigned on October 2nd, 2020.
And who succeeded him as first assistant?
Because Jeff Mateer resigned and Attorney General Ken Paxton had, a right to then select someone. And, under the Texas Government Code, every state agency needs to have an executive head. And at the Attorney General's office, that executive head is the first assistant. And so they pretty much manage the division day to day. And so Attorney General Paxton appointed Brent Webster, and then he began that same Monday, I believe, October 5th, 2020.
At the time that Mr. Mateer resigned, were the other former staffers still employed at Office of Attorney General?
Yes.
And so at that time, they reported to Mr. Webster, is that right?
Yes. Starting on October 5th, 2020, they would have been reporting to First Assistant Brent Webster.
And would those staffers be required to comport with OAG policies in their interactions and their work for First Assistant Webster?
Yes.
And that would be a reasonable expectation that Mr. Webster would have of them?
Yes.
Let's talk about Ryan Bangert. Do you recall what his title was?
Ryan Bangert was the Deputy First Assistant Attorney General.
And how did his employment at OAG conclude?
Mr. Bangert submitted a letter of resignation on approximately, I think it was October 28th, 2020, and then left the agency as identified in the letter on November 4th, 2020.
And what about Darren McCarty? How did his employment at OAG conclude?
Darren McCarty was the Deputy Attorney General for Civil Litigation, and Mr. McCarty submitted a letter of resignation on, I believe, October 26th, 2020, and then left the agency pursuant to the letter he left on November 4th, 2020.
And what about Blake Brickman? Do you remember his title?
Mr. Brickman was Deputy Attorney General for Policy and Strategy.
And how did his employment at the office conclude?
Mr. Brickman was involuntarily separated.
Mr. Arroyo, could you please pull up AG Exhibit 224? And Your Honor, I'm going to move to admit this exhibit. I understand from counsel during the break that there is no objection.
No objection.
The exhibit shall be, what was the number again?
AG 224.
224, admitted to evidence.
Mr. De La Garza, is this memo a memo that you drafted related to Mr. Brickman's employment with the Attorney General's office?
Yes.
And does this memo reflect advice that you provided to the office related to Mr. Brickman's continued employment and ultimate termination?
Yes, it was advice about if we wanted to write a justification, this could be a draft of a justification.
And is this justification, was this the result of an independent analysis that you made with respect to his employment at the office?
Yes.
Were you instructed by anybody to come to any conclusions regarding his employment?
No.
Could you please explain the conclusion of this memo for the jury?
I only see page 1. I'm not sure if...
Your Honor, may I approach the witness, please, with a hard copy?
Yes, you may.
Thank you. Just the conclusion was that involuntary separation, that he could be allowed to resign.
Looking at the memo, at the bottom of page 1, you write that Mr. Brickman has engaged in the following misconduct as identified in the agency's unacceptable conduct policy. Do you see that?
Yes.
And you list a number of violations, is that correct?
Yes.
And is it true that in this memo, you indicate that regardless of Mr. Brickman's report to law enforcement, there are violations of agency policy that justify termination?
Yes. I mean, in many ways, it's just it was a situation of an employee with a new boss and having an insubordinate or unprofessional tone towards the new boss and not following orders, directives of the new boss.
And based on the information that you were aware of at the time, was it your opinion that Mr. Brickman's had some job performance issues in the workplace following his report to law enforcement?
Yes.
And was part of that misconduct creating an atmosphere that was untenable for the agency?
Yes.
And can you just describe a little bit what that is? I'm looking at page 2 of your memo, talking about the working relationship being strained and inefficient. Could you describe what you were aware of at the time that you made this memo?
Yes. I mean, overall, it appeared that there were some pretty egregious violations of the kind of the insubordinate tone of that policy that you had mentioned earlier. And the insubordinate tone, the demeanor, the language, the refusal to perform directives from Mr. Brickman's new boss, new supervisor. Just overall, there were those issues really stood out. And then overall, just based on the everything applicable, state law, federal law, the facts presented, there was no reasonable expectation that he wanted to work for the new boss, the new first assistant, or no reasonable expectation that.
Objection. Narrative. We just asked for a question and answer, Your Honor.
Sustained.
Mr. De La Garza, you mentioned that Mr. Brickman's behavior was egregious. Did I hear that correctly?
Yes.
And is it your understanding that part of the egregious nature of his behavior was his refusal to meet with his supervisors?
Objection. Leading.
I'll rephrase.
Rephrase. Sustained.
Mr. De La Garza, what was egregious about Mr. Brickman's behavior?
I mean, based on the facts presented to me, that type of insubordinate tone and demeanor is pretty rare in our agency.
Who did you provide this memo to?
I believe I would have probably sent it to my boss at the time, the human resource director at the time, and probably Brent Webster, the new first assistant.
Who, to your understanding, who made the decision to terminate Mr. Brickman's employment?
It would have been, his supervisor was the first assistant.
And did you support the decision to terminate Mr. Brickman's employment?
I mean, based on the facts as presented to me and the applicable state law and federal law, especially about, political patronage, yes, there didn't seem to be a reasonable expectation that he could continue working with or for Brent Webster or continue serving as a high-level policymaker for the Attorney General.
And do you stand by the advice in this memo today?
I do.
Okay, let's talk about Mr. Ryan Vassar. Was he the Deputy Attorney General for Legal Counsel?
Yes.
And his employment at the office was terminated, is that correct?
Yes, involuntary separation, yes.
And who made that decision?
That also would have been the first assistant.
Did you support the decision to terminate his employment with the office?
Based on all the facts presented to me and the applicable state and federal law, yes, there was a variety of reasons. There was a lack of confidence in his...
Objection, Your Honor. Hearsay. The witness just testified based on information he received.
Sustained.
Mr. De La Garza, did you provide any recommendations concerning Mr. Vassar's, the involuntary separation?
Yes, I mean, as a HR director, I have to rely on information that is presented to me.
Okay, and sorry, I didn't mean to talk over you. When you were providing those recommendations, were you advised by management of some issues, some job performance issues that they were experiencing with Mr. Vassar?
Objection. Hearsay. Advised by management. Out of court statement, Your Honor.
Your Honor, if I may, I'm asking about the facts that inform his recommendation. I'm not offering them for the truth of the matter, but rather for just the things that he was aware of at the time he made his recommendation and why he made that recommendation.
So
I'm going to sustain your objection. Find another way to ask the question.
Thank you, Your Honor. Did agency policy support the decision to terminate Mr. Vassar's employment with the agency?
Yes.
And was it your understanding that Mr. Vassar had violated agency policy by sharing confidential grand jury subpoenas outside of the agency?
Objection, Your Honor. I need to interrupt. This is knowledge gained through hearsay and leading.
Sustained.
Could you please describe what the violations of agency policy were that supported termination?
Well, just overall, as far as the reasons presented to me for separating him were, there's a combination of...
Objection, Your Honor. Reasons stated to me is an out-of-court statement, hearsay.
Your Honor, again, this goes to the basis for his recommendation. This is not he's not testifying as to the truth of it, but rather the information, his understanding of the information and what informed his advice to the agency.
We'll overrule your objection this time.
You can answer the question, Mr. Delagarza.
Yes, I mean, I have to rely on the facts presented to me. I mean, we have 4,000 employees. So with respect to Mr. Vassar, I had to rely on the facts presented to me on what he had done or had not done. And so as far as the overall reasons, there was a variety of reasons, a lack of confidence. There were some issues about his performance, some issues about the handling of grants or mishandling of grants. Overall, there was some insubordinate tone and demeanor, and overall, there was, my understanding, there was one last meeting to see if there was any reasonable expectation that Mr. Vassar could or wanted to work with or for his new boss,
Objection,
Brent
Your Honor. I apologize for interrupting. Can we keep this question and answer? My objection is narrative.
Sustained.
Mr. Delagarza, let me ask you about that meeting. You mentioned that there was one last meeting before there was a decision made to separate Mr. Vassar from his employment at the office. Were you present at that meeting?
No.
Were you later requested to provide counsel as a result of what had happened in that meeting?
Yes,
And sorry, I'm going to stop you right there just because I want to make sure that we're keeping this question and answer. But I appreciate your testimony. When you were asked for advice, did you ultimately recommend separation?
Yes.
And do you agree with that decision today?
Yes.
Let's talk about Mr. Maxwell. Was he the director for law enforcement?
Yes.
And was his employment also terminated from the Office of Attorney General?
He was involuntarily separated on, yes.
And who made that decision?
First Assistant Brent Webster.
Did you advise Mr. Webster with respect to that decision to terminate Mr. Maxwell's employment from the agency?
I recommended that it could be done, that it was reasonable based on the facts presented to me.
And did you personally have prior experience with Mr. Maxwell and some violations of agency policy in the past?
Yes.
And how would you recommend, or excuse me, how would you describe your experience working with Mr. Maxwell?
I mean, I admire all that he's done, but with respect to HR issues in HR, certainly it was a developing pattern of not going to HR for guidance on some very sensitive HR matters.
And did the failure to go to HR for guidance on very sensitive matters, did that ultimately expose the agency to liability?
It could have.
And about how many instances?
Well, there was one case with a Hispanic peace officer, a female who had been subject to sexual harassment.
Objection, Your Honor. This is knowledge gained through hearsay. Presumably he did an interview with this woman who will not come in to testify. All of the information he gathered and he's relaying to us is hearsay.
Your Honor, I'll move on.
Sustained. Continue.
I'd like to offer what's going to be marked as AG Exhibit 1055. I understand counsel does not have an objection to this either.
No objection, Your Honor.
Admit 1055.
And Your Honor, may I approach the witness with a hard copy? Thank you. Mr. Arroyo, could you please pull up AG Exhibit 1055? Mr. Delagarza, do you recognize AG Exhibit 1055 as an email that you drafted to Brent Webster and Aaron Reitz?
Yes.
And does this memo provide your legal advice regarding the continued employment of these staff members?
Yes.
What prompted this email?
Mr. Maxwell and Mr. Penley, Mr. Maxwell and Mr. Penley had been on investigative leave, and they wanted to have a meeting to see if there was any reasonable expectation that they could work with or for Brent Webster.
And I'm sorry, Mr. Delagarza, just for the record and for clarification, when you say they wanted to have a meeting, who is they?
Well, primarily the first assistant, Brent Webster.
Thank you, and I'm sorry to interrupt. Please go on.
And there was this kind of a sort of a last ditch, let's see if there's any reasonable expectation that they could work with or for Brent Webster, the new first assistant, and whether there was any reasonable expectation that they could continue as high-level policymakers with Attorney General Ken Paxton.
And so is this email your suggestions of things to ask in those meetings?
Yes.
Why did you pick these particular questions? Like, do you trust me? Do you trust the Attorney General? Are you committed to the vision? Why did those questions make it into this memo?
Well, based on the case law, Elrod v. Burns, Branty v. Finkel, and its progeny, that's what you focus on: the loyalty, trust. Can the elected official, trust the people that he's or she is chosen to support their vision, their goals.
And why would that be important to the agency?
Well, it's definitely a question about efficiency. I mean, you want everything to move along, and if his deputies aren't, if they're not seeing eye to eye, it's going to break down, and then it eventually starts trickling down, and we start losing, efficiency, and there could be worse problems.
Mr. Arroyo, could you please pull up House Managers Exhibit 383? And Your Honor, this is already in evidence. May I approach the witness with a hard copy? Thank you. Mr. Delagarza, do you recognize this email that was sent by Greg Simpson, your former boss, to Brent Webster copying you related to the CID division?
Yes.
And I don't want to go through this whole thing, but I just want to ask you, on the second page, could you please read aloud the last two sentences on the last page of this document?
It reads, overall, HRD has had difficulty getting CID to work with us on matters that are appropriately and exclusively within HRD's authority. Maxwell's actions have exposed the agency to potential liability.
And what does HRD and CID, what does that mean?
HRD would be the Human Resources Division, and CID would be the Criminal Investigations Division.
And the Criminal Investigations Division, that was the division that Mr. Maxwell was chief of, correct?
Yes, that's one of the primary divisions under law enforcement, under his purview.
And so does this email identify a number of issues with Mr. Maxwell's management of his division?
Yes, Mr. Simpson explained that there were some challenges that HR had faced.
Did you agree with the decision to terminate Mr. Maxwell's employment with the agency?
Yes, based on the facts presented to me and the applicable law, it seemed reasonable.
And, okay, you can set that aside. Thank you. Do you agree with that decision today, Mr. Delagarza?
I do.
And who made that decision?
That would also have been the first assistant, Brent Webster.
I'd like to talk to you about Mr. Penley. Do you recall that he was the Deputy Attorney General for Criminal Justice?
Yes.
And he was also involuntarily separated?
Yes.
Was he offered the option to resign?
Yes, he was.
And to your knowledge, before Mr. Penley was let go, did he meet with Brent Webster?
Yes.
And did he have the meeting that you suggested or that you mentioned earlier about whether there could be a reasonable expectation that Mr. Penley could work effectively with the new first assistant?
Yes, that meeting took place.
And what was your understanding about the prospect of Mr. Penley being able to effectively work with Mr. Webster following that meeting?
My understanding from that meeting it was that there was no reasonable expectation that Mr. Penley wanted to work with or for his new boss, First Assistant Brent Webster, that he could in the future, and that he could serve as a high-level policymaker for Attorney General Ken Paxton.
Did agency policy support Mr. Penley's involuntary separation?
Yes.
How so?
Well, just based on the lack of confidence, there was some evidence of questionable decision making, just the breakdown in the working relationship. There may have also been, from what I recall, some insubordinate tone or demeanor towards Brent Webster. And so just overall, based on the applicable state and federal law and the facts presented to me, it seemed reasonable, and the policy supported that.
Was it also your understanding at the time that Mr. Penley had omitted some material information in a court filing?
Yes, that had been also presented to me as far as some wrongdoing, whether it was misconduct.
I apologize for interrupting. This had been presented to me as hearsay, out-of-court statement. We object to hearsay.
Your Honor, this is the same ruling that you made earlier to overrule the objection. This is the facts that were presented to him that informed his advice to the agency and that was subsequently conveyed to Mr. Webster, who determined what the employment decisions would be going forward.
Your Honor, if I may.
Overruled.
You may continue.
I'm sorry. What was the question again? I'm sorry.
Yes, the question was whether it was, you know what, I think you answered it. Thank you, Mr. De La Garza. I will ask you a follow-up question. You said it was your understanding that facts had been presented to you that Mr. Penley had omitted material information from a court filing. Is that right?
Yes, that was the facts presented to me.
And do you know whether that constitutes a violation of the agency's policy on handling confidential and privileged information?
Yes, we have a specific policy on that.
And did you agree with Mr. Webster's decision to terminate Mr. Penley's employment?
Yes, based on the law and the facts presented to me, it was a reasonable decision.
And sitting here today, do you stand by that support, that recommendation?
I do.
Mr. Arroyo, could you please pull up AG Exhibit 120? And Your Honor, this is not in evidence, so I'm going to offer it now. I understand that counsel does not have an objection.
No objection.
Admit AG 120 into evidence.
And Your Honor, may I also approach the witness with a hard copy?
Yes, you may.
Thank you. Mr. De La Garza, do you recognize this email?
Yes.
And does this email reflect some of the legal advice that you provided to the agency, including to Mr. Webster, about the application of the Whistleblower Act?
Yes, I provided some what I considered privileged and confidential advice regarding the petition that had been filed.
Understood. Mr. De La Garza, looking at the first paragraph of this email, you write, "Here is my list of why Vassar, Maxwell, Penley, Brickman should be considered high-level policymakers who are exempt from whistleblower protection. Do you see that?
I do.
And I want to ask you about that term, high-level policymakers. Why was that important?
That is the term used in sort of political patronage case law about that elected officials can appoint. They have to be high-level policymakers for them to be appointed.
I'm sorry, they have to be high-level policymakers to be appointed. Is that what you said? Thank you. And all of the former staffers who made reports to law enforcement, in your view, fell under the category of high-level policymakers.
Objection leading.
Your Honor, I'm just clarifying his testimony, but I can restate.
Sustained, just restated.
Mr. De La Garza, is it your opinion that the former staffers who made reports to law enforcement were all high-level policymakers?
They were high-level policymakers.
And could you just summarize for the jury some of the points that were important to you here that led you to your conclusion that they constitute high-level policymakers that are exempt from the Whistleblower Act?
Well, based on the list that I have here, and it was supported by case law, they required more than simple ministerial competence. They created or implemented, agency goals, policy. They controlled or exercised a role in the decision-making process as to the goals and general operating procedures of the agency. They ensured that policies which the electorate had sanctioned by electing the Attorney General were effectively implemented. They all had access to confidential documents or other materials that embody policymaking deliberations and determinations. Party affiliation was an appropriate requirement. They served as
sorry, Mr. De La Garza, if I could, I just want to stop you there at the bullet point about party affiliation. You write here that party affiliation was an appropriate requirement for effective performance of the public office involved. Is party affiliation something that the agency would look for in the employees who apply for competitive jobs in regular postings?
No.
Mr. De La Garza, do you stand by this advice in AG Exhibit 120 today?
I do.
Thank you. You can set that aside. Mr. De La Garza, did the Office of Attorney General have legitimate, non-retaliatory reasons for terminating these staffers' employment?
In my opinion, yes.
And under the Texas Whistleblower Act, can the Office of Attorney General or any state agency terminate a whistleblower based on information or evidence that is not related to their whistleblower report?
Yes.
And do you agree that that for the agency to be effective, that high-level policymakers need to be able to collaborate effectively with the first assistant and with the Attorney General?
Yes.
Did you believe that there was any reasonable possibility that any of these former staffers could do that?
Well, Darren McCarty resigned. There could have been Ryan Bangert. I would say that there was possibly with them, but
for the ones that resigned, but for the ones that were terminated, was there a reasonable expectation that they could work with the new first assistant and with the Attorney General?
Yes. For the ones who were involuntarily separated, no, in my opinion, there was no reasonable expectation.
Did Ken Paxton ever indicate expressly or implicitly that these former staffers needed to be fired because they made a report to law enforcement?
Not to my knowledge.
Do you have any knowledge that Brent Webster ever indicated expressly or implicitly that these former staffers needed to be fired because they made a report to law enforcement?
Not to my knowledge.
Did anyone at the Office of Attorney General determine what your recommendations would be with respect to the legal advice you provided for these former staffers who were involuntarily terminated?
Not to my knowledge.
Was your analysis of whether the former staffers had violated agency policy, was your analysis an independent analysis?
Yes. I mean, at times I consulted with the other lawyer, my boss, before he left.
Mr. Arroyo, could you please pull up Article of Impeachment 6? And could you turn to the next paragraph of Article 6, please, Mr. Arroyo? Mr. De La Garza, Article 6 accuses the Attorney General of terminating the employees without good cause or due process and in retaliation for reporting his illegal acts and improper conduct. Do you see that?
I do.
Is good cause required to terminate an employee in Texas?
No, it's not. But at the Attorney General's office, we ensure that there are good reasons and that it's fair.
And did good reasons and fair reasons exist for each of the former staffers that were involuntarily terminated?
In my opinion, yes.
Is due process required to terminate an employee in Texas?
No, there's no property right to our jobs since we're at will. So due process, there's no constitutional right, and but we ensure that it's fair.
So, okay, thank you. And were any of the former executive administration staffers terminated in retaliation for making a report to law enforcement?
In my opinion, no.
Thank you, Mr. De La Garza. I pass the witness, Your Honor.
Thank you. Your witness. Please state your name for the record.
Yes, Your Honor. Yes, Your Honor. Daniel Duco. Hi, Mr. De La Garza. How are you?
Fine, thank you. How are
Mr.
you?
De La Garza, you testified a moment ago that you are familiar with the Texas Whistleblower Act, correct?
Yes, I did.
And you understand that the Texas Whistleblower Act affords protection to people that go to law enforcement so they can go to law enforcement without retribution, right?
Yes.
And as part of the Texas Whistleblower Act, that protection only extends to people who still have their job.
Yes, they are, yes.
Right, so what I mean is, if you report someone to law enforcement and they still have their job and then they're retaliated against, they are protected by whistleblower, correct?
If they comply with the retaliatory, the requirements in the Texas Whistleblower Act, yes.
But if they get fired before they go to law enforcement, they're not afforded the protection of the Whistleblower Act, correct?
Right, it has to be, right.
Right, so before you go to law enforcement, you don't want to tell your boss, I'm going to law enforcement.
Objection, speculation.
Sustained.
Under the Whistleblower Act, if you tell your boss you're going to law enforcement, you get terminated, then you go to law enforcement, you're not entitled to the whistleblower protection, correct?
Objection, speculation. It's the same question, Your Honor.
Just said he knew this.
You can answer if you know.
All right, could you just repeat the question, please?
Sure. Under the whistleblower statute that you said you're familiar with, if you tell your boss, I'm about to go to law enforcement, then you go to, before you go to law enforcement, you get fired, then you go to law enforcement, you're not entitled to the protections of the whistleblower statute, are you?
I guess you could make the argument in court. I'm not sure how successful you'd be.
But you agree with my statement, correct?
Probably wouldn't be the best way to do it.
So if someone were to stand up here over and over...
Witness needs to speak up when you speak.
Oh, excuse me.
If someone were to stand up here over and over and say, why didn't you just call your boss? Before you went to law enforcement, why didn't you just call your boss? Under the Whistleblower Act, that wouldn't be a good idea, would it?
I mean, if your plan was to file a lawsuit, then yes, you shouldn't do that.
You should not go to your boss first.
If you were planning to file a lawsuit, I mean, it depends on the situation.
I'm not talking about a lawsuit. I'm talking about whistleblower protection. It would not be a good idea to call your boss first, right?
Objection, asked and answered.
Overruled.
Right?
You're asking me to speculate. I'm not sure what a plaintiff should or shouldn't do.
You don't want to answer that, do you?
I'm not here to, speculate as to what a potential plaintiff under the Whistleblower Act should do or could do.
Just so we're clear, you're not here now. A moment ago, you were okay with it, right?
Objection, Your Honor. It's argumentative.
Sustained.
All right, let's put up AG 120, please. Can you see AG 120?
Yes.
This is a document that you created, an email, right?
Yes.
And in this email, it says, here are my list of why Vassar, Maxwell, Penley, Brickman should be considered high-level policymakers who are exempt from whistleblower protection, correct?
Yes.
This is your analysis.
This was a privileged and confidential document that we are brainstorming.
I appreciate that, but I think I wrote down your words, and what you said was, this is my analysis. You still stand by that?
Sure.
And you said, I stand by that today.
Yes.
And you said to the senators here, this is the correct analysis, right?
At the time, I believed it was the correct analysis. So
this argument, this exact argument that's in this document right here, was made in the court, right?
I'm not sure. I wasn't involved in that.
You're not familiar with the Court of Appeals case, Office of the Attorney General versus Blake Brickman, Mark Penley, David Maxwell, and Ryan Vassar? You're not familiar with that?
I'm familiar, but I wasn't involved. I didn't work on that appeal.
Are you familiar with the decision that came out in that appeal?
I would have to read it and
You don't remember?
To be honest, I'm not sure if I carefully, that was not something that I needed to read.
Well, if you had read it, you would know that the Court of Appeals said all of your analysis in AG 120 was wrong.
Objection,
right?
argumentative.
He knows.
Overruled.
Right?
It happens as lawyers, we make arguments and courts don't agree with them. And so, there's always going to be a winning side and a losing side. And at the time, I was just coming up with potential arguments. That's what, we do.
Right. So when the senators are deciding whether or not this is a valid argument, they can disregard it because the Court of Appeals already decided it was not.
Objection, this misstates testimony and is going outside of direct. This also is talking about a document that is not in evidence, and there's been no testimony before this witness about.
Overruled.
Right?
I defer to the Senate to do the right thing.
You spent a lot of time telling us about how people were involuntarily separated. That means fired, right?
Yeah, we just like to use involuntary separation.
Okay, I just want to make sure we're on the same page. That means fired.
It does.
You also spent a lot of time using the phrase, based on facts presented to me, right?
Yes.
And those facts were presented to you by Brett Webster.
For the most part, yes.
Doesn't it seem like you had a Brett Webster problem?
Well, he was the new first assistant, and these employees were reporting to him.
I mean, you've heard the term garbage in, garbage out, right?
I've heard the expression.
So if Brett Webster is giving you information that's not true, then your analysis is wrong, correct?
I have to rely on the information given to me.
I appreciate that. My question is a little bit different. If Brett Webster's not telling you accurate information, then all the analysis you gave on direct examination is all incorrect.
Objection, speculation.
He knows.
Overruled.
Correct?
I have to rely on the facts presented to me, and so
Is my question difficult?
It's, you're saying that if he presented false if he presented false information to me, and I'm using that false, yes, it could affect my analysis.
Well, let's talk about the real reason why these people got fired. Stacey, can you put the timeline up, please? I'm going to use this for demonstrative purposes, so...
Your Honor, I'm going to object. I've never seen whatever this is before. Counsel and I discussed exhibits during the break. This was not provided to me, so I would request that we get a copy of whatever this is to quickly review.
Not an exhibit, Your Honor. Simply demonstrative purposes, not going back based on dates that this witness provided on direct examination. If the dates are wrong, counsel can correct me.
Well, Your Honor, I mean, we might have an objection to whatever he's going to put on this timeline. I don't know what it is, and I don't have an opportunity to verify it, and it's being published to this jury as if it's fact. So I'm going to object to displaying this to the jury.
Your Honor, they're making evidentiary arguments. I'm not offering this into evidence. It's purely demonstrative.
Your Honor,
Hold on. Don't talk over each other. I think you can provide the counsel with what you're about to show. Yes.
Thank you. Your Honor, I might have objections as this goes along because I don't think there's any foundation that he's laid yet, at least, to ask to publish these as something that's within this witness's personal knowledge. But subject to that, I appreciate counsel providing this copy, and we can move along.
Move along.
Mr. De La Garza, on September 30th, and just before we get started, I want to point out this timeline is a...
Yes.
Stay at the microphone.
Yes. I want to point out, Mr. De La Garza, that this timeline is roughly a month and a half, less than a month and a half. Do you see that?
Yes.
And as you are familiar with the whistleblower statute, as you testified in direct examination, I'm sure you're familiar with 554.004, right?
Could you remind me?
Sure. It says, in an adverse action, if within 90 days of reporting to law enforcement, there's a presumption of retaliatory conduct.
There is a presumption that can be rebutted.
And so the law says, if within 90 days of reporting something to law enforcement, you're terminated or have an adverse action, we are to presume that was retaliatory, right?
There's a presumption.
So, September 30th, whistleblowers go to the FBI, right?
I'm not sure. I have no personal knowledge of what they did.
The head of HR, you don't know?
That's what I heard. That's what they presented to my boss, a letter saying that they had gone there.
Let's start over. You're the head of HR, right?
Now, yes.
You know that they went to FBI on September 30th, right?
I have received information that they did. I have no reason to disbelieve that.
You also know on October 1st, the whistleblowers notified HR and the AG Paxton of the FBI report, correct?
Yes, I believe it was the first.
The next day, Mark Penley and David Maxwell were placed on administrative leave.
That's correct.
On October 13th, David Maxwell made his formal complaint against Ken Paxton.
I'm not aware of exactly when he did. Formal complaints go to the formal complaint officer, so if you say it was the 13th. But
you spent a lot of time telling us about David Maxwell. You reviewed all the file. You're telling me you don't know when David Maxwell made his formal complaint?
I don't have personal knowledge of that because formal complaints go to the formal complaint officer. They don't go to HR.
Well, we can assume by the fact that your lawyer hasn't stood up and objected that that's the day he made his formal complaint, okay?
No reason to disbelieve that.
October 15th, Brickman, Vassar, Bangert, McCartley, and Penley all file formal complaints. You know that as well, right?
I understood that they all filed formal complaints.
October 20th, so 20 days after going to the FBI, 19 days after the whistleblowers notify of the fact that they went to the FBI, Blake Brickman was fired, right?
Yes.
Lacey Mace was fired.
Yes.
November 2nd, a month after going to the FBI, David Maxwell was fired.
Yes.
November 2nd, a month after going to the FBI, Mark Penley was fired.
Yes.
November 17th, 6 weeks after going to the FBI, Ryan Vassar is fired.
Yes.
Have you ever heard of the expression, there's no coincidences in Austin? Pass the witness.
Redirect.
Just briefly, Your Honor. Mr. De La Garza, did agency policy support the termination of Lacey Mace?
Yes.
And did you recommend that termination?
I did.
Do you stand by that recommendation today?
I do.
No further questions, Your Honor.
Are you?
No need for it.
Okay, we can excuse the witness?
Yes, Your Honor.
Yes? You may step down, thank you. A little housekeeping before the next witness. I said that after the break, I would admit 702 into evidence. We did not do that, so 702 is admitted into evidence. Mr. Donnelly, I think that was the correct number. Also, if both parties would like to come to the bench for a moment.
Okay, so Deandra.
Oh my Lord.
This timeline. Thoughts on this timeline?
I mean, I think I said before we came back that maybe I wouldn't call any more. This is exactly what I was talking about. I mean, that was not good. That was not good. That is, the timeline was bam, bam, bam. And all of these alleged theoretical HR issues they didn't have them in September. They didn't have them in August. They only had them after they went to the FBI. All of them. Amazing.
And there's something about a timeline that has power. I know when I'm
very visual.
When I'm doing a story, I tend to do it chronological, because when you tell a story chronological, then you can see those patterns, and you can really see that pattern when you hear the timeline.
Well, the other thing that surprises me is this is still pending litigation. So the fact that you put this guy on to say all of these things when there's a lawsuit pending, I just don't really understand the strategy there.
But?
Well, De La Garza did briefly say that yes, you can fire him if it can be rebutted. That there could be illegal grounds for firing them, but he never circled back to that or repeated that again. So he mentioned what he thought was going to be his out, but he never brought it up. This was the second defense witness in a row that hurt the defense, and so far the defense is they're not helping their client.
There's an old saying, quit while you're ahead.
Yeah.
It feels
the
kind of
only
like
reason we wonder if maybe they were behind, and that's why they felt like they had to present a defense. Maybe they felt like they were behind.
I mean,
but this is not. This witness fell apart like an Oreo cookie. He crumbled, and just he did not seem like an inspiring state employee at all. Some of this just leaves you the impression that all that was left at the Attorney General's office was a bunch of lackeys and weak-kneed people who just said yes to whatever the boss wanted without really knowing what was going on.
Oh, I think he's back. Is he coming back?
Are they coming back? Let's see. Let's
doing
pull
a break,
up that live look
or?
real quick. Let me take a look at my other screen. I've got the Senate feed shows they're still up there at the yeah, they're still
back at the dais?
they're still up at the dais.
Yeah.
But I got an email from an employment law attorney, and this is what she wrote. She said, HR employee and an attorney, De La Garza, did not provide a complete current definition of at-will employment.
Mr. Dorfman, if you'd raise your right hand.
Oh, no, they're swearing
I
somebody
do
in.
solemnly swear or affirm. Mr. Dorfman, if you'd raise your right hand. I do solemnly swear or affirm that the evidence I give upon this hearing by the Senate of Texas of the impeachment charges against Warren Kenneth Paxton Jr. shall be the truth, the whole truth, nothing but the truth, so help me God. Please have a seat.
Thank you.
Your witness.
May I proceed? And it's Anthony Osso, O-S-S-O, on behalf of Attorney General Paxton. Sir, would you please state and spell your name for the record?
It's Grant Dorfman, G-R-A-N-T. Dorfman is D-O-R, F as in Frank, M-A-N.
Okay, and I understand you're a judge, but just to keep the record clear, I'm going to call you Mr. Dorfman if that's all right.
I appreciate that.
Okay. Mr. Dorfman, could you please tell these senators how you're currently employed?
I'm the Deputy First Assistant at the Office of the Attorney General.
Okay. And I'm going to ask that you lean into that mic and speak loud and clear so that everybody in the courtroom can hear you. Now, before we talk about your role as the Deputy First Assistant, I want to talk to you a little bit about your background and who you are. Can you tell us where you're from?
Grew up in Dallas, Texas.
Okay. And where did you end up going to school?
Brown University in Providence, Rhode Island.
Okay. And then, was that for undergraduate?
Sorry?
Undergraduate?
That was my undergraduate, yes.
Did you go on to do law school?
I did.
Okay. Can you tell us where you went?
Yale Law School.
And what did you do after you completed your time at Yale?
I accepted a clerkship with a federal judge in Houston, Texas, brought me back to Texas after 10 years on the East Coast. I also took 2 years out before law school, got a graduate degree there, not in England as well, and then had a 1-year clerkship opportunity in Houston. Thought I was going back to D.C. to join the Department of Justice for the second term of the George Herbert Walker Bush administration. That never materialized, so I ended up blessedly staying in Houston.
Okay, so after that didn't work out, what did you end up doing next?
I went to work for a commercial litigation boutique and continued in that line. Went to a second firm where I made partner in, I think, 1999.
Okay, which firm was that?
Ogden, Gibson, White & Brooks, and the first firm was Sussman Godfrey.
Okay, and while you were working as a partner, can you describe to us kind of what type of law you were practicing?
Commercial litigation, generally that's a big area, but civil trial work and appeals, and a lot of energy work, a lot of employment cases, and just the things that Houston trial practice is made out of.
Understandable. What did you do after you spent your time working as a partner at the law firm?
Well, I had a desire for government service. I'd never really set it out to be a partner at a law firm and continue that for the last 30 or 40 years of my career. So I'd applied to the Department of Justice when the George W. Bush administration came around, went up to interview for 2 vacancies in deputy AGs in the civil division. I ended up withdrawing within 1 week of the interview because my daughter was on the autism spectrum disorder. She was then 4 or 5 years old. And it turns out, to my surprise, but after exhaustive research, the school she was in Houston did not have any counterpart, any comparable service in either the Washington or Baltimore metro area. So I had to withdraw from consideration for that. That lit a fire under me, reminding me that's kind of what drew me to the law in the first place.
Okay.
And so...
let me stop you real quick. So that's back to Houston, right?
I'm still in Houston.
Okay.
Never left. But then I put in for an application to Governor Perry's office for 2 district court vacancies in 2002.
Okay. And can you tell us what happened with that application?
It was successful.
Okay.
I was appointed to the 129th District Court in Harris County. It's a civil district court in May of 2002.
Okay. And can you tell us what happened after that term and farther on in your career?
I'm sorry, I didn't catch that last part.
After you served as a judge, a civil court judge in Houston, what did you do next in your career?
Oh, well, involuntarily, the voters decided in 2008 that they liked President Obama better than the rest of the ticket. I went in-house with Neighbors Drilling as an independent oil and gas contractor, I should say, with worldwide operations based out of Houston with about 25,000 employees and managed their civil, all their litigation.
Okay. And then at any point did you serve another term as a judge in Houston?
Got remarried in 2013, wanted to do something different, and reapplied to Governor Perry for a district court bench and was appointed in November 2013 to the 334th District Court, also in Harris County, same kind of court I'd presided over before.
Okay. And so in total, about how long did you serve as a judge?
I think altogether 10 years, okay, not including visiting judge service afterwards.
Okay. And then at some point, you become Deputy First Assistant at the Attorney General's office. Can you talk to us about what took you from Houston to Austin for that job?
Yeah, not to dwell on bad news, but in 2016, I, along with most of my Republican colleagues on the bench in Harris County, lost. And I went back in private practice for a couple years. My father passed in that time frame, and I stepped into a family business that needed more care than I could give it as a full-time litigator. So I juggled that with having left the law firm, being a mediator, an arbitrator, available to parties to resolve their disputes, and also a visiting judge when the administrative presiding judge in Houston appointed me to service in that capacity.
Okay. So what brings you to the Attorney General's office then? How do you go about applying for that job?
Well, it came sort of out of the blue. I had a call from my friend Austin Kinghorn, who I'd known for several years as a law clerk to one of the justices on the Supreme Court, and before that on the Court of Appeals. And he asked if I knew anyone who might be interested in working for the Attorney General. And I said, yeah, me.
Okay. I want to talk to you about that. It's no surprise we're here because there have been a lot of allegations made against Attorney General Paxton. You're aware of this, I assume?
Sure.
So when you get that call from Austin Kinghorn, you're interested in the job. Were you aware of all these allegations at the time?
Yes.
Okay. And can you talk to us a little bit about how you became aware of what was going on?
News reports, as probably most others did.
Was that concerning for you?
Yes, it was.
Can you talk to us a little bit about the concerns that you had after reading the news reports?
Well, I knew the reason they were calling and looking for people was because they had openings, and that was the good news. The bad news was these were serious allegations, serious charges that concerned me. And when I did go up to interview in Austin, and for that reason, probably unlike any other interview I've had, I took special time to press, in this case, First Assistant Brent Webster, on these charges.
What were your main...
Normally the interviewee is the one trying to sell him or herself.
You had to cross your T's and dot your I's. Can you talk to us about what your main concerns were coming into the Office of Attorney General?
You might be less interested in this, but I had kids at the time in high school and in junior high, so commuting back and forth to work was a concern. Where to live in Austin, it's not cheap, was a concern as well. So those were, I think you're asking something else.
Well, that's a fair concern, but I am also interested, like legally speaking, you're walking into an office where the Attorney General himself there have been allegations made to the FBI. Sure. And so what about that was specifically concerning to you in that situation?
Well, as I said, I spoke with Brent Webster when I interviewed, and I was much more pointed and brusque than I would normally be when I'm trying to get the job. And I knew he was a prosecutor, and by all accounts, a good one. So I pulled no punches. I pressed him, asked what I thought were fairly pointed, direct questions as to, okay, this is the allegations I'm seeing in the paper. What's the answer to that?
Kind of like a cross-examination a little bit?
A little bit. And it had an evidentiary quality to it as well, because he very patiently, I thought, given the busy nature of the office and the constraints he was under, took the time with me to walk me through the documents he'd assembled at that point.
Okay. Now, after leaving that conversation, can you talk to us about what your opinion was with regard to taking the job as Deputy First Assistant Attorney General?
Well, I satisfied myself that these charges were, in my opinion, then not well-founded. I knew as part of my job there were a number of interesting things going on in the office, but I also knew as part of that, like the Google ad tech lawsuit was coming. In addition to that, I'd be in charge of defending, I think it was then pending, the Whistleblower Act lawsuit involving these charges. So that was also a concern.
Right. So I assume you take the job because we're here right now.
I did.
All right. And I want to talk to you about, well, when exactly was it that you started as the Deputy First Assistant?
December 3, 2020.
Okay. So that's after everything kind of went down with regard to October and the reports to the FBI, right?
Yes.
You mentioned that you were a part of ultimately the whistleblower suit. Are you aware of reports that were drafted within the office?
Yes.
How many reports were there?
2.
Can you distinguish the 2 different reports that were drafted on behalf of the Office of Attorney General?
Yes, the first one started almost from the time I was there. The first I remember seeing a draft was sometime in January, I think early January, because I was still working from home right after the holiday. I remember that going through edits of 2021. And that was released by our office in August of 2021, publicly on our website.
Okay.
And that detailed the main whistleblower allegations and what our office, after forensically collecting documents, emails, exhaustively compiling everything, was able to put together to address these allegations.
And can you tell us who actually authored or published that report?
The Office of the Attorney General.
Okay. Now, is it safe to call that the internal report?
Yes.
Was there a secondary report that was drafted?
Yes, and if you have a copy, that would help me be clear and precise, but I believe it is on Louis Brisbois' letterhead or in the format of a memo to the Office of the Attorney General.
Objection, Your Honor. Testifying from a document not in evidence, testifying about a document not in evidence, and hearsay.
Thank you.
Sustained.
There's a report in existence, correct?
Same objection, Your Honor.
There are 2 reports.
He's not testifying with regard to what is stated in the document.
Overrule that. Go ahead.
Okay. There is an existence of a Louis Brisbois report, correct?
Yes.
All right, we'll get there. But before we do, I want to be very clear. You started in December of 2020, right?
Yes.
You've looked at both of these reports, the internal report and the Louis Brisbois report, right?
Objection leading, Your Honor.
It's only to lay a foundation, Judge.
I'm going to sustain, just,
Yes, Judge.
ask the questions one at a time.
Certainly. Are you aware of...
It's hard for me not to rule, by the way.
Are you aware? It's in their allegation, so I'll talk about it. Are you aware of the 2 reports?
Yes.
Have you read the 2 reports?
Yes.
Now, were you present at the Office of Attorney General during any of the subject matter involved in those reports?
I want to answer no, and I think that's right, but I would have to look at the reports to absolutely confirm. But I think everything that was detailed in both reports predates December of 2020.
Sure. Well, let me be more specific. Are you aware that the Office of Attorney General was involved in an open records request involving Nepal?
Historically, I'm aware. I wasn't there at the time.
Are you aware that they were involved in litigation with the Mitty Foundation?
Yes, again, historically.
Are you aware that there was an informal guidance letter with regard to non-judicial foreclosures?
Yes.
Now, were you present at the office during any of those events?
No.
Were you present at the office during the hiring of Brandon Kamek?
No.
So is it safe to say that you don't have personal knowledge of any of those events that are authored in the reports?
Yes.
All right. Give me one sec, Judge. I intend to get an exhibit for the witness. Copy for the court. Thank you. Mr. Dorfman, would you take a second to look at a copy of my exhibit numbers cut off? Attorney General Exhibit 23, and let me know whether you recognize the document.
I have looked at it and I do recognize it.
What is this document?
This is what you're referring to as referred to as the Lewis Brisbois report, the second report in time that our office released on these matters. Well, I say our office, this was outside counsel sending it to the office.
Okay. And is this a fair and accurate copy of the report issued by Lewis Brisbois on behalf of the Office of Attorney General?
Near as I can tell.
At this time, Judge, I would offer Attorney General Exhibit 23.
Your Honor, there's so much hearsay in there, I don't know where to begin. The document itself is hearsay. Within this document are conversations between people that are out-of-court statements that are hearsay. It relies on documents that are out-of-court statements that are hearsay. It also relies on people talking to other people who talk to other people, which is 3 layers of hearsay. So my objection, Your Honor, is hearsay squared.
Judge, may I respond briefly? My understanding, and Mr. Arroyo, if you would pull up Article 7, please. My understanding is that the House Board of Managers allegation in this case is that Ken Paxton and the Office of Attorney General issued a report that basically alleged false and misleading facts. This is a legally operative document in this case.
Your Honor, may I respond?
And the House doesn't want it in evidence? I don't understand how they can argue it's a lie if it's not even in evidence before the jury.
Your Honor, I hope counsel is not trying to mislead this court because this article of impeachment is based on the internal AG report. This report, the Lewis Brisbois report, came out after the article of impeachment. And so I'm sure counsel would like to retract his statement and not mislead this court. Regardless, this is so much levels of hearsay, and this thing up on the screen doesn't get around that.
I don't wish to retract my statement at all. I don't think that the allegation is necessarily clear, and I'm going to continue to argue that this is a legally operative fact.
I would suggest as an officer of the court that he retract it because this report has nothing to do with this article.
Come forward, gentlemen.
Thank you, Your Honor.
For the record, I had sustained that objection and it stands. Go ahead.
May I proceed, Judge?
Pardon?
May I proceed?
You may proceed.
Okay.
Hold on 1 second. Our jurors left the building for a moment. I did not notice. Give a senator a minute and they're gone. We will be taking a break shortly, members, okay? We've just been back 90 minutes and we normally take a break between 90 minutes and little bit more. I think we're still missing a few. That was a short meeting at the bench compared to other ones, so they were basing their exit on their experience here the last 2 weeks.
I could tell where it was going, so.
Good news is the cricket also left the chamber.
I just think we're more entertaining, Mr. Dorfman and I, so cricket's out of here.
I believe all are present and accounted for. You may proceed.
Thank you, Judge. Before we talk about the internal report, I want to talk to you about your time at the Office of Attorney General in December of 2020. Can you talk to us about what was going on as far as it relates to productivity in the office at that time?
It was a very busy time. I think I mentioned the Google ad tech lawsuit that had been years, as I understood it, in the making. We were about to release the complaint at long last in federal court. It was a huge and extraordinarily complex case. You're taking on Google, so I was told if I took the job, I would have frontline responsibility for, or at least overseeing that, and we intended to hire outside counsel. So that was a big part of that. At the time, of course, the election was still going on. There were still election challenges, and I know people were talking to the office about that. That ended up resulting in the Texas versus Pennsylvania lawsuits. My first week on the job, I think my first day on the job, we went to lunch.
I'm going to slow you down. I'm going to break that up, Mr. Dorfman. So you're talking about the election. I assume it's the presidential election, correct?
Yes.
Okay. And can you talk about the effect that that had on the workload of the Office of Attorney General at the very beginning of 2021?
Well, I had nothing to gauge it by, but it was extraordinarily busy time.
And did it appear that the morale, that people were working hard at the Office of Attorney General?
Oh, absolutely.
And despite the allegations that were made against Attorney General Paxton, people were still working at the office?
Yes, in my first 2 weeks there, I don't think I made it home before 8 p.m., certainly.
Did you have any, sorry to cut you off, but did you have any concerns about the work pace and workflow at the office?
No, it was fun. I mean, if that had been for the next 2 years, I would have had concerns.
Okay. As far as burnout goes or things like that, were there any concerns about anything like that?
Specifically December 2020?
More into 2021.
Yes, as 2021 went on, obviously the Biden administration came into office. Day one, people may remember this, a raft of executive orders. We were the first, and I'm proud of this, we were the first Attorney General, State Attorney General's office to obtain a preliminary injunction against one of those executive orders. It was the day one immigration order that imposed a 100-day moratorium on deportations, even where congressional statute dictated that removal must take place of a deportable alien within 90 days. And so we challenged that in court, federal court here in Texas, and won. And of course, there were other executive orders that we were challenging and filing lawsuits against. I was a voice in the office from a beginning then, but throughout this time, and as we continue to do the work, that look, it's great to be in court. It's great for our lawyers to go into court at the daytime and spend the whole day and file briefs at night, but you can only do that pace for so long. So I wanted us to be careful, husband our resources, use them wisely, pick the right cases, prioritize appropriately.
Utilize your resources.
To maximize the good work we were doing, okay. I thought.
Now, during that time in fall of 2020, winter of 2020, and into spring of 2021, are you guys working in the office or are you working at home at this point? Or is it a mix?
Where I was, everyone was in the office. Now, some of the attorneys in the divisions, the litigation divisions, did a combination.
Okay.
In a lot of the cases, the courts were shut down due to COVID still in many cases. So even though we had cases all over the state, you might have a hearing in San Antonio on this computer in your office, then you turn and have a Zoom hearing in Midland or El Paso 30 minutes later.
Understood. And
which helped, less travel.
Right. You said that you were Deputy First Assistant Attorney General. Are you aware of who your predecessor in that position was?
I believe it was Ryan Bankert.
Okay. Can you talk to us about your role at the time as the Deputy First Assistant Attorney General?
The core responsibility I had is to oversee the litigating divisions, both criminal and civil. As I'm not a criminal lawyer, never have been, never was a criminal judge for that matter, I rely very heavily on my criminal division deputy, it's Josh Reno, and to manage those responsibilities and report up to me and as needed. But the civil litigation divisions, I feel very comfortable overseeing them. In addition to that, I have overall responsibility at the executive level for policies, procedures. From time to time, I've also had direct report responsibility over human resources, as I do currently, and also over the communications team.
So a wide array of divisions.
Yes.
Now, are you familiar with whether at any point special litigation was under the oversight of your position, Deputy First Assistant Attorney General?
I don't think it has been since I've been there. I think it was at one time. Again, I don't know this personally.
And can you tell us now who oversees the Special Litigation Division?
Ralph Molina.
Okay. And then under Ralph Molina, or at any point in time, was it a Patrick Sweeten?
Yes.
Is he still working that position, moved to a different position?
He's currently our lead counsel in the Buoys case in the Rio Grande River, but that's on loan from the governor's office.
Did you have the occasion of working at the Office of Attorney General while he was in charge of special litigation?
Absolutely, yeah. I mean, until I think earlier this year, he joined the governor's office. Up till that point, he was there the entire time I was there.
Okay. Did you feel like you had to help him with his job, or did he appear to be qualified in handling his business in that position?
Patrick?
Patrick.
Very talented lawyer, very experienced, very capable. If I had one criticism of him, it's that he's in court more and managing less. We wanted him to clone Patrick Sweetens, so we had a team of Patrick Sweetens, but Patrick's so good and so natural in the courtroom, I think he longed to be there.
Okay. Do you feel that Patrick is the kind of guy that takes pressure off you if you didn't have to watch the Special Litigation Division?
Certainly. They're the Special Litigation Division for a reason. I think that was a creation of Attorney General Abbott to have the tip of the spear. We have a lot of litigating divisions. We have our General Litigation Division, which are outstanding. All our divisions are very good, do different things. And special litigation is you need to be at the courthouse in 30 minutes. We just found out the Obama administration's filed doing this. They've issued that executive order. No time, let's go.
Okay.
And so if I had to oversee that as well as everything else, you're right, it would put more pressure on me.
I want to fast forward and talk to you about the internal investigation report. You said you had no personal knowledge of the contents or the subject matter of that report, right?
Say that again, please.
You had no personal knowledge. You weren't personally there for the subject matter that is in the internal report authored by the Office of Attorney General.
I wasn't there at the time these events happened.
Were you present at the Office of Attorney General when the report was being drafted?
Yes.
Can you talk to us about who was responsible for that, and if you know what process went into drafting that report?
I think in the first instance, we relied on an office-wide forensic compilation of documents, emails, et cetera, that were relevant. Brent Webster took the lead in compiling that. And then we had a team, and again, as early as January, I was editing drafts with others, Josh Reno, later Murtaza Sudarwala, our deputy for legal policy, Austin Kinghorn, Enrique Varela. There were others, but I may have left them out.
Okay. And can you talk to us about what your role was with regard to the publishing of that report, or at least getting the report ready to be published?
Well, I don't think we published it until August of 2021, and that probably is a reflection, one, of just how busy the office was and how much other stuff there was to attend to. But I'm sure I had revised and edited and redlined at least 5 or 6 times the entire document front to back.
Okay. Now, understandably...
and others did as well.
Right. Understandably, you weren't present for these events that the document summarizes. Did you play a hand in trying to find documentation to support the positions taken in that report?
More oversaw that process.
Can you talk to us about your oversight of that process?
Yeah, I felt very strongly this had to be, it was going out as a report of the office. I believe the Attorney General had said, look, these allegations are baseless and I will investigate and present the facts and let the voters decide. Words to that effect. I wasn't there. And so this was a fulfillment of that commitment. I took that as a charge to lay it out there. And I think it's fair to say that the document, my emphasis throughout this process of editing was, look, this needs to be the voice of the agency. It's not any one person. It's all of us, and it's objective. It's factual, both in tone and substance. If we make a conclusion or from the facts that we presented from the documents that isn't supported by the document, let's not make that conclusion. Let's take that out and let the people reading it make their own decisions.
And so really, you're just trying to make sure that they're not making allegations that they can't back up.
Objection, leading.
Sustained.
Would you agree that your job was to make sure that the claims were verified?
Same objection, Your Honor.
Sure. Was it your job to make sure that there was evidence or at least something to corroborate statements that were made?
Was there an objection there?
Not to that, Your Honor.
I didn't think so. Okay.
I certainly viewed that as my job, yes.
All right. Now, you mentioned earlier that at some point you get involved into the lawsuit in this case, and I want to talk to you about the lawsuit, okay? Can you tell us your understanding of when the whistleblower lawsuit was first filed against the Office of Attorney General?
I think it was November of 2020.
Okay. Can you tell us who the named parties within that lawsuit are?
Going to struggle on their first names.
No problem.
Ryan Vassar.
Okay.
Mr. Maxwell's first name is
David Maxwell.
David Maxwell. Thank
right.
you.
Mark Penley, ring a bell?
Mark Penley and Blake Brickman. Sorry.
Okay. And more focused on who is the named party or the named defendant in that lawsuit?
There's just one defendant, the Office of the Attorney General.
Okay. Was Ken Paxton specifically named as the party to the lawsuit?
No.
All right. So it's the Office of Attorney General on the filing?
Yes.
And what is the first thing that you all do? Who all is working on the lawsuit with you at this time?
About the same time I was interviewing, I think they were interviewing for outside counsel, so I knew Louis Brisbois had been hired, and either the first or second week we might have had a phone conference or meeting with them. At that point, I think the lawsuit had been amended at least once. There was later a second amended, and so I was working on it. Austin Kinghorn was working on it. The first assistant would have been involved.
How about Chris Hilton? Was he working on it?
I think that's right. I think Chris Hilton was also from the start there. He certainly was later.
Sure.
Enrique Varela as well, who worked with Austin Kinghorn.
And I'm going to cut you off. You mentioned Louis Brisbois. Can you explain to us what Louis Brisbois' job was with regard to the whistleblower lawsuit against the Office of Attorney General?
To be outside counsel, Bill Helfand is an attorney I've known in Houston for at least 20 years. Very good lawyer, specializing in government work, especially defense like Section 1983, federal court lawsuits, many of which, if not most, have an employment quality to them. The sheriff being sued by his deputy, something like that.
And just without getting into the contents of the document that I showed you earlier, the Louis Brisbois report, was that authored by the attorneys that were outside counsel for the Office of Attorney General?
Yes, Mr. Helfand and others.
Okay. Now, in that litigation, did you all file a plea to the jurisdiction?
Yes, we did.
Okay. Can you explain to us what a plea to jurisdiction is?
A plea to the jurisdiction is a document that says to the court, every court must first assess whether it has,
speaking of the microphone.
Every court must first assess, that was too loud, whether it has jurisdiction to entertain a lawsuit. And the state of Texas cannot be sued for money damages without its consent. And this body and the House are the ones that must expressly waive by statute the immunity from lawsuit, the sovereign immunity of the state of Texas, in order for a plaintiff to recover money damages. They argued, the plaintiffs in this case, that
I'm going to stop you and I'm going to break that down. You know, I didn't go to Yale, so you got to make it slow for me. Mr. Arroyo, would you please put up Article 8 onto the overhead screen? So essentially, pleaded jurisdiction. Well, let me ask you this. Is that something that is commonly filed in lawsuits in your experience as a civil litigator? Or at least with regard to Office of the Attorney General?
I was going to say, at the Office of the Attorney General, I'd say probably 90% of our defensive cases, at least the ones I'm most familiar with, we file pleaded jurisdiction. Almost every case challenging the most recent enactments of the legislature arising out of the last session, which have been, all those legal challenges have been brought in the last few months. We filed pleas of jurisdiction, I think, in every one of those, saying this suit can't go forward. The court has no jurisdiction. The state is immune.
Okay. Now, Eric, if you could just blow up the second paragraph specifically all the way down to, well, this part's fine right here. If you could blow that up. Okay, so I'm just going to read the Article 8 to you, Mr. Dorfman, which states that specifically Paxton entered into a settlement agreement with whistleblowers that provides for payment of the settlement from public funds. The settlement agreement stayed the wrongful termination suit and conspicuously delayed the discovery of the facts. The next page goes on to say, and testimony at trial to Paxton's advantage. Sorry.
Let it get up on the screen. Yep. Okay, continue.
To Paxton's advantage, which deprived the electorate of its opportunity to make an informed decision when voting for Attorney General. So at what time did we know that the lawsuit was filed in November of 2020. When was it that the Office of Attorney General actually files the plea to jurisdiction?
Not exactly sure, but I believe it was January of 2021.
Okay. And when did the Office of Attorney General engage in settlement agreements with the whistleblower plaintiffs in this case?
Almost exactly 2 years later.
Okay. So when we're talking about the plea to jurisdiction, we are 2 years before settlement discussions even come into play, right?
Right.
Now, I think in your motion for plea to jurisdiction, it was in two parts, correct?
I'd have to see it.
Well, did you talk about sovereign immunity?
Absolutely.
Can you explain to us how sovereign immunity comes into play in your plea to jurisdiction?
Well, I think I've covered that. The state is immune from suit unless there's an express statutory waiver from the legislature.
Okay. And then the second part of that was that you talked about separation of powers.
Yes.
Can you talk about that too?
Well, let me go back and cover the first one, if you don't mind. May I, Your Honor?
If you'd please go back and cover
I need to qualify my comments. What you're describing is, you've reminded me and refreshed my memory that yes, the Whistleblower Act is exactly the type of express statutory waiver of sovereign immunity that allows one to sue the state, in this case for money damages. But the case law has been clear, and we argued it, that unless you meet all the elements of a Whistleblower Act claim, there is no waiver of sovereign immunity. There's no jurisdiction for the court to proceed. And we alleged that the plaintiffs in the case had not met their burden of establishing all the elements of the whistleblower claim, and therefore sovereign immunity still applied.
Okay. And was that file in the plea to jurisdiction, was that made in good faith and based on your legal research?
Yes.
All right. Now I want to focus back onto the article that states specifically, if you'd go back to the other page, Eric. It talks about, and you zoom in, the settlement agreement stayed the wrongful termination suit. I just want to be clear, when you all filed the plea to jurisdiction, that had nothing to do with the settlement agreement, right?
We weren't even discussing settlement at that time, no.
Okay. Now, what is the result of a plea to jurisdiction with regard to discovery in a lawsuit?
The plea to jurisdiction, again, every court must first assess whether it has jurisdiction. If it doesn't, it's powerless to order discovery or proceed any further. And the the legislature has passed an interlocutory appeal so that even if we lose the plea to the jurisdiction, if we win, the case is over and dismissed. If we lose the plea to jurisdiction, we have the right to immediately appeal when normally you would have to wait till the end of a case to file your appeals. And the immediate appeal stays the court's jurisdiction. It can't proceed further in any capacity until the appeal is resolved.
Okay. Now, was that plea to jurisdiction filed to stop the discovery getting out to the public in this case?
I don't understand your question.
You just said that a plea to jurisdiction essentially stops the discovery from occurring in a lawsuit, right?
It stops anything from occurring in the trial court.
So my question to you is, when you all filed a plea to jurisdiction, did you do so because you felt that the law applied in that situation, or did you do so because you wanted to stop discovery from getting out to the public?
We did it because we thought the state had sovereign immunity, and it was our duty to assert that, as we do in so many of our cases. That does have the effect of stopping discovery from going forward and saving the taxpayers the expense of that discovery and our lawyers the time that, discovery really is where the time gets taken in trial cases.
Okay. I want to talk to you about the procedural posture of the plea to jurisdiction. Can you talk to us about the first court that ultimately ruled on you all's plea to jurisdiction in the whistleblower lawsuit?
The first court?
Yes.
That was the Third Court of Appeals here in Austin.
Well, did it go to the district court prior to that filing?
I'm sorry. Yes, you're right.
Can you talk to us about that?
We had some discussions back and forth. I don't know how much detail you want to go into, but with the plaintiff's attorneys about scheduling a hearing on two things. They wanted to have a temporary injunction hearing. I think initially they said they needed 4 days. The only purpose of a temporary injunction hearing in this context would be for Mr. Maxwell and Mr. Vassar to seek reinstatement under the Whistleblower Act. So to be reinstated to their position with the Office of the Attorney General.
So are you saying that Mr. Maxwell and Mr. Vassar actually wanted to come back to the Office of Attorney General?
Yes, and I think that's still in their live pleading. Well, they're pleading, I shouldn't say live.
Right. Now, what was the ultimate decision by the district court with regard to that plea to jurisdiction?
Well, so we were trying to schedule the plea to jurisdiction before, 1 week before, something, 1 day, whatever, because the court can't have a temporary injunction hearing until it's heard and ruled on the plea to jurisdiction. The plaintiffs requested and the court agreed to set them on the same day, but that had the effect of meaning before the judge ruled, we were set to a temporary injunction hearing, which got underway and started. And there was even testimony taken, I think, from Mr. Mateer for some time before we got the Court of Appeals to agree that by proceeding with the temporary injunction, she had implicitly ruled, the judge had implicitly ruled that she had jurisdiction. And
so ultimately, and I'm going to cut you off, ultimately the case goes up to the Third Court of Appeals?
Yes.
Okay. So the district court didn't rule on the plea to jurisdiction necessarily?
I'd have to go back and check. I think she may have written an order expressly denying it, but not until after we had already gone up to the third court and said, we need intervention.
Okay. And can you talk to us about what happened at the Third Court of Appeals?
They said oral argument, and I can't remember exactly when that was, but I believe it was October of 2021 when they issued their opinion, maybe 30 pages.
So almost a year later, while that plea to jurisdiction is still pending, right?
Well, the plea would have been filed in January, I think, and so you're talking 9 months later.
Okay. And can you tell us how the court ruled, the Third Court of Appeals ruled?
The Third Court of Appeals agreed with the plaintiffs that the trial court had jurisdiction, that our reading of the Whistleblower Act on the two prongs you mentioned was wrong. Well, they disagreed with it.
Okay. And in response to the Third Court of Appeals ruling in that case, what did you all do on behalf of the Office of Attorney General?
We appealed that to the Supreme Court of Texas by filing a petition for review, asking them to take the case and reverse the Third Court's ruling.
Okay. Now, do you recall when the appeal to the Supreme Court of Texas was filed?
not exactly, it would have been within 30 days, maybe 45 of that October, I think 2021 opinion from the third court.
Okay. And at this point in time, what is going on with the litigation in the whistleblower lawsuit?
Only the appeals process.
Counselor, excuse me, I promised a break about 15 minutes ago for the jurors. They've been in a 2-hour sit down.
Now's an okay time
Is
to
this
stop,
a good
Your
time?
Honor. Sure.
I don't want to interrupt, but it's a good time. Members, it's 5 minutes before 4. Come back at 4:15, 20-minute break.
Okay, so Deandra,
We'll stand at ease.
is this helping?
I don't even know what this guy's doing. I mean, I guess they're trying to show that there was no intentional delaying of the court case to impact the election.
Right.
I don't know. It's pretty dull.
Yeah, we had testimony from one of the whistleblowers that talked. Oh, that was Brickman. It was Brickman. Yesterday we had testimony from Blake Brickman talking about how when the Attorney General's office argued that the Attorney General was not subject to the Whistleblower Act, that stopped discovery. So they seem to be, like you said, making this argument that the stoppage of discovery, that it was coincidental that it happened to coincide ultimately with an election, and then they, after the election, decided to enter into settlement negotiations.
Big settlement negotiations, big money.
$3.3 million worth.
Well, you know, I've learned throughout this trial that there are no coincidences in Austin, so I'm just going to go with that. Learned a lot of lessons in this trial. I've learned don't ever go to Starbucks with Ken Paxton. I've learned this whole thing about coincidences in Austin. So I'm sure that it had nothing to do with the election.
So when they get him on cross, if you were cross-examining him, what would you do?
Probably I'd start out with the fact that this guy made some statements thinking that all these firings were justified when he has no personal knowledge about any of this. I mean, he didn't even come on board, I think he said, to what, December?
Yeah, it was
of
later
that
on.
year.
It was
So,
after pretty much everything had happened.
I don't know. First there's that, and then he was talking about how busy they were with Google, and then somehow he's got all this knowledge about this. I don't know. I'd kind of go after his knowledge base and what conversations were going on as far as their decisions to fight this thing and then suddenly cave as soon as the election's over and decide they're offering $3.3 million.
Well, and he said he oversaw the drafting of the report, and he said that he wanted it to be, quote, the voice of the agency and to be factual both in tone and substance.
Well, I wonder if he interviewed any of the whistleblowers before he got his factual in tone and substance report.
I don't know. They'd all, at that point, they had all been quit, resigned,
I'm sure they
fired.
had phones. Could have called them. Could have called their lawyer. Asked for their side of the story. I mean, these guys. But, you know, he seems like a nice enough guy. I mean, he's, I'm not sure why he's here, I guess is it.
The only thing I can figure is just that he's there to rebut the claim from Blake Brickman that that the timing of the settlement negotiations had to do with the election. That's the only thing that makes sense right now.
Yeah, it's just all coincidental that it all happened at the same time. I'm going with that. It's working for me.
Okay.
What do you think, Bud?
Well, the interesting thing I thought was the little kerfuffle with OSO over what was admissible and which report they could use, and you know, it seemed like that the defense got slam dunked on.
Len Dutko called it hearsay squared.
That's right.
Yeah, that was good. I've never heard that before, but it was a really good
the hearsay
description.
inside the hearsay inside the hearsay
about hearsay. So.
Yeah.
You going to try using that sometime?
I actually may steal that. He was very good. I liked his cross on these people. I don't know if he's doing it on this next one, but he's very good.
I would assume he is, because he's the one. So far, whoever's doing the objections is the one that then does the cross.
Well,
so.
I think he's excellent. I wish we'd heard a little bit more of him before today.
Well, we're seeing some really good lawyering, I think, from some of the, from Aaron Epley and Mark Donnelly and Dutko, who we've not heard from before today. And I was telling someone, I feel like we've got a new legal legend in Aaron Epley, because she's pretty good.
Now, I thought Allison Collins did a good job this morning on the defense side.
She did.
She has a very nice way about her.
A good demeanor.
She's very nice demeanor. I thought she did a good job.
But I've been waiting to see if you suddenly see Busby or Cogdill or Mitch Little come swooping in to rescue the defense lawyers who have struggled with some of these witnesses.
I think of the three, Allison Collins was probably the most effective on the defense side today.
Okay. I want to go back and talk about, because I think it was, and I think we all agree that it was pretty powerful when Dutko is questioning, let me go back into my notes, the HR guy, De La Garza, about, the firings, the Whistleblower Act. And I started to read this email from this employment law attorney while they were a minute ago, and I thought this was just fascinating what she had to say. Let me pull this email up. She said that De La Garza did not provide a complete current definition of at-will employment. That doctrine has existed since 1888 based on a Texas Supreme Court decision in East Line and Red River Railroad versus Scott. A reason that has to do with the reasoning that when neither party has expressed a period of employment, either party may terminate at any time. And she says that when that ruling came down in 1888, there was no whistleblower or anti-discrimination laws. Currently, and this is quote, currently an employer cannot use at-will status as an absolute right to terminate, all in caps, if the termination was for an illegal reason, i.e. whistleblower retaliation. Timing is also an issue. If an employee blows the whistle and then an employer suddenly, quote, finds, end quote, reasons to terminate, such conduct starts to smell more like retaliation than a legitimate reason for termination. Using an, quote, insubordinate, end quote, tone doesn't smell very good.
I agree with that. I think that's a very good analysis. I think when you have 8 people go to the FBI and then suddenly all of them are gone within 30 days, 40 days?
Within 6 weeks, a combination
I think it was about a month and a half, right?
Yeah, so September 30th of 2020 is the day they go to the FBI, and that is the day, let me see. I believe September 30th is the day they got wind of the second bank subpoena. I think the first bank subpoena was the 29th, but the 30th is the day they go to the FBI. October 1st, they notified HR and the Attorney General. October 2nd, Penley and Maxwell are put on A-time. October 13th, Maxwell files a formal complaint. October 14th, some of the others file formal complaints, and then 19 days after they go to the FBI, you start to see firings, and then we got people fired November 2nd, and you just a combination. So pretty quickly, you got people being fired.
Well, I'll just point out that these 22 Republicans in the Senate are all conservatives who are not generally supporters of organized labor, and like the idea of themselves led arguments about Texas being an at-will state, and they're probably not in love with the whole idea of arguing based on labor law or protecting labor. So arguing the nuances of firings probably doesn't go over well with the Republican majority.
No, and I think that when you're a conservative on the right, that you are a rule follower. You believe that rules exist and the laws exist and you're supposed to follow them. And firing people based on whistleblowing is against the law. You can't do it. You open yourself up to civil litigation, which obviously happened. I would be interested, and I don't know if anyone ever looked into this, was anyone else fired from the AG's office in those 6 weeks?
Besides the whistleblowers? I don't know.
I just would be curious to know if these were the only people fired. But it was only 6 of the 8, right? Because didn't 2 resign?
Let's see.
I mean,
Right.
one.
6 are the whistleblowers.
A couple of them resigned, and I'm
2
losing.
of them.
Mateer resigned.
Okay. They took all his duties away, right?
I don't know.
Somebody
Probably.
said
There's
they resigned.
There's people that lost. If they start to kind of run in my head,
Yes.
and I want to be careful about what I say about each one because it's. But I know Mateer resigns, and then you have some people like Brickman.
Brickman's a whistleblower.
And he's fired, but he's basically told, you can resign or be fired, and so they fire him. That's what he testified to yesterday.
I thought Mateer, Bangert, Vassar, and Brickman were the whistleblowers.
Well, whoever were the whistleblowers that got fired, I'm just curious if anybody else was fired during that time. But, I mean, it really defies belief that educated attorneys are sitting around the AG's office thinking we can just come up with HR reasons to fire these people. Probably it's all going to be okay. And I would love to have been a fly on the wall during those conversations of how they're going to justify firing all these people.
Well, and they wrote a memo.
Yeah, they did write a memo.
And the Third Court of Appeals didn't. The Third Court of Appeals dealt with the question of whether or not an elected official was subject to the Whistleblower Act. So Jay's going to bring up this, and I want Bud to kind of talk about it. He's going to bring up what it takes to convict or not to convict.
The numbers?
Yeah, and he doesn't really like the word convict, actually.
I had the numbers. Well, we're not convicting anybody of anything here. There's nobody on trial or facing any allegations. It votes to sustain articles of impeachment.
What are the colors?
What we're discussing here.
What are those colors?
But these are basically, so you have 31 senators.
Okay.
You have the 12 Democrats that we are likely to vote in favor. And then what has to happen in terms of with the Republicans, one way or the other.
You have to have 9 Republicans to vote with the 12 Democrats in order to get to 21. So you see the 9 Republican blocks that are purple there. They have to vote with the Democrats in order to remove Ken Paxton as Attorney General. The presumption is, based on the pretrial motions, there were from 6 to 8 Republicans who voted to continue with the trial. So you believe going in that there are from 6 to 8 Republicans who are in those red seats, that probably more once the trial's over would be in those red seats and would be in favor of keeping Ken Paxton. The number that he's looking for, it takes 21 in order to remove it. 20 to 10 vote means that the articles fail, the motions fail. It takes 21 in order to remove him from office.
But you basically said, Bud, this morning that you feel like there's not the votes to sustain.
I have said all along that I did not feel like there were the votes to sustain the articles of impeachment. I felt like going in that it was within a vote either way, and that the trial might push a vote one way or the other. It would be a question of whether the prosecution brought such a strong case that a senator would feel confident going back out for re-election and saying, well, now look at this case. If there was so much attention brought to it and so much thorough feeling of wrongdoing that the voters themselves were convinced, then another senator might feel like they could go out and vote for removal. I'm not sure that's happened. I still think it's within a vote either way. I think it could be 20, it could be 21, and I think that really is still up in the air. I think that there are times at the beginning of the trial, I thought early in the trial, I thought that the prosecution was making some headway and might have gotten that 21st vote, that 10th Republican, and that 11th Republican, and then I thought, well, maybe not. That maybe they've lost some ground. So, it only takes 10 Republicans to save Ken Paxton.
Well, and keep in mind that in a criminal trial, you're not going to have people tweeting their support of the defendant to get to the jurors. You're not going to have phone numbers of jurors put out for people to call their offices and try to pressure them, and you're not going to have threats of running people against them in the primaries if they don't vote the way you want. That doesn't happen in a criminal trial, which is another reason this is such political theater.
And there is a political element to it of opponents. But, you know, I don't think most of these senators are very worried about an opponent. They have the incumbency, they have the strength of being incumbents. It would take a really well-known challenger to unseat an incumbent.
Oh, yeah, and money.
And you know, considerable amounts of West Texas money. That money's going to be there, but the candidate may not be there. So I don't think the concern about the challenger is that strong, but it might swing a vote one way or the other. You know, I was going to talk about the term rhino.
Yeah, let's talk about it.
That was good.
Some of these questioners, they've started out right away and said, "Are you a rhino?" You know, and that's been one of the direct questions. And everybody talks now about, "Are you a rhino?" Donald Trump's message on social media said, "Oh, these rhinos, rhinos, rhinos." You know, Donald Trump has made the term rhino mean anybody who's against me is a rhino. It's kind of replaced the never Trumpers.
Right.
You know, now the people who used to be called never Trumpers are called rhinos. The term rhino first appeared in the 20s of the 20th century, in the 1920s, in the Manchester Union Leader, was one of the most conservative papers in the country throughout the 20th century. Referred to some rhinos there, but then it really wasn't in common use. In the 60s and 70s, we talked about the Rockefeller Republicans in the party. They were the business Republicans. They were called the Country Club Republicans. They were the Rockefeller Republicans. And then it was not until the late 90s and the Clinton administration, after the Contract for America, after Republicans had started using the rallying cry that the pro-choice movement is baby killers, after that kind of language was used, that Republicans started attacking everyone, first of all, if they were in favor of abortion rights, something that doesn't exist in the Republican Party anymore, then they were rhinos. Or if they were in any way willing to negotiate with Democrats or work with those baby killers or even compromise with those baby killers, then they must be rhinos. It rose again in the 90s in the California Republican Party and then became applied nationwide. And so you went on, you had people like Speaker John Boehner and Mitch McConnell today, and of course Mitt Romney, the various Republicans who've been labeled as rhinos over the years because they didn't toe the line of either the party platform that it was written in the state level. The party platform is written by those few hobbyists who make their point to go to regional and state conventions, without really any input from anyone else. They go down and make things up, and then they think that everybody else should follow the things that they went off on their own and made up. The strain between elected Republicans and the delegates was so strong that last year Governor Greg Abbott didn't even speak to the state Republican convention. He held a reception of the party across the street because the state Republican the actual members of the party, the delegates, are so hostile to elected office holders that they don't even socialize with them. They don't even get involved with them anymore. But the term rhinos now, Donald Trump made it in 2016, made it into an across-the-board term for everybody who's against me. And this is part of the new loyalty oath that the Republican Party preaches, is that you're either for Trump or against Trump. You have to be for Trump all the way and do everything for Trump, whether you think it's legal or illegal, whether you think it's right or wrong. You must be for Trump. And that we see this same kind of argument in the Ken Paxton defense, that when the lawyers say that they didn't work for the state, they worked for Ken Paxton. You see this kind of idea that somehow the loyalty to the office holder is more important to than the loyalty of the people. But Donald Trump's appropriation of the term rhino and making it into something, which is really ironic, because Donald Trump himself was a Democrat until 2009. He was a registered Democrat, and so he's only been a Republican
and a donor.
now. What's the math on that? 14 years.
Right.
He's been a registered Republican, but now he can determine who is a rhino. And so he's used the term rhino to mean they're against me, and he labels everybody else, all the people we used to call never Trumpers, now you're a rhino. And now we see all of the great echo chamber on social media using the term rhino too. The social media commenters, many of whom are paid, we know, $50 a comment, some of them, we see all of them echoing that if you're against Ken Paxton, it's all the rhinos and the terrible rhinos who are trying to get rid of them, rhino, rhino, rhino. And so it's become a very different term even than it was in the 90s or the 2000s.
Well, what's interesting in this case is these so-called whistleblowers, and I don't really like calling them that, but just the group, the fired ones or whatever, are some of the most conservative people you're ever going to find. So to label them rhinos is actually kind of funny because it's ridiculous. It's absurd. These are not Republicans in name only. These are very conservative, right-wing Republican people who are the ones that are lost their jobs, went to the FBI.
It's almost like the world's a little bit upside down.
It's extremely upside down. I mean, it doesn't matter for any particular purpose, but I mean, I'm a Reagan big tent conservative. I have been for many years, ran as a GOP candidate multiple times in Dallas, and was president of my Republican Women's Club like 4 times. And I guess maybe I'm a rhino. I don't know. Maybe I am. Today I would be.
And women's clubs, and Republican women's clubs in general, are suspected of being rhinos and have been threatened with, removal from the party because they're not going along with the more manly leadership that some of the candidates want. We've had Republican candidates who said that only men should be elected and things like that. So, but the whole use of rhino has changed. Certainly, the business fiscal conservatives, are being labeled as rhinos even when they're the strongest fiscal conservatives. And then you have some of the there is a division in the faith and values conservatives. There are the strong Christian believers who believe that for all Donald Trump's or Ken Paxton's flaws, they are leading America to be more Christian and to be ruled by Christian faith and values for all their personal flaws, that they're anointed by God to make the nation and the state more Christian. Then you have another set of Christian believers who believe that the way to lead people to Christ, to win souls to Christ, is to model Christian values and Christian beliefs.
Christian witness?
And they believe it's a Christian witness, that these are not, that Ken Paxton is not a valuable Christian witness. And so Dan Patrick has written a religious book. I mean, you have many people of deep faith in the Texas Senate, and you probably have some who fall in both categories of the Christian faith movement currently, the religious conservative movement. The faith and values conservatives who are not so on board with the whole Christian domination policy believe in more of a Christian democracy where Christians are elected, Christians win elections fairly, Christians pass bills with fair representation for everyone, and all religions are included, and America's a nation for everybody. And so you really have this division over whether Christians should boss everybody or lead everybody.
Well, interesting. Just look ahead to closing arguments. I'm going to be fascinated to see who argues, because there have been so many lawyers involved on both sides.
You mean who does closing arguments?
Yeah, who does the closing argument for each side? I'm sure they'll probably split it up, which is normal, which is you get allotted X amount of time and one lawyer does this portion, another lawyer does this portion. But with this many lawyers, and I think you said they were only getting an hour.
Yeah.
Is that right?
For closings, yeah.
It'll be interesting. Some of them are probably very good orators and might be more interesting to listen to. So I'm excited about closing arguments. I would like to hear. I'd like to hear a bit
she's
from
got
Rusty.
my vote.
It'll just be interesting.
DeGaren's really good at closing.
It'll be interesting to see who bats cleanup for both sides.
Yes.
I mean, it feels like for the defense it will be Busby. It's hard to imagine Busby giving up the closing.
He's getting the big check.
He probably wouldn't do all of it. Maybe he'll break it up. I mean,
and I think for Hardin, for the prosecution in the same way.
That'd be good.
Because he's there to appeal to the senator.
And you've got to go through each, and it's a lot to do in an hour, but you've got to go through each 16 of them, and you've got to say, we proved it with this and this and this testimony and this evidence, and then the other side's got to do the same thing and say, and they didn't prove it because of this and this and this, and that's how it works.
Do you have closings already written at this point?
When I try a case, I usually have a theme that I carry throughout the whole trial, so I know where I'm headed. So I know what I'm going to be doing at the end. Now, trials are easy to prepare for, but when you're trying a case, it can all fall apart. Like, you can have a theme and then things happen, people say things you didn't expect, all kinds of things can happen, and you have to sort of change your theme. That's happened to me before. But generally speaking, I would say I have the basic outline of what I'm going to say at the very beginning.
So let's talk about that. So
What do you say?
theme, let's start with theme for the prosecution.
Theme for the prosecution, I think, is going to be kind of what I just described, where you're going through each one, and I would do a lot of visuals. I might even have a photograph of each witness and how they proved, what evidence they gave towards that particular article of impeachment. So, because there were a lot of people testifying, and you can tell by the way this room is laid out, in a normal trial, the jurors can see each witness because they're really close to them, but you see how far away all the seats are? If you're in the back, you maybe didn't see them very well. And so I would like to have a little photo of each witness and their name and a little summary of how I think they added evidence to prove that impeachment, and have a lot of visuals. Kind of like the timeline you said, how powerful the timelines can be. Kind of an infographic of each one of the impeachments, I would think would be a very good way to go. And then
theme for the defense?
It really is going to depend on who is doing the closing arguments. If it's Busby, you know, there's going to be a lot of stomping and yelling because that's kind of his bombastic style, which has worked very successfully for him in his career. And lots of probably sarcasm and this is ridiculous and all the kinds of things we heard during his cross-examination. And then he's probably going to get up and say, in this article, they didn't even come close to we can just throw this one out. They didn't even come close, and do a lot of this dramatic stuff.
Right, because that's kind of par for the course.
Let's just throw this one. Let's just throw this one. Let's go to this one. They didn't throw this. Let's throw this one out.
He's got to do 16 of them.
Yeah, I think
maybe he'll have 16
pieces
of paper or something. You know.
You know, he's a very dramatic guy. I expect it to be fun.
You know, one of the things we were talking about yesterday with Victor Vital is that, you know, all this, you know, rules of evidence, and I mean, because I've watched a lot of trials, but it's pretty rare to have, you know, lawyers, you know, subsection this of rule T, blah, 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 blah.
Yeah.
I mean, almost like, is this going to be played in law schools, like a legal clinic?
Well, Erin should be, because I'll tell you what, she was ready. She was ready for objections more so than, you know, just about anybody else. She was really ready.
She had her rules down.
But the guy today, what was his name?
Dutko?
Yeah, he was really good too.
I noticed
he was
somebody
making good
tweeted
objections.
and said, I want to go out to commit crime just so Erin can defend me.
Oh yeah, she's excellent.
Bailiff can
Very
bring in the
impressive.
witness, please.
Oh, here we go. We're back in.
Bailiff can bring in the witness, please. We have all the jurors. Mr. Asso is the correct pronunciation. I want to be sure I have that right.
Thank you, Judge. Mr. Dorfman, we were just talking about the effect that a plea to jurisdiction actually has on the discovery in the case. Now, I want to focus, Eric, if you wouldn't mind focusing on the next page, top paragraph, which is the bottom paragraph of Article, bottom paragraph of Article 8. I want to read that to you. Testimony at trial to Paxton's advantage, which deprived the electorate of its opportunity to make an informed decision when voting for Attorney General. Now, throughout the course of the lawsuit that the whistleblowers filed, are you aware of whether specific facts or allegations became public? And could you turn your mic on, sir?
Better?
Okay, I'm going to re-ask that question.
Please.
Were you aware of whether the specific facts or allegations with regard to the whistleblower suit became public?
Yes.
Can you tell us about in which ways, if you know, they became public?
Well, we talked about that earlier before I came to interview at the office. There were news stories that contained allegations made by the whistleblowers. It was about that same time, maybe a little later, that the lawsuit was filed. That was a news story and a very detailed state court petition that's public record, public filing, covered in the press accounts. And then I think they amended that petition twice between the original filing and early February. So there was a first amended maybe in December, and then in February, just before the plea of the jurisdiction hearing and the temporary injunction hearing, they filed a second amended petition, which I think is the last one. But that's 63 pages, very detailed allegations.
And I'm going to stop you real quick just to clarify. When you say they filed and amended petitions, can you talk to us a little bit about, well, who filed those petitions?
The four plaintiffs through their lawyers.
So David Maxwell, Mark Penley, Ryan Vassar, and Blake Brickman?
Yes.
And did those petitions include specific facts that they were alleging
Yes.
Attorney General Paxton and the Office of Attorney General committed?
Yes.
Okay. And those pleadings were actually available to the public, correct?
Yes.
You can look them up online?
Yes.
Okay. So, Eric, if you don't mind going back one page to the bottom paragraph, bottom clause. Article 8 alleges that Paxton entered into a settlement agreement with whistleblowers that provides for payment of the settlement from public funds. The settlement agreement stayed the wrongful termination suit and conspicuously delayed the discovery of facts. Is that allegation true?
No. Can I explain?
Please do.
The settlement agreement didn't stay the wrongful termination suit. It was on appeal, and our petition for review was pending with the Supreme Court of Texas. That court doesn't have to take any case it doesn't want to, so you have to convince it to take the case. We had made a case. Filed 2 briefs to do that.
I'm going to stop you because we're going to get there, and I want to break that down.
Sorry.
But with regard to conspicuously delaying the discovery of facts,
the settlement agreement didn't do that.
And weren't the facts available to the public at this point anyway?
More than we discussed. Obviously, the petitions I mentioned, but the Court of Appeals decision is 30 pages and has bullet point block paragraph recitals from the pleadings. Mm-hmm. So it was restated the most serious allegations that the complaints, the petitions made, were restated in the Court of Appeals decision, which also garnered news attention when it came out.
Right. And you had talked about, I think, opposing counsel actually held up a document that was the Third Court of Appeals decision against the Office of Attorney General in this case, correct?
I'm sorry, what was your question?
Essentially that the Third Court of Appeals ruled against the Office of Attorney General.
Correct.
So you filed what with the Supreme Court?
A petition for review. An appeal, notice of appeal of the Third Court's decision with a petition for review asking the Supreme Court to take the case.
Can you explain to us, I deal predominantly with criminal law. Can you explain to us kind of how the process works when you file a petition for review with the Supreme Court of Texas?
It's in the form of a brief, very much like what we would call a merits brief, but it's not. It is simply an argument for why this case is sufficiently important to be one of the 100 or 110 cases that the Supreme Court can take from the entire state and rule on. They only hear so many oral arguments or take so many cases. So you have to convince them this is worthy of their attention. We tried to do just that.
Okay.
Our opponents filed a brief between our initial and reply brief explaining to the court they should not. They should let the Third Court of Appeals case stand, in which case the case would have then gone back to the trial court.
Okay. And so the Third Court of Appeals ruling was actually up for appeal, right?
Yes.
Was that ultimately ruled on, that appeal?
Not to this day, no.
Okay. Can you talk to us, are there certain sessions or time periods where the Supreme Court tends to hear cases?
I think that's right. I would defer to people, bless you, who argue in front of the Supreme Court for a living, but yes.
Okay. Do you feel that, I guess at any time, the Supreme Court can pull your case out of a hat to hear it, right?
I think that's right. They usually confer as a body, I think in person, although maybe by remote sometimes too, especially during COVID.
Okay. Does that have an effect on your ability to negotiate or work out a settlement with another party? Or does it affect the other party's maybe goal or them wanting to settle?
I don't know what the what is in your sentence.
The potential for the Supreme Court to pull your issue out of a hat and have it come before them.
Absolutely. It's a significant moment in a case. If they take it, I think the conventional wisdom would be they're not taking the third court's case if they decide to take it to affirm it, because they could just do that by denying the petition for review, save themselves time.
So what does that mean to you in the event that they might decide to take your case for review?
It would have altered our assessment of the case and made it, we would have felt very good about our chances for winning the appeal and dismissing the case outright.
Would that give you the upper hand potentially in settlement negotiations?
So much so that it might make settlement impossible.
Okay. Do you think, if you know, that had any effect on this case coming to a settlement, or at least settlement discussions starting in this whistleblower lawsuit?
I think that's why settlement negotiations started.
Okay. About what time did settlement negotiations actually begin in this case?
I'm not sure whether it was the very end of December or the first week or so in January of 2021, but about somewhere in that time.
2021 or 2022?
Sorry, 2023.
2023.
December 2022 and January 2023, thank you.
And just to clarify for the senators, the petition for review probably sat with the Supreme Court for quite a while, did it not?
Yes, I think we filed our initial petition, initial brief in July of 2022.
Okay. Who reached out to who to discuss settling the whistleblower lawsuit?
They reached out to us, my recollection.
And when you say they, you mean the whistleblower's attorneys?
Yes.
Okay. And can you talk to us about when, if you know, when that occurred?
Like same time, late December, early January of 2023.
And what did you do in response to them reaching out?
We discussed internally whether we wanted to, as they were requesting, go to mediation with a professional mediator in the Austin area.
What kinds of things were you discussing within your office as to why or why not settle a case?
We certainly wanted to discuss the pending petition for review and when it might be ruled on and what that might do to the party's willingness to mediate at that point if it happened. Whether we could get a professional mediator worth his or her salt on that short a notice, because I think the plaintiffs wanted to mediate in the next 7 to 10 days, maybe 14 at the outset, at the latest, because they were concerned that the Supreme Court might rule, and either way it ruled, the other side would feel good and the other side would feel bad and maybe couldn't. So risk creates settlement potential. So that would take out some of the risk.
Risk for the plaintiffs, right?
Risk to the plaintiffs that the court would grant it, and that might indicate their case was going to be dismissed maybe in a year, maybe in 9 months. they may have assessed it differently. That's how I would have seen it. And risk for us that if the court declined to accept our petition for review, the third court ruling stands, and we're back in trial court, and we have years perhaps of lawsuits and appeals, litigation and appeals, and the accompanying expense and time.
Who found the mediators?
The plaintiff's lawyers did that. I remember clearly because I was very skeptical that on that short a notice we would get any good mediators, and they told us in response to that, I think that not only they had 2 or 3 who had available dates in the next week or two, which indicated to me, I told people at the office, that's a good sign that they're eager to mediate, because they must have called 10 or 12 people if they could find 2 or 3 available on that short a notice.
Okay, so it appeared to you that they intended to reach a settlement with you?
I think they were highly motivated to settle.
Okay, and that's based on your years of commercial litigation experience, I assume?
And as a mediator and trying to get a mediator on short notice.
Fair enough.
In fact, that was kind of my specialty, is I didn't mediate full time, so if parties couldn't get one of the regular mediators, they knew I was probably available.
Now, I want to zoom out a little bit, just generally speaking, in your years of experience in both a mediator, a judge, and a litigator. Does a party's willingness to settle a case indicate that maybe they think they're liable, or that they think that the other party is correct? Can you talk to me about that?
Sure. In my experience, especially mediating and representing parties who mediate their cases, both sides at least will say they like their case, and they frequently do. Mediation takes place when there's risk and uncertainty, and the only way to control the outcome is for the parties to reach an agreement and take it out of a jury's hands. You never know what a jury's going to do. You don't know who the jurors are. And it may be 2 years from now. It may be, again, 12 people pulled off the street. That's, if you want to subordinate your control of your affairs to those people, that's your choice, but that's expensive and risky.
Okay. And I'm
not sure I answered your question. Did I answer your question?
You answered my question. Okay. I appreciate it. And I want to bring actually your answer and apply it to the fact of this case. Did you have a conversation, without getting into specifics, with other OAG employees about settling, or at least going to a mediation with the plaintiffs in this case?
Oh, yes.
Okay. Now, when you entered those discussions, did you have a viewpoint on the strength of your case for the defense, the Office of Attorney General in this case?
Yes.
And what was your viewpoint?
Well, we hadn't probably looked at it in some time since filing the briefing, so we reconvened, revisited, reminded everybody where things were and what the arguments were, so we could assess that. I remember being a voice, as I am generally and maybe professionally. Look, let's go to mediation compared to years of trial and discovery and outside counsel on both sides. The expenses, the time is short. We can do it in a day, maybe 2. And the expenses, a rounding error in the budget, it's the responsible thing to do, especially in this case. It's one thing if you're a private plaintiff or a defendant. It's another when you are dealing with the state's money. I think I felt and articulated that we kind of have a duty to explore settlement. Maybe it can't happen, but we should give it a try.
Right. Your Honor, at this time, may I approach the witness in the court and opposing counsel? Thank you. Mr. Dorfman, I'm showing you what's been pre-marked as Attorney General Exhibit 335. Do you recognize this document?
Yes.
And what do you recognize this document to be?
This is an internal memo prepared by Chris Hilton, the chief of our General Litigation Division, assessing after we'd received settlement statements from, I think, 3 of the plaintiffs in the Whistleblower Act case, explaining why they thought their case was strong and what they thought they would recover at trial.
And let's not talk about the contents of the document, but could you tell me when this document was authored?
This, on its face, it says February 1st, 2023. I don't have any reason to doubt that's the date. That's the date, by the way, we mediated the case.
Okay.
So whether it was circulated before that date in draft form, I think it was, my recollection. We certainly discussed the contents of it internally before it was put into final form.
Okay, and did the findings, without getting into what the findings were or the subject matter of the document is, did this have an effect on your mindset going into the negotiations?
I don't know if it certainly informed me, and I relied upon it and had, I think it summarized the state of play well.
Okay, and is AG Exhibit 335, is that a fair and accurate copy of the memo that you received from Chris Hilton?
Give me 1 second.
Sure.
Yes.
Your Honor, at this time, I would offer AG Exhibit 335 into evidence.
Any
Mr.
objection?
Austin, I just want to make sure I have the right document. Is this the one with the AOG seal, but with Ken Paxton's name removed?
Yep, that's it.
Then no objection.
Admit
May I proceed?
335 AG exhibit into evidence. You may continue.
Thank you, Judge. Now, I don't want to go line by line in this report, but would you mind just summarizing the kind of what this document is and what you and Mr. Hilton's thought process was with regard to the financial aspect of this mediation in the case?
Sure. It's important to realize the mediation. We were told in no uncertain terms Blake Brickman would not participate in mediation. He would not come to mediation. He would not be there. He was going to trial come hell or high water. So the opportunity was to settle with 3, not all 4 of the whistleblower plaintiffs. And this, so we received settlement statements from demands, basically. This is what we're going to present the week before, maybe a few days before the mediation date. And this was kind of a summary. I think collectively their attorneys argued for over $5 million in damages if they settled today. Of course, prejudgment interest and attorney's fees, as they said, would go up if the case continued, etc. But so for 3 of them, that was and we didn't want to take their word for it, so we asked one of our top attorneys to read those carefully, review the case law, and report back on what we would consider a more realistic assessment of the case's value was.
Okay. And just a brief question. This is just an inter-office memorandum, right?
Yes.
Objection leading.
Was this?
Overruled.
I'm going to ask the question again. Was this an inter-office memorandum?
Yes.
Did you send this out to anybody outside of the Attorney General's office?
No, we would not have done that.
Did you represent that you were the Attorney General or that you had the authority to act without Ken Paxton's, I don't know, authority in this document?
By this memo?
Yeah, by this
No.
memo. No, okay. So, can you tell us whether or not you felt that there was an ability to potentially save the state of Texas, the public of Texas, money by engaging in a mediation and potentially a settlement?
Well, I certainly thought that was the case. Otherwise, it wouldn't have been advisable to go to mediation.
Okay. Now, which specific plaintiffs in the whistleblower lawsuit were involved in the initial willingness to settle or request to settle the case?
Ryan Vassar, Mark Penley, and David Maxwell through their attorneys. I don't think we ever talked directly to them during this process.
What about Blake Brickman?
Well, as I said, Mr. Brickman's attorney told us, and actually the attorneys for the other 3 plaintiffs told us, Blake Brickman will not come to Austin. He will not participate in the mediation. He doesn't care. He wants his day in court.
Did you have a reason or idea as to why Mr. Brickman wanted his day in court?
Yeah, well, this is secondhand, so I understand Mr. Brickman is financially secure.
Objection, hearsay. This is secondhand.
Sustained.
Your Honor, I'd actually argue that it goes towards settlement agreements in this case, and under 408B, it should come into play.
Then my objection is 408. This goes to settlement, and it's also hearsay.
Which is if 408B is the exception to the rule, and
We've had this discussion on, I think, yesterday or the day before, so I sustain the objection.
Yes, Judge. Needless to say, Brickman's not there, is he?
Wasn't there, wasn't going to be there. Well, and I say wasn't there. We didn't anticipate this or plan this, but February 1st, the date we set for the mediation, ended up being the winter freeze.
Did Mr. Brickman's attorneys come to you with additional demand? Well, we'll get there. Talk to us about how the mediation went. What day do you recall you started mediation?
I believe it was a Wednesday, February 1st. And we had planned to be in Austin in person at the mediator, Patrick Keel's, former judge, office. As it happened, when the freeze set in, I stayed in Houston, and we were all on a Zoom.
And Mr. Dorfman, it's been a few years. Is it possible that the dates
might not have been a Wednesday?
Fair enough. Judge, may I approach Mr. Dorfman?
I think it was a Wednesday.
Was this a one-day mediation or a two-day mediation?
Ended up being initially planned to be one day, February 1st. We ended up, I think, on February 8th, having a second day by agreement with the plaintiff's attorneys.
Okay. Can you talk to us, and we'll get to the document in a second, but can you talk to us about how the first day mediation went?
It went long. I think we broke sometime around midnight. I want to give Patrick Keel all the credit in the world. We didn't know until it started turning dark that he didn't have power in his house. And at some point, he was on his laptop and lost that power, couldn't recharge, so he's now on his phone on the Zoom call.
This is all happening online, right?
All happening online till midnight, and I think his juice gave out at some point.
Was it a good day of mediation, or was it a bad day of mediation?
I didn't have a whole lot of expectations that this would settle. It didn't, obviously, on that first day, but we got real close. And again, we came in with the expectation that the option today is to settle with 3 plaintiffs. Sometime between 5 and 6 p.m., Mr. Brickman showed up, again, remotely, so I don't know if he was physically present.
Sure. I'm going to stop you real quick. Was this the first day that it got real close and Mr. Brickman showed up, or the second day of mediation?
First day.
All right. So you guys are making headway. You said Mr. Brickman showed up. Can you talk to us about any effect that only 3 of the 4 plaintiffs were present that it had on you? And then what happens when Mr. Brickman shows up?
Well, I think Mr. Hilton's memo, Exhibit 335, speaks of the fact that it's more valuable to us to settle the entire case.
Okay. And why is that?
Because if we're settling with 3 of them, we're paying money out. Mm-hmm. Yet we still have to pay our lawyers and outside counsel on top of that to go to trial, to go to discovery, all the expense, maybe less time, maybe less discovery because it's just one plaintiff, but still time, resources that we would like to save, ideally by getting rid of the whole case at once.
Because what is the point of settling this case to you guys?
We have to be good stewards of the taxpayers' money, of the state fisc. And so we viewed this as any other case. One, that's why I argued for mediation, is we should at least try, if it's cheap and inexpensive to try and settle this and save that money and time and resources. And then settling with 3, I think it would be less valuable, but by the same token, we would offer less money. And I think Mr. Hilton says it in the reverse way in his memo that if Mr. Brickman would come to the table and we could make sure we don't have to expend any money after a settlement, I think his word is that would be worth a premium.
Okay. Talk to us about what happens when Brickman joins the negotiation table. How did that go down? Did you all reach out to Mr. Brickman, or did somebody else reach out to Mr. Brickman? What is your understanding?
I don't recall real clearly. I think it was a surprise to us.
And how did you take that surprise?
Good and bad.
Can you tell us about that?
The good is, look, we've all along preferred to settle with all 4 rather than piecemeal. It's more valuable, it's worth the premium for the reasons Mr. Hilton stated in the memo, the exhibit. So that was good. Bad is, wait a second. You told us all along, all week, maybe 2 weeks now, Blake Brickman's not interested in settlement. Blake Brickman's not going to participate in the mediation. He's not available. He's going to trial. And now that we're talking real dollars and it looks good that we might actually settle, now he's interested. All that, was that posturing? Were we being sold a bill of goods? That the suspicion crossed my mind.
Did you all reach a settlement that night?
No, we got real close, but no.
Now, I want to talk to you about AG Exhibit 423. Do you recognize this document?
Mr. Ross, I'll be sure you speak up and stay on that mic a little bit.
Yes, Judge. Do you recognize AG Exhibit 423?
Yes, I do.
What do you recognize that document to be?
This is General Paxton conferring on me
Objection,
and on...
Your Honor. Testifying from a document, not in evidence.
I'm going to lay the predicate right now, Judge, and I'll instruct the witness.
Overruled.
Without getting into the contents of the document, what do you recognize this document to be?
It's a memo from Attorney General Paxton to me and to Chris Hilton, subject line settlement authority dated February 8.
Okay. And did this email have an effect on your abilities and your thought process when going into the mediation on day 2?
It confirmed what we had discussed internally, yes.
Okay. Did it grant you any form of authority?
Yes.
All right. Is this email that you see in AG 423 a fair and accurate copy of the email that you received from Ken Paxton on February 8th of 2023?
Yes.
At this time, Judge, I would offer AG Exhibit 423 into evidence.
Any objection?
Yes, Your Honor, I have 3 objections. First, it was never produced. Second, it was listed on their privilege log, so it was never produced. And 3, it's hearsay, so it is inadmissible.
I can address the objections. I didn't hear your second objection. Could you repeat that?
Yes, this document was identified on your privilege log, so you never gave it to us. And now you're bringing it to court for the first time and showing it to us for the first time.
Let me address the privilege log first. As an attorney for Ken Paxton, I think at this time we'd be willing to waive any privilege.
I appreciate that, but the fact
I'm not done, and if I could just finish my response, then I'd be happy to be quiet and let opposing counsel go. So first and foremost, as Ken Paxton's attorney, I'll waive the privilege. With regard to hearsay, it's not offered for the truth of the matter asserted. It goes towards the effect on the listener in the mediation the next day. We heard Mr. Dorfman just state that on the record. And his first objection with regard to it being not being on the witness list, or excuse me, the exhibit list, Judge, this is a rebuttal case at this point, and arguably we don't even have to put a case on. Most of our exhibits are rebuttal exhibits, but we did give them a list. I am arguing that this is a rebuttal exhibit, and for that reason, it is not covered by the the exhibit list rule, and it should come into evidence.
Your Honor, may I respond?
Yes, you may.
Just so we're clear, the process that occurred was they produced a privilege log, never gave us this document, and now for the first time they're sandbagging us with this document without giving it to us. As the court is aware, you have ruled several times that documents that we did not produce would not come into evidence. They never gave this document to us. This is the first time we're ever seeing it. If they want to take every document off their privilege log and put it into the record, we're good with it. Otherwise, we have a valid objection. Second, Your Honor, it is clear hearsay. There is no business record. The predicate laid was not the standard for hearsay, and so it is inadmissible on all of those grounds.
If I, and just brief, yes, Judge. Well, I'm not aware of a privilege log that we came up with or provided to the House Board of Managers first and foremost. This was on our 4th supplemental notice of the exhibit list. I think the court is aware that the managers have given us plenty of exhibits throughout the course of this trial. I mean, if I remember correctly, Mr. Bangert dumped phone text messages between him and the Attorney General during the middle of trial. So to say that I'm sandbagging them, it's just simply not an accurate reflection of what's going on throughout this case or with regard to this exhibit.
Okay. I've heard both arguments. Give us a moment.
Andrew, just react to this.
Well, once again, we're in a situation where you've got a hybrid proceeding that's sort of part criminal, part civil, and
Part whatever.
part just made up. And so, but apparently part of the rules were that you had to turn over what you were going to have to the other side. And if they had a privilege log and this document was on it, and then now all of a sudden they're pulling it out and trying to admit it, I mean, I don't know what these guys are doing. And also, this witness is just so boring. I wish they would move it along.
Yeah, this witness, well, and you know, I actually covered the settlement situation, and my recollection, based on what I was told back at the time, was that it was actually what Brickman described, that Paxton's side reached out to start the settlement negotiations.
That was always what I heard.
And Dorfman is testifying to the exact opposite. So that's very interesting to me. You know, that's a factual question now. Who started? I mean, because it becomes an important point, right? In a way, because the point that Brickman made of it was that settlement negotiations weren't initiated until after the election, right?
Yes.
So he's saying the exact opposite. So, you know.
Well, and once again, I go back to the fact that there's pending litigation. These cases are not settled, and to put all this stuff out there in sworn testimony, I just don't think it's a good idea.
Can we settle who started it? I mean, is it going to rest as his word against Brickman against Dorfman? Is there something that's going to resolve that?
I don't know.
We don't know. We'll have to wait till cross to see if the other side has any.
And that could also come out
in writing.
I mean, you know, like she said, there's still a pending lawsuit, and it could come out in that lawsuit later.
Well, there's been what I would think or what sounded to me like a lot of disparaging comments coming from some of these AG witnesses against these whistleblowers who have this pending civil litigation against them. I don't know. I don't understand why they're doing that. I would not be touching it. I understand it's an article of impeachment. I just think you could have gone around it without throwing more aspersions on these people, which is what they've been doing.
Well, I mean, they're trying to attack that particular article, and they've been working on it, you know, almost, you know, the whole afternoon and part of the morning. And it seems like that is an article that they feel like is very, very important to them to bring down, and very important to mount a defense against. They're working on the whistleblowers themselves and their credibility.
Oh, well, he's hammering.
Okay, let's take a listen.
Got the big hammer.
Jurors, please take your seat. After consultation with my team here, we will sustain the objection on hearsay. Continue.
Yes, Your Honor. Did General Paxton delegate you the authority to engage in a settlement agreement with the whistleblowers?
Yes.
Okay. Did he do so on February 8th of 2023?
On or about that date.
Where was Ken Paxton while the settlement agreement was going on?
I don't recall. I know he wasn't in Austin, and I believe he was traveling, which is in part why we needed to formalize my authority and the scope in case we weren't able to reach him on short notice if it appeared that we had an agreement subject, again, to his confirmation.
But to be clear, you guys formalized that delegation of duty, right?
Yes.
Right. So then you go into the second day of mediation, right?
Yes.
Will you talk to us about the second day of mediation?
I believe it was also remote by Zoom, even though the weather had cleared up. And I can't remember exactly when it was we agreed we had a deal, but the same dynamic had played out. Mr. Brickman was participating from the start on the second day at least, and so we were now dealing with 4 plaintiffs rather than a settlement for 3, as we had most of the first day of mediation.
And did you all reach a settlement agreement?
We did.
What was the settlement agreement that you all came to?
And to be certain, I think we reached it that day. It may have been the next morning.
Okay.
Before it was finalized.
Fair enough. What was the settlement agreement?
It was in the form of a mediated settlement agreement, payment of $3.3 million to the 4 plaintiffs in exchange for full and complete releases of liability against the Office of the Attorney General. There was other components we had agreed to, and if you have the copy of it, that might help me, but we had agreed to attempt with ERS to reinstate Mr. Vassar in his retirement plan. I think that was the only fringe benefit that was addressed, but I recall that. And then Mr. Maxwell had an separate F5 administrative hearing case in SOA, State Office of Administrative Hearings, which was abated pending the pendency of the whistleblower case. So that stayed, their filing stayed that proceeding, which was an attempt to reclassify him from a plain discharge to an honorable discharge, without which his employment as according to them, as a law enforcement officer in Texas was problematic.
Okay. How did you feel about this agreement on behalf of the Office of Attorney General and the public of Texas?
I felt overall, especially now that it was a settlement of all 4 plaintiffs and the case would not go forward, it was a good assessment of our risk. To be honest, it's more than we would have liked to have settled for. I'm sure it's less than certainly was less than the plaintiffs' lawyers were telling us they should settle for. So that's probably, again, 95% of mediation settlements fall into that category.
Okay. Now, after this case comes to an agreement, you still have this petition for review in the Supreme Court, right?
It's still pending, yes.
And did you all file any motions with the plaintiff's attorneys in regard to that petition for review?
I think the next day.
Can you tell us what motion you filed with the plaintiff's attorneys in regard to that petition for review?
I believe it was styled as a joint motion to abate in the Supreme Court.
Can you tell us what the joint motion to abate did in this case?
Very short motion. It was simply telling the court, look, we've reached a settlement agreement that's binding and disposes of the case. If the Supreme Court went ahead and conferred and spent time deciding whether to take our case or not and made a decision, they'd be very peeved if they found out later that that was wasted energy on their part. So we didn't want to upset the court. So we let them know, hey, we've reached a settlement. We're going to paper it up and finalize a larger document. It's all the bells and whistles, dot some I's, cross some T's, but you don't need to do anything now, and the parties are jointly asking you to put it aside for now.
Okay. Now, I want you to focus your attention on the article of impeachment that is on the screen right now. And it states, the settlement agreement stayed the wrongful termination suit and conspicuously delayed the discovery of facts. Is that true?
No.
Why is that not true?
Well, the plea of the jurisdiction stayed the termination suit pending the Supreme Court. At that point, the Supreme Court's consideration, it didn't, whether it's conspicuous or not, it didn't delay the discovery of facts by settling. There was no discovery ongoing at that time. And the way this is written, it's sort of passive voice. But who's doing the delaying? Is the suggestion here that the whistleblowers, by filing a motion to abate with the Supreme Court, are trying to delay the discovery of facts?
Mr. Dorfman, I don't know. I didn't draft the articles of impeachment.
Right.
Okay, so I want to move on to who pays this lawsuit. Who pays this lawsuit? Who pays the settlement?
Well, the defendant is the Office of Attorney General. That's the party that would be liable and would pay any settlement. Obviously, the legislature has to fund that. So those.
And why is that? Why does the legislature have to fund that settlement?
Goes back to our discussion about sovereign immunity. You can't sue the state without its consent. And even if you have a waiver of sovereign immunity, like the Texas Tort Claims Act or the Whistleblower Act, and you go get a judgment from a court, jury, verdict, all the way, hold it up to appeal, you have a final, unappealable judgment that entitles you to, let's say, $2 million against any state entity. This legislature, this body, can still decline to pay it. They have to agree.
Okay. And are you aware of whether that lawsuit has been paid?
No, it has not been paid, not been funded.
Now, did you engage, without getting into specific conversations of what was said, did you engage in discussions with the plaintiff's attorneys about getting the legislature to pay for this lawsuit?
Yes.
Were they for or against that?
For it. For it.
Now, were you a part of any specific discussions with any legislators about getting this lawsuit funded?
Yes, I was.
Okay. Can you talk to us, without getting into the specific conversations you had, can you talk to us about who it was that you met with to talk about the settlement?
I think there were 2 separate meetings that I participated in. Other people in our office had more, both on the House side and the Senate side. I recall a meeting with Senator Hughes where we discussed it, and with Senator Huffman.
And so you also mentioned that other people were meeting, or were other people meeting with other legislators about getting the settlement paid?
I believe our head of government relations at the time, Ryan Fisher, and his deputy, Colleen Tran, were having such meetings, formal or informal. And Mr. Hilton, I think, too, had some
And
meetings.
if you know, were the plaintiff's attorneys in this case aware of these conversations happening with legislators?
Absolutely. They were adamant. There's email traffic where they're saying we're not doing enough, we need to do more, this person wants to meet with you, that person wants to meet with you, and we said we're doing our best. We agree we have obligation to act in good faith and make reasonable efforts, but it's really, you should be highly motivated to do what you can and have the meetings you need to have as well, and we'll show up with you, but let us know.
And just because they haven't agreed to pay it yet doesn't mean they can't at a later date, right?
Of course.
Do you, and you still believe that it is the state of Texas, the public funds that should fund this settlement agreement, right?
I believe that initially. I believe it now if the case goes back to trial, which I think it's settled, but others may feel differently. All the reasons that were there before, again, we'll go back to the Supreme Court presumably, so, but the risk return of time, the certainty of time, litigation, resources, lawyers being devoted to this when they could be doing Biden administration lawsuits or something.
Let me stop you real quick. Okay. And just to be clear, you said if the case went back to trial, if the case had gone to trial and there was a judgment entered against the Office of Attorney General, would it still be, should that still be paid from public funds?
That would be up to the legislature to decide.
Okay.
No one can make them.
Would Ken Paxton ever be personally liable for that lawsuit?
No, he's not a defendant.
Okay. You were at the Office of Attorney General. You're currently still working there, right?
Yes.
My understanding is you took leave for a little bit of time.
Yes.
Okay. About how long were you gone from the office?
From roughly early May. I returned to work remotely probably around the July 4th holiday.
So just recently, right?
Just recently.
Okay. I want to talk to you about the time period from when you started at the Office of Attorney General in December of 2020 up until you took leave in May of 2023, okay?
Okay.
Can you talk to us about some of the accomplishments made by the Attorney General's office under the leadership of Ken Paxton while you were there?
Well, I've referenced the Google ad tech lawsuit, one of the biggest antitrust cases, not just in the country, but in decades. That's still ongoing.
Objection. I apologize for interrupting. Anything after this lawsuit is irrelevant.
Actually, Judge, if I may be heard on the matter. Yesterday, the House Board of Managers elicited testimony from Blake Brickman. I have the transcript here and be happy to show the court, but they've opened the door to the Office of Attorney General's productivity after this whistleblower lawsuit, after these terminations occurred. They talked about the fact that there was not productivity and that the office wasn't functioning well. As a result, they've opened the door. That would leave a misimpression on the jury, and as a result, Mr. Dorfman should be able to talk about how the office is functioning.
Overruled.
So you talked to us about one of the lawsuits. Would you please continue to talk about the other accomplishments and the functioning of the Office of Attorney General?
I should have started with our immigration cases, which I'm probably most proud of.
Would you please tell us about your immigration cases?
Day one, I mentioned this maybe earlier, of the Biden administration, all the executive orders that came out. One was the 100-day moratorium. We were the first to get a nationwide injunction requiring the Biden administration to abide by congressional directive that no, if you have a deportable alien, they must be deported within 90 days, no exceptions. And that we continue to file and challenge and try to hold the Biden administration to the letter of the law and the rule of law on our border. Title 42 is one of those cases. DACA is a continuation of a case then Attorney General Abbott brought years ago against the Obama administration. We just won, I think in the last week, a ruling out of the federal court in Houston that the revised Biden administration DACA policy is just as illegal, unlawful, I should say, as that in our favor.
Okay. I'm going to bring you talked about big tech already. You talked about the Google case.
That's one of the Google cases. Another Google case we settled before I took leave. We broke away from a multi-state, all the states suing in one location. We broke out of that, filed our own lawsuit in Texas state court. We settled with Google for $8 million when all the other states put together settled for $9 million over the Google Pixel phones, and that was to the relief of Texas consumers who were deceived by misleading advertisements.
Any litigation with regard to opioids?
This is mostly before my time. The money has come in since I've been at the agency, but I can't claim credit. General Paxton himself led the nationwide negotiations on that, worked very hard on that, deserves the credit for that. And it's been billions in money from those manufacturers, distributors, marketers, consultants, pharmacies that were responsible for the opioid crisis that was so devastating.
And so based on what you've seen at the office during your time there, have they been successful in their efforts and their litigation under the leadership of Attorney General Ken Paxton?
I think so. I've been amazed at what we've accomplished. We've worked our lawyers very hard, and they've done very well. They deserve the credit. They're the ones going to court, making the winning arguments and filing the winning briefs, not me. So I don't want to seem like I'm tooting my own horn when I say CNN, no great fan of Attorney General Paxton or our office, had to concede in a news article that Texas had become the legal graveyard for Biden administration policies and executive orders.
Well, thank you, Mr. Dorfman. I'll pass the witness, Your Honor.
Your witness? That sound you're hearing you have not heard for a long time. It's called rain.
We're sure. All right. Hi, Mr. Dorfman. How are you?
I'm very good, thank you.
I was
The mic's not on, Mr.
Can you hear me?
Yes, sir.
Mr. Dorfman, we were looking at Exhibit 335 that was introduced by your counsel, or counsel for Mr. Paxton. Can you pull that up for me, Stacy? No.
Check your mic one more time. It doesn't sound right.
Is it not working?
No, it is now, but you're tall enough that you're going to have to bend down a little bit.
Yes, Mr. President. Is this the memo that you were talking about on 335 with the counsel a moment ago?
It's one of them, yes.
And this memo was created by Chris Hilton?
I believe so, yes.
And one of the lawyers standing over there, sitting over there?
Sitting, yes.
Sitting, yes. When you got this memo, were you shocked?
By what?
By the fact that Mr. Hilton was attempting to usurp the power of Ken Paxton by removing his name from the letterhead.
No.
Did it appall you?
No.
Was it simply a matter of Mr. Hilton picking out this letterhead that is available to every employee of the AG's office?
I think you'd have to ask Mr. Hilton about that. I don't know.
You talked about the internal investigation that was conducted by the Attorney General's office, correct?
Yes.
And you talked about the fact that it needed to be fair.
Yes.
It needed to be unbiased.
Well, it needed to be objective, I think is the word I used.
And the subject of that investigation was Ken Paxton.
One of the subjects of that investigation.
It certainly was a big part of it, right?
The allegations against him were a big part of it.
Your Honor, may I approach the witness?
Thank you.
Mr. Dorfman, I am showing you what has been marked as 524, Exhibit 524. Do you recognize this document?
Give me 1 minute to read it quickly. Can you restate your question, please?
Yes, maybe I can make it easier. You see your email address right there, halfway down the page?
I do.
This is an email exchange that you received, you were on?
Yes.
And so as a result, you recognize this document?
Yes.
And, you know, to use a predicate that's being laid by your counsel, this fairly and accurately represents the email as well as the attachment.
I think that's right.
Your Honor, at this time, we offer Exhibit 524.
Any objection?
Yes, Judge. I'd object to hearsay, and they haven't provided a proper foundation for this witness to sponsor this document.
Your Honor, we have a business record affidavit that overcomes hearsay. That gets by that, and the predicate is this witness was part of this email exchange, is a proper sponsoring witness, testified it fairly and accurately represents the email exchange that he was a part of.
Judge, I'm just confused. I don't have a copy of a business record affidavit.
You do have a copy of the business record affidavit. I didn't hand it to you, but if you want, I can get it for you.
Well, that'd be great. I think part of the rule is that it's, got to be provided to counsel, so that would be good.
I will.
Would you provide him a copy?
Yes.
Judge, if I could just have a moment to look at the business record affidavit.
Take a moment.
Thank you.
Your Honor, I assume we're stopping the clock, respectfully?
Judge, I mean, I don't see why it should. They're offering it.
If it's a minute, we're not stopping the clock, but if it's longer than that, I'll stop it.
Judge, I have to reurge my objection. This business record affidavit is not the correct affidavit for these documents. It references Office of Attorney General numbers that are just not contained on the documents that counsel has provided me. And so I can't verify that it's the document that he's purporting it to be.
And we don't have a copy either of the business affidavit.
I can get you a copy.
That would be good. Yeah, it's supposed to be attached so that we know.
I appreciate that, Your Honor. It was attached to a bigger swath of documents. This is just one of the documents as part of it.
We will stop the clock and give you credit for a couple of minutes here. Mr. Dutko, I will say I stopped the clock, but when either side has not been ready to present us what is needed, we have not stopped the clock previously. So I've given you 2 minutes here, but I don't know how long you're going to take.
Yes, Your Honor.
It does not seem you have your paperwork together.
Yes.
So can we continue and get the clock running and come back to that if you'd like?
Yes.
All right. Resume the clock, resume your questioning.
May I proceed? Mr. Dorfman, when you were on direct examination, you spent a lot of time talking about the fact that the quality of attorney that is currently at the Attorney General's office. You remember that?
Yeah, I think so.
And you said how you were proud to walk through the halls and the lawyers and the high caliber of lawyers.
I don't recall saying that. It's certainly true, but I don't recall saying it.
And you were talking about how good the lawyers are and how hard they work. Do you remember that?
Yes.
Yet, despite the fact that there's the high quality of lawyers that currently exists at the Attorney General's office, Ken Paxton had to hire Louis Brisboe as outside counsel.
Didn't have to, he did.
And it was certainly something that could have been handled internally.
I'm not going to agree with you on that. Now, I have an explanation why.
Okay. Are you aware of the fact that Louis Brisboe has billed the Texas taxpayers $524,000 for the work that was done?
Yes, I am.
And that doesn't bother you?
I think I've been very clear that I view the Texas fisc as a sacred calling for us. That's very important for us to preserve it and spend it wisely. Again, I had a reason why I supported the hiring of Louis Brisboe as outside counsel. But part of the motivation for settlement was to stop paying Louis Brisboe as outside counsel.
Your Honor, we have the business record affidavit that we were going to present to opposing counsel.
Okay.
Is this for this document? Yes. You just got extra copies of VRAs on. Again, Judge, I got to re-urge the objection. The document that they've handed me doesn't have a single Bates label on it, and this business record affidavit talks about Bates label documents. No way for me to verify the validity of these documents.
Your Honor, just so we're clear, these are documents that
Could I have a copy of that?
Yes.
And before you answer his objection, let us look at this. We're ready to resume. I'm going to sustain the objection because we don't find a way to identify this affidavit with the document.
Yes, Your Honor. Remember when you talked about the plea to the jurisdiction a little while ago?
Yes.
One thing is clear, a plea to the jurisdiction stays the case.
Once it's denied or granted.
Right, and so when you filed that plea to the jurisdiction, you, as the Attorney General's office, knew that the case would be stayed.
Yes.
That meant there would be no written discovery.
Yes.
That meant there would be no deposition discovery.
Right.
That means that Ken Paxton did not have to testify under oath for the entire time that that plea to the jurisdiction was being determined.
No one had to testify, yes.
Right, but Ken Paxton didn't as well.
Yes.
Right?
Yes.
And so when you filed it, you knew that was going to happen.
Once a ruling was made, yes.
Right. And even though you lost at the trial court, instead of going back to the case and conducting discovery, you appealed it to the Court of Appeals.
Well, we didn't lose the case at the trial court. We lost the plea.
Right, you lost the plea to the jurisdiction.
We disagreed with that and we appealed it, yes.
Which means that when you lost that case, that plea to the jurisdiction, that meant if you did not appeal it, you could go back to the trial court and take discovery.
If we chose not to appeal it?
Right.
I suppose that's true.
And then you appealed it.
We did.
And lost.
We lost in the third court.
So then, instead of going back to the trial court to conduct discovery, where Mr. Paxton would have to give his deposition, you took a flyer and took it to the Supreme Court.
I disagree with you that we took a flyer. We urged the constitutional separation of powers, which is a pretty important constitutional doctrine. And we also relied on the sovereign immunity of the state, which this body thinks pretty importantly of as well.
Right, and then while the case was pending at the Supreme Court, there was an election, right?
Yes.
And after the election, before the Supreme Court, where you said you had a good faith basis to go, immediately after that's when you guys settled, right?
Not immediately, no.
Shortly thereafter.
We settled 3 months later, a little more than 3 months later.
Your Honor, I was told that the document that was printed for everybody had the Bates label that ran off the bottom, and so now I have a version that has the Bates label that identifies it as a document within the range on the Attorney General's, on the business record affidavit. Since it was a short notice, I have one copy. I would like to show it to opposing counsel and then bring it to the court, if that is okay.
Can I see it first?
Yes, Your Honor.
You can come forward if you like. Come forward if you like. Y'all can take a stand-up break, but don't leave because we're moving forward.
So, Deandra, they really want this email in, don't they?
Yes, they do really want it. And it sounds like there was a business records affidavit with a lot of documents attached from somewhere, and they are trying to pull out one email exchange from those records to offer, which they should be able to do if everything is the way it should have been prepared to show everybody. I mean, they obviously decided to do this at the last minute.
So and it must show some kind of contradiction?
It's probably something that contradicts something Dorfman said that they didn't expect to ever offer, and because of what he just said, they're trying to impeach him. That's what I'm guessing. They're trying to show that something he said is not match up with something he emailed, maybe.
Because why go through all the trouble? I mean, when
they really want it in.
I mean, they're wasting time to do it. Yeah.
Yeah. So it must be something.
And so, let's talk about letterhead gate while we.
Well, it sounds like that's gone. I suspected that was the case all along.
That was ridiculous from the beginning, and it was something that was obviously just a joke, and that there were some letterheads that had Paxton named, some that didn't. But there were several things that were published without Ken Paxton's name, particularly in the days after impeachment. In the confusion over who was the Attorney General.
Well, and they probably have pre-printed letterhead, and some of it has his name, some doesn't. They don't throw out the old stuff.
Right.
Keep it around. It's got the seal of the Attorney General's office
Well, and they probably
on it.
have letterhead for different things.
Right.
Yes, different things, and they just grabbed some and printed out their letter. The whole thing was silly.
We do change Attorney Generals now and then. They probably have a stock of standard letterhead.
For in between.
But what Dutco was able to successfully do was point out, look, this letterhead thing they've been talking to y'all about through this whole thing. Here's one from that guy sitting over there.
So much for the conspiracy.
They tried to make it sound like that the whistleblowers, that there was some sort of disloyalty going on because they published something that didn't have Ken Paxton's name on the letterhead. Then the defense themselves brings it out.
Oh, they did it the first few days. Remember, it was like every single witness.
Yeah.
Yeah. Well, they tried to make it seem like
it's a conspiracy.
They went on their computers and
Members, please take your seats.
Okay, here we go. Let's take a listen.
Members, please take your seats. Give them a second to settle down here for a moment. You may continue.
Mr. Dorfman, I'm going to make this short because everyone's ready to be done. You started in December of 2020.
That's a yes.
And when you started, all of the whistleblowers had already been fired or resigned, correct?
Yes.
You didn't interview Mr. Vassar?
No, I did not.
You didn't interview Mr. Bangert?
No.
You didn't determine the veracity of what their testimony is in front of this Senate?
I haven't been allowed to watch their testimony, so I don't know.
Right, but you didn't determine the truthfulness of what they were saying?
To the Senate?
No, as far as the whistleblowing allegations.
We took their pleadings at face value and addressed those in the report.
I appreciate that, but you didn't make a determination yourself.
I never interviewed them, but the report is I don't know if you call it a determination, it's a report of our office.
Right, but when it comes to determining personal knowledge about the allegations that are made here in the Senate, the allegations that are made before you got there, your testimony would not be helpful as far as personal knowledge goes.
I have no personal knowledge of what happened. I didn't hear it in conversations in September or October or prior to that at the agency. That's true.
Pass the witness, Your Honor.
No redirect, Your Honor. Can we excuse the witness, both sides?
Yes,
Good?
Judge.
Thank you, Judge. Mr. Busby, who is the next witness?
Your Honor, Attorney General Ken Paxton, Riss.
The parties approach the bench.
Okay, so right now, at about 5:20, just a short period of time, 5:34 actually, Tony Busby rested on behalf of Attorney General Ken Paxton. They're up at the bench talking to, all the attorneys are up there talking to Lieutenant Governor Dan Patrick. We're waiting to see what's going to happen. We don't want to talk too much because we don't want to make sure we don't step on anything that's being said. I'm assuming they're trying to decide when they'll do closing arguments, but I mean, I would guess tomorrow morning just based on...
Yeah, I'm sure it's scheduling is what's going on now. I'm going to assume that they're going to let everybody go home and come back in the morning and do closing arguments at 9. Normally you wouldn't do it tonight.
But I bet Dan wants to push something tonight, and so they could wrap up by the end of the day tomorrow.
Yeah. Well, and it, you know, I'm sure these senators want to go home this weekend.
Tanya, that tomorrow tomorrow or whenever it comes up, they have 16 votes calling 31 names one by one, and then if they vote to remove, then there is another set of 16 votes calling 31 names one by one. And I'm not sure about that second set, but they did the House dropped the motion to combine the two. So we do have 2 votes if the first vote is to remove.
And each side has 1 hour for closing arguments. So you would have each side having their 1 hour. Then you would have deliberations, although we have no idea how long that could take. It could be short, it could
Remember,
be
there's
long.
videos and
mean,
evidence they haven't seen.
They could decide to watch the videos, or they could just decide they've heard enough and they want to, make their decision. I don't know. And then of course you will have, as Bud described, 16 votes.
Yay or nay?
Yay or nay. And then if he is sustained on one of them, you would have one or more of them. Then you would have the vote on whether or not to bar from public office in
seeking
Texas.
future office.
Yeah.
I think Tony Busby rushed back. He saw how these assistant attorneys general were doing, both on the stand and as defense attorneys, and said, okay, I can count to 10. Let's go ahead and let's cut it off now. Tony Busby thinks he's counted 10.
He thinks he's got it.
He thinks he's got it.
Okay.
Well, I'm curious how the deliberations part of this is going to go. I mean, if any senator wants to go look at stuff, documents. Am I on?
You'll just keep talking.
Oh, if anyone wants to look at documents, watch any of the videos, any of those kinds of things, it would seem that they would have the opportunity to go do that. I mean, I don't know what the rules would be. If one senator says, hey, you know what, I want to go watch some videos.
I don't know exactly what the rules are for jury deliberation, but since I have said all along that I thought the jury had their minds made up before the trial started, then I don't think that there's going to be a lot of reconsideration. There may be enough just to look like they gave it some thought. But I don't really think that there's going to be a lot of changing votes. I think they know, and they've known for a couple of days how they plan to vote. I think probably of the 31, I think probably 29 of them have known since the start how they plan to vote and haven't changed. I've said all along I thought it was in a vote or two. It's either they need 10 for Paxton to retain office, and I think Busby cut short all the defense. He left a lot of time on the clock, 5 or 6 hours, that they could have continued to present defense witnesses, and I think that he probably cut that short because he knows he can count to 10, and he knows that Ken Paxton will not be removed, that none of the 16 articles will be sustained.
Yeah, I don't doubt that. I've felt it was going to probably fall that way too. I'm just, I just feel like, what if there's one person in there that says, hey, I want to go look at this evidence? Do they get to go do that? I don't know how this whole thing works. In a normal trial, that's what it would happen, but this isn't normal.
No, there's nothing about this situation.
There is nothing about the Texas Senate that's normal.
Well, no.
In fact, I'm pulling up the rules for the procedure here, because what I'm wondering is where there's an hour for rebuttals, and I'm wondering where that fits in.
Right.
Typically, I'm trying to pull that up. How would that normally fit in?
Well, so maybe an hour closing on one side, an hour closing on the other side, and then 30 minutes rebuttal, 30 minutes rebuttal.
Yeah, I'm trying to get to that.
No, that can't be right.
No, I said an hour. So rebuttal wouldn't be part of the testimony. That's just...
No, rebuttal. So in a criminal closing argument, state goes first, then the defense, and the state can reserve some of their time to come after the defense. So, but then you wouldn't give one side 2 hours and the other side 1 hour.
Okay, so I've got the rules up. Okay, so only one person per side can question a witness, and only one person per side may cross-examine.
Okay.
5, rebuttal evidence, 60 minutes per side. Final argument, 60 minutes per side.
Okay, so that means that the state will probably do a portion of it to begin with, or they could not. They could do nothing. Let the defense do their hour, and
you
then
can still
do
stand.
full hour.
I just need a little quiet. Both parties come back.
And then do a full hour, or they could break it up. They could do like 30 minutes and then save 30 minutes.
Haven't we already had the rebuttal? I'm confused about this.
Yeah, so no, I mean, according to I pulled up the rules.
Yeah,
according to the rules, it says rebuttal evidence, 60
during
minutes per
testimony.
side. So
was a separate clock.
Well,
that was,
no, the state, excuse me, the state can normally in a trial call, once the defense rests, could call rebuttal witnesses. Maybe that's what
Yes.
it's talking about.
Okay.
We may be getting premature here. It could be they have another witness and we don't know about it.
yeah, we're working to get Teresa Woodard from Austin.
We're assuming
live in a
everybody's
minute.
closing, but that may not be what's happening here. If the state wants to call, I keep calling it the state, but if the House, which is, if the House wants to call rebuttal witness, then they could do that.
Yeah, I mean, because it does say rebuttal evidence, 60 minutes per side. So obviously there's still discussion here. So we could theoretically see the House call somebody.
It could.
And then the defense. So this could.
That could and it doesn't happen a lot in criminal trials, but it does happen. State can call rebuttal witnesses.
Or they could both decide we've done enough.
And we're just going to do closing arguments.
And we're going to do closings. Mm-hmm. So that.
So we're just waiting for them to tell us what the schedule is going to be.
Yeah, that's.
I don't know why it's such an issue.
Does it strike you as odd what's happening now?
No, because a lot of times when one side rests, we all get together and figure out what we're doing next.
It doesn't strike me as odd because it's 10 till 6, and
No, everybody wants
everybody's
to go
asking,
home.
do we stay or do we go?
No.
Well,
Should I stay or should I go now?
Exactly.
Well, and if there's
We could be
rebuttal,
playing
if
that
there's going to
song
be
right now in the
rebuttal
background.
evidence and you don't do it tonight, then
drags out tomorrow.
Then you're into Saturday, because then you've got
That's
rebuttal
true.
evidence in the morning, closings.
Is he about to do something?
Well, he could say we're going to stay here Friday as long as we need to. He could say that.
That'll make everyone happy.
Okay, he's calling. I see Rusty back up there. Busby's back up there.
Dick DeGuerin's
There's
back
Dick
up there.
DeGuerin. There's Therese Booth. Chris Hilton's approaching. Yeah, they're all kind of gathered around there. So while we're waiting here, Deandra, how effective do you think? I mean, walk me through what you thought was good about the defense witnesses, and what you thought wasn't good.
I'm not. The last guy was just. It was really long, and I wish that wasn't what they closed on. Wish they'd kind of had a stronger witness to close the case out, because he was sort of long and boring. I would have put him on first. Probably.
You would put who on first?
This Dorfman.
Judge Dorfman.
Judge Dorfman, probably. Who weren't we saying that his dad used to own
The filling station. That's what somebody.
Yeah, that's
said.
kind
He's
of
a Dallas
cool.
guy.
Dallas.
I mean, that's what
He's
you say, he's a Dallas guy.
Well, he said he was from Dallas, so yeah, that's
Yeah.
kind of cool. That was a great bar back in the day. But the
He seemed more polished.
He was.
He didn't seem like one of the raw rookies that we've seen
Yes.
from both sides working in the AG's office.
Yes. I thought the first witness did a good job. I might have ended with him.
Okay, so we've got Teresa Woodard.
Oh, we getting some word.
Our reporter in Austin. Teresa, thank you for joining us. What are you hearing?
Absolutely. Well, we're sort of playing waiting game that I'm sure you guys are back at the station. Clearly, there's just a huddle going on up at the dais where Lieutenant Governor Dan Patrick, who, of course, as we know by now, is acting as the judge in this case, is meeting with both sides. Guesses are that he's trying to formulate exactly what the next steps are going to be. We know that since the defense has rested, up next would be an hour of rebuttal for each side. And so the prosecution would get an hour and the defense would get an hour for rebuttals, and that would come before closing arguments. The big question is exactly, is that going to happen now as we speak? Are they going to just try to power through and go as long as they can tonight and get as far as they can into this thing? Or are they going to say, tired, it's been a long day, let's take a break and come back and start over fresh tomorrow? It's anybody's guess right now as to exactly what's going to happen next. But the day, I think, can just be summed up by saying it was the defense's turn to try to poke holes in the prosecution, to plant seeds of reasonable doubt, And the way they tried to do that was by using current employees of the Office of Attorney General. They put 4 current employees on the stand today and tried to sort of pick apart all of the claims that the prosecution. And I don't know. Cross-examination seemed to be a little rough for some of those witnesses. And I'm sure you guys felt the same way watching it back there.
Yeah, I thought in particular the cross-examination of the one witness where they went through the timeline of
yes,
what happened.
The HR director, Henry De La Garza. Yeah, he certainly could not dispute the timeline, which was, that came moments after. I was just, in fact, looking back on some of that testimony. It was about 15 minutes after he told the defense attorneys, we had reason to let these people go. It was not retaliatory. About 15 minutes later, the prosecutor laid out that timeline and said, on October 2nd, this happened. On November 1st, this happened, and there's no disputing that.
It's a powerful timeline, no matter how you look at
yes.
it.
Yes.
So each side has an hour for rebuttal. What's your understanding of do we have much of a sense of how that would work?
From what I understand, they can call witnesses. And so, you may wonder if, remember yesterday there was that accidental arrest by Rusty Hardin that came in the middle of a witness. And so I don't know if that witness would be called back for either side to maybe ask a few more questions. The defense didn't call him today. And so, I don't know if that is what would happen over the course of those hours, or if they would just use it to bring somebody back to clarify something. It remains to be seen, really. I don't know exactly how that 1 hour is going to be used as rebuttal. And then closing arguments, correct me if I'm wrong, it's been a bit since I've read the rules specifically. I believe each side has an hour for closing.
They do. I had to pull the rules up just now because I wanted to make sure I understood the rebuttal thing, because I was not clear on the rebuttal, and that's how. So each side has 60 minutes per side, and the rules say if there is a conviction, 15 minutes per side on the issue of disqualification to hold future offices, because they give these. You've read the rules more than I have, but the timelines on everything. Were we expecting Busby to rest at this point, or did it seem like it came?
Yeah, well, I can tell you that many of the people I've spoken with, just people who are just sort of watching this case, they did expect for something to come to a head today in order for, I think that common thinking is they want this to wrap up before the weekend. And so, it's maybe not surprising that the defense arrested. I think only 4 witnesses that they called to the stand, but it's 5:30 on a Thursday evening, and I think everybody's getting a little tired. So, you can take it for what it's worth. Maybe the defense said we've done enough. Yeah, I second that. I'm a little tired too.
It has been, Teresa, it has been a long week. Last week was a long week. This week's a long week, and it's not over with yet. And it's looking like we might go into Saturday. It's really hard to call. And Patrick has made it very clear that this will keep going until it's over with. Either way. So. Yeah,
I think that's the one thing we do know is that they're not going to break for the weekend. We're going to continue on until there is an outcome.
Okay. Well, Teresa, thank you so much, and we appreciate you coming on and talking to us.
Absolutely. I'll keep you guys posted, but I know you're watching the stream just as I am, so we'll probably know at the same time.
Absolutely. Thank you, Teresa.
All right. Bye-bye.
Okay. Well, I guess we're going to wait to see if we're going to have rebuttal evidence tonight, or if they're going to regroup and start back in the morning. One part of me thinks that I could see Patrick saying, let's just
work it.
Let's just work it and get this done, because if you don't do rebuttal tonight, then you ensure that you go into Saturday. I don't see how you don't.
Well, I'm going to need a Dr. Pepper if we're going to have any more witnesses. Lord have mercy.
I don't know. I mean, and they might decide, both sides might decide we don't need to do rebuttal. Like, we've done enough, and we're gonna wrap it up.
She had a good point. If there was a witness they were going to call that they didn't get to call because of the accidental arrest, you could call them now.
They could.
I think he's also very conscious of his senators, and he wants to be sure that he doesn't push them any further then they want to be pushed. He wants to be demanding, but also he does not want to upset the members of the Senate and keep them so late that they're exhausted.
Yeah, and I mean they've all been there since 9 o'clock this morning, or I mean they've probably presumably been there before that, but that's when they started. The session started this morning, and of course it's now almost 6 o'clock, and it's a long day sitting there listening, and the testimony today has not been exactly riveting.
No.
I mean, there's been moments where it was interesting, but it punctuated by.
This morning was more interesting. This afternoon, it's kind of dragged.
I think the most important thing we'd say is that it hasn't pushed the needle any way.
No.
It hasn't picked up any more votes for the defense, and it probably hasn't lost them any.
Well, isn't one of the impeachment articles about firing the whistleblowers?
Yes,
retaliation?
whether it was inappropriate and whether.
They seem to spend a lot of time on that today.
I thought there was some pretty good evidence today about that. I mean, I don't know how you come out the other way, but to me, it's all going to be political. It's going to be political decisions, and it's not a court of law.
Well, this whole situation is.
Yeah.
While it has the trappings of a criminal/civil trial, it is ultimately a political proceeding.
There are going to be 10 Republicans who go along with the idea of, well, they're whistleblowers, get rid of them. And so, that's the question. I mean, about half the Senate is lawyers. Some of them may see the flaws in the argument, but will they vote that way? Will they be able to respond to their district if they vote that way? They have to have 10 Republicans who go along.
And we haven't talked about it yet, but the head of the party, the Texas Republican Party, sent out a tweet today, right?
It sent out several tweets, but they sent out a fundraising tweet saying, stand up to the wrongful impeachment of Ken Paxton. Even sent out one tweet early in the day, if I saw this right, that explained that the judge could be replaced with a motion from the floor. And so the state Republican Party, which really has very little clout and is not able to raise much money and doesn't have much impact with donors, has had quite a bit to say about this trial on the side of Attorney General Ken Paxton.
What does that tell you, though?
Well, I mean, this is no surprise. I mean, the state party leader, Matt Rinaldi, and the state executive committee have been firmly arguing Paxton's case all along and defending Paxton. The Paxton is their guy, and Matt Rinaldi is from the camp that supported either Allen West or Don Huffines for governor, and that was the far right camp. These are the major funders of what's left of that faction of the party. You have the Ferris Wilks in Cisco. You have Tim Dunn in Midland. They pour millions of dollars into conservative religious causes in the party, and so that's where the only money that's left for some of the state officials comes from, and so that's kind of the flag they fly.
Well, and I've got on my other screen here, I've got the Senate feed up. That's what we're looking at right now. Is actually the K-View feed. But the Senate feed, you can still see the various, the prosecution and the defense up at the dais talking to Dan Patrick, presumably trying to hash out how this is going to go.
Well, now I think it's not all of them up there. I think it's Busby and
there's
Hardin.
Jay, can you put up the other view? Yeah, see, this is the other view. You can see them all up there. There's a whole
I'm sure
crowd
the senators are all like, hey, we getting to go home soon?
And I don't know, I couldn't hear Teresa, so I don't know if she addressed this, but we do have 4 articles of impeachment that were held in abeyance for this trial. And so
no one's mentioned them. And
so even if the Senate dismisses these articles, denies these articles, he's still impeached on those other 4 articles. Presumably there would be a motion to dismiss those other articles, but that would require another motion at the end of the trial.
Yeah, I don't know.
And those are the ones all related to criminal prosecution.
The securities case that is in court in Houston now.
but when we were talking earlier, Deandra, do you still feel the way you felt earlier that they could have quit earlier, that they should have kind of not presented as many of these witnesses? Or what's your feeling on what you saw in terms of these defense witnesses?
Starting out this morning, I kind of thought that this defense might call no witnesses and just rest this morning and
say our guy's innocent.
Our guy, y'all didn't prove it, and put on no one. The first guy they put on, I mean, he seemed like a nice enough guy. I don't know that he made a lot of headway, and I don't think the second guy helped them. I think when he got crossed, going through all the timeline of the filing with the FBI and all that kind of stuff, I just don't think that was really good for the defense. So I still think I would have just sat down and not put anybody on.
I really think, and I'm just speculating here, but I think these attorneys on loan from the Attorney General's office, who were state employees, said, let us put on our case, let us put on our case. And at some point, Tony Busby and his staff came back in and said, hey, let's go ahead and rest. Y'all are not doing that great.
Well, the other thing is, remember, you've got people that are on leave from the AG's office cross-examining their, oh, thank you, I got my Dr. Pepper, cross-examining their colleagues.
That's a weird situation.
It's very weird. I mean, they're cross-examining their colleagues. They're probably their friends, are these guys that they called, maybe even their supervisors.
Well, and you've got a memo with the whole letterhead thing. You've got a memo written by Chris Hilton that's part of the evidence in the case. I don't know. It's just the whole thing's kind of weird, because Chris Hilton was pretty involved in his job at the AG's office handling the whistleblower lawsuit.
What's also kind of funny to me on the letterhead thing is you've got all these AG people on leave working on the defense team. They don't probably know that the letterhead thing was bogus, and they were still going along with that argument. They had to know that.
And and the explanation is early in the trial, they were challenging the whistleblowers, saying, why doesn't this letterhead have Ken Paxton's name on it? Were you trying to go around behind his back? Or is this part of the mutiny? But now the defense shows the same thing.
Yeah, that they just have multiple letterheads in the office, which was what I forget who was with us that one of those days, and that was exactly what they were saying. One of the attorneys I had with me was just saying, well, offices frequently have multiple letterheads. That's not all that unusual in a big office. If Ken Paxton sends the letter, of course he's going to have a letterhead with his name on it. If it's an underling sending it, they may not have his name on it, because that's not that unusual in a large organization
to have
multiple
letterheads. Yeah, multiple versions of your letterhead pre-printed. You buy them in bulk. They're probably sitting in some kind of drawer or filing system, and everyone has access to it. And
I mean, they probably even have like a policy on when you use what letterhead. It wouldn't shock me if there's not a policy.
Well, obviously, we saw today they use the other letterhead without his name on it.
That was a pretty good moment when Dutco said, this guy right here, oh, he's sitting over there. Oh, Ken Paxton's name's not on that letterhead,
And I really liked was it Dutco?
Dutco.
I really liked him. He was very good. I thought he was very effective.
The people in the chat were calling him Jimmy Stewart.
He was very Jimmy Stewart-like.
He was. Then they were calling him Jimmy Stewart.
Mr. Smith Goes to Washington. Yeah, I can totally see that.
Even the suit kind of had that it did. It was like they were calling him Jimmy Stewart.
Well, he was so tall. He was really far away from the microphone, so it was a little bit harder to hear him. He would need to lean over, I guess, to really get in that microphone. He wasn't very loud.
No, but he was really effective.
He was very good. Really impressed. He had a good style about him. So yeah, I liked him. Eric and Stacy didn't get enough time today.
No, but we talked about
Eric
Jay
and
quite
Stacy.
a bit.
Yeah,
we got Jay. So for you folks that may be jumping in and out of the stream, where things stand right now is the Tony Busby, the lead defense attorney, rested at 5:34 p.m. The attorneys for both sides have been up there at the dais talking to Dan Patrick, presumably discussing scheduling. We know based on the rules that each side has 1 hour for rebuttal evidence. Now, they may decide not to use it.
Yep.
So that's what we don't know, and it could be that they decide they are going to use it, and we're going to do it tonight. And then they have, beyond that, there's 1 hour for each side for closing arguments, and then deliberations, and then voting. Now, that's the gist of where we stand. But we don't know exactly what they're deciding. I mean, again, it's got to be a scheduling issue. What are we going to do? Are we going to do rebuttal? Or are we going to do it tonight?
Well,
or are we going to not do it at all?
also, do they have, if they were going to call a witness, and I mean the state, the House, do they have them there?
Well, that's the other issue.
I mean,
I remember we have that other issue of the. I mean, does the 24-hour rule apply to rebuttal evidence?
Normally, it would not in rebuttal, but it could. There could be rules in this. Like I said, this is some sort of cobbled together proceeding with all kinds of rules.
I'm looking at the rules, and I don't know exactly where the 24-hour thing that particular rule comes in.
What's the description of deliberation, or does the jury even go back into the
deliberations are done in the Senate chambers, and it's closed off from
the media?
Yeah,
so no
from everybody.
cameras?
Nobody can be in there. Nobody can be in the Senate chamber.
Okay.
And deliberations is supposed to mean they all can talk to each other about it.
Right.
Right.
Right. And so
and play videos if they want.
They entered those into evidence. They could play those videos if they wanted to. If they decided that was something, there's a couple of video interviews of Nate Paul. One of them's a little over an hour, and one of them's like an hour and 45 minutes. So I think it's close to, between the two interviews, it's close to 3 hours of video, and then there's a couple of audio recordings of Kamek going to talk to the banks. I don't know if those got introduced into evidence or not. Okay, here we go. Rule 8, closed court deliberation. This is according to the Senate rules. The sessions of the court of impeachment are to be open. Deliberations of the court are to be closed. The court may meet in closed session, but no formal action may be taken in a closed session. Deliberations may not occur until conclusion of all final arguments. Only members of the court are permitted in deliberations. Any vote shall be in open court without debate or comment. After final judgment, a member of the court may provide a written statement on their vote within 72 hours to the clerk of the court, which will become part of the official record and entered into the journal. So I guess once the vote's taken, they could also enter some kind of written statement if they so choose.
Oh, that's interesting.
Yeah, it is interesting.
I'm voting this way, but I'm giving a disclaimer.
Exactly.
Can you imagine?
Or maybe I voted this way, and this is why I voted that way.
Oh, yeah, I'm voting this way, and this is why. This is.
Yeah.
Oh,
so I don't know.
Interesting.
It's all very interesting.
And a viewer asked about why I'm saying count to 10 if Angela Paxton's abstaining, isn't that, doesn't that mean there are only 30 votes and 2/3 would be 20?
No, she
but
counts
she
in the number.
still counts in the number. So there are 31 senators. She counts in the number. It takes 2/3. It takes 21 to sustain an article of impeachment. And so if there are 10 votes to dismiss an article of impeachment, then it fails.
Yeah, we'll see.
She's going to be there for deliberations but not vote. Is that your understanding?
She has been barred from, I think she's barred from deliberation.
Okay.
The Constitution says she has to be in the chamber during the trial, but I think she's barred from deliberation.
Because she's not a juror.
Right.
Because she can't vote.
Right.
So she shouldn't be there during deliberations.
They're just following the Constitution, which says that all members of the Senate must be present during the trial.
I mean, because you do have this extraordinary situation where the Attorney General's wife, Senator Angela Paxton, of course, is a member of the Senate, and thus, as a result, that's why she's in the Senate and counted as part of that 31, even though she cannot vote on the impeachment. Yeah, I'm reading the rules, trying to. I mean, presumably, she would not be in the deliberations since she is not a juror. But
I'm
trying
surprised Dan Patrick hasn't given an update. You know, he's been giving updates to the senators.
On the time and
Pretty, yeah. Hang on, we're about to tell y'all something. He hasn't done that.
Yeah.
No, I mean,
he's an old TV sportscaster. He's used to saying,
"Oh, is that right?
We'll be right back." Yeah.
Is that true?
Yes.
Oh.
Wasn't he a sports?
Interesting.
He was the TV sports anchor in Houston. He was famous for shaving his chest and painting it Oilers blue during the Oilers' heyday, and all sorts of
I like his style.
Sportscaster stunts.
He has a good voice. I can hear that. I can see that.
Well, and of course, I grew up in the Houston area, so I remember the Oilers when they were there. You know, so whole different era than today. They ran off to Nashville.
We talk about all the people we haven't seen during this trial. We never saw Laura Olson.
Well, we saw her.
We saw her, but
we
we're
saw
not
her quite a bit. But we saw her coming and leaving, is all we saw. We didn't see all these people that Tony Busby brought up in his opening statement as all the boogeymen involved in the trial. We never saw, Dick Weekley, Karl Rove, George P. Bush, all the people that he said were, Nate Paul. We never saw Nate Paul.
Well, I mean, Nate Paul could claim the fifth because he's under federal indictment right now.
Well, what about the contractor?
They said earlier that the contractor, this might have been yesterday, they said that was yesterday, they said the contractor had refused to testify.
Well, he doesn't have a choice if he gets a subpoena.
And
See, you don't get to just say, you know what, I just think I'll tap out.
And of course, we only saw Ken Paxton one time. We saw him at the beginning of the trial, and we have not seen him since. So.
Well, he's off to talk to Tucker, isn't he?
He's and the reference there is that he tweeted that he's going to Maine next week to do a show with Tucker Carlson, which apparently means that he won't be at work next week. So we'll see whether he's back on the state payroll next week.
Well, based on what you're saying, you feel like he's going to be back on the state payroll.
I feel like he'll be back on the state payroll, but it'll be up to a vote of the Senate on whether to continue with those other 4 articles of impeachment or dismiss them, or continue to hold them in abeyance pending the outcome of the court case in Houston. So, if they hold them in abeyance, then he would continue to be suspended. If they dismiss them by a majority vote, then he would be eligible to return as Attorney General.
Do they have a dress code in the Senate?
They do, and it's been pretty loose in this trial.
Just curious. I mean, everybody looks pretty dressed up to me. I was just wondering if there's a dress code.
I've seen some people, well, yes, you have to wear gentlemen have to wear coat and tie, but I mean, I've seen some odd-looking sweaters and attire around the lieutenant governor's dais.
Well,
really?
You can see some pretty animated discussion up there at the dais.
I think the jury may be deliberating. They may be deliberating where they're going to dinner.
Well, don't we have a couple of restaurants we could send them off to?
Well, Polvo's.
Yes, Polvo's. I'm going next time I'm in Austin.
And of course, Starbucks.
I'm going to go to Starbucks. I'm going on the tour.
Be sure you have a ride back if you go to Starbucks.
I'm going to take an Uber.
Clearly.
Were there ever any Uber records?
No.
They never.
Uber is something else we never saw in this trial.
You're right.
There were supposed to be some Uber records.
Uber, fake names, fake accounts on Uber, which, as was pointed out by Ken Paxton's team, there's nothing illegal about having a fake Uber account, but that never came up in the course of this trial.
Well, a lot of celebrities have those kinds of things. Like they'll check into a hotel, they use fake names, they have fake names on Uber accounts. So to stay out of the public eye, that's really not unusual.
Well, and it may have been that had we heard from Laura Olson, that we would have heard about the Uber records.
maybe they were gonna get that in.
But they didn't come in this, and well, at least not in this part. I mean, could it somehow come in rebuttal? But I don't see why it would come in at this point. I mean,
I don't think so.
I don't see any particular reason for that.
I don't see where it furthers any of the 16 articles.
Because at this point, the 16 articles really are hinging on who do you believe? Do you believe the whistleblowers or do you believe Ken Paxton's side, right? Or does it matter who you believe?
I think you probably have senators that are more interested in what their constituents believe. because that's, that's who
And
they
the
answer
senators from the beginning have been more interested in what Dan Patrick believes, because they need Dan Patrick to pass bills. They're taking very widely divergent positions. Some of them are not voting with people they normally vote with. They seem to be voting from deeply held conscience. Those who are backed by the West Texas financiers seem to be holding together pretty well. But in the end, they all have to please Lieutenant Governor Paxton and Patrick, and they will. And if he has a preference, they'll try to follow that. I think that Dan Patrick has gone through this trial without showing too much partiality, and
I do too. I think he's done a good job.
No, he has. I think he's done a very good job. I think
he has a good demeanor.
I think that
I've been very impressed.
He's very
with
pleasant.
Dan
I wish
Patrick.
all the judges I appeared in front of had as pleasant a demeanor in
It
court.
looks like we're gonna
Some of them are not so nice.
it says we're bringing everybody
Isn't
back.
that Birdwell right there up there at the front?
Yes, that's Senator Birdwell
And
from Granbury.
Brian Birdwell was the.
Parties, I need someone from
9/11
each side to
survivor who
announce that
chaired the
you're
committee that wrote the rules.
going to have closing arguments in the morning.
That's
before
it.
I
Closing
adjourn
arguments
for the
in
day.
morning.
Parties, I need someone from each side to announce that you're going to have closing arguments in the morning before I adjourn for the day.
Mr. President.
Do you close tomorrow?
Yes, Mr. President, the House will have closing argument.
On the record?
Yes, Your Honor. The Attorney General will close tomorrow. Closing argument.
Okay, for the record. (9 a.m. as always. 9 a.m. We are adjourned for today. Members, before you scatter, talk to your two leaders here.
So bring the mics up. Okay, so the proceedings have wrapped for the day. They have obviously decided we will not hear rebuttal evidence. Each side had an hour for rebuttal, and they've decided to not do that. And so we'll see what they say in the morning, 9 a.m. Real quick before we wrap up, because we're going to make it quick. Deandra, give us your, for both sides, prosecution, closing, the 2-minute version on each one, prosecution, defense.
I think I mentioned it earlier, prosecution, but I'm confused as to who's actually going to be arguing, but like what person is doing it for both sides. But I would say you've got to go in and hit, for the prosecution side, hit each one of those articles of impeachment and how you proved it. And I think you should have graphics. Make it very simple. Walk them down the path. We proved this one, this one, this one, this one, this one. Defense is going to get up and just basically probably toss out this one. They never even mentioned this, and and kind of get down maybe to the main key ones, and then just hammer probably credibility of witnesses.
You know, House ethics presentation to the House when the House passed the articles of impeachment was so emotional and just so gut-wrenching, and just made you feel like, oh my gosh, the wrongs, this is terrible and horrible that the business of Texas was conducted this way. They brought none of that emotion to the trial today. So they have to bring back some of that emotion and and convince senators of why all the various things that they heard about in tiny little fragments and pieces here were wrong for the people of Texas. You know, the defense has to repeat the same case they've had, is that, you know, there's no bag of money, nothing changed hands. You know, there
no
was,
cabinets?
There were no cabinets. There nothing happened. He didn't get anything. He didn't do anything. He didn't give any favors. You know, they may have conducted the business of the AG in a certain way, but that was within the authority of the AG. and that's enough, that he's constitutionally elected and he gets to do what he wants to do as Attorney General. And so I think the defense will say that and more, and they'll say that these turncoat employees tried to put together this thin case that the House brought, and that it was totally worthless and a waste of time for the senator.
Okay. All right, guys. We'll be back tomorrow at 9 a.m. Bud will be joining us in the morning, and in the afternoon I think we'll have Bernadine, and then we'll have Stephanie Alvarado, who's a local defense attorney, who will join us as our legal expert as we're seeing how things turn out. See you tomorrow.